Preface of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Avai in January 2022. Stratagems and Conspiracies to Defraud Life Insurance Companies. An authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Preface. The first edition of this book appeared in 1878. It was limited to 1,500 copies and was exhausted soon after publication. Subsequent applications for copies were attended with disappointment, and followed with frequently repeated requests for a new edition embracing the more important additional cases which have occurred during the intervening period. The present revised and enlarged volume is published in response to this demand, and is commended as a trustworthy record to those for whose use and reference it is primarily intended: life insurance companies and agents, medical examiners, insurance lawyers, and medico-legal experts. Objection has been made that if such a record of ingenious devices for defrauding the life companies transcends its immediate design and purpose, it may prove dangerously suggestive. But it should be remembered that a double-edged sword cuts both ways, and if these narratives fall within the range of the evil eye, the vision is not confined to the exposure of the cunning contrivances and artifices of this class of schemers and plotters. It includes picturesque views of detection and punishment, of the determined efforts of the companies, at whatever cost, to run them down, of the machinery of courts of justice, of the gloom of the prison cell, of the dark outlines of the scaffold. The cases in this book are for the most part more suggestive or instructive to detective agencies than to conspirators. To the managers of our life companies, these records furnish an impressive object lesson. Collectively, they emphasize, as never before, the increasing importance of scrutinizing the moral hazard as closely as the physical risk, and the need of more watchful attention to the question of insurable interest and its bearing upon assignments. The anxiety of the companies to increase the lines upon their books, and of the agents to increase their remuneration, has heretofore been largely responsible for placing aggressive weapons in the hands of intending assailants. It is encouraging to note steady improvement in this direction, to observe that the companies are substituting quality for quantity and circumspection for overconfidence. They realize that in their coming encounters with this form of human ingenuity, halfway measures of repression and compromise settlements must give way to remorseless pursuit. In the cases in which important questions of law are involved, the reasons of the courts are given at more or less length for convenient reference. In addition to the law points, the reader will find in some of the charges of judges to juries concise and careful and comprehensive reviewal of the facts, and these are valuable because of the fairness and the intelligence to which they bear witness. There are but few cases in this volume in which the fairness of the bench is questionable. It is quite otherwise with the 12 in the box. The perverse prejudice of the average juryman against corporations too often results in scandalous injustice, as many of the verdicts herein reported prove. If their findings were to end with subversion of justice, with expression of contempt of the obligations of the companies to honest policyholders, and with manifest disregard of the sacredness of trust funds, it would be deplorable enough. But as these records show, such jurymen serve as scene shifters for fresh conspiracies, and tempt the malefactors they have liberated to the commission of new crimes. These narratives also show that no community has a monopoly of the piratical adventurers who thus prey upon beneficent institutions. They are of all nationalities as well as of both sexes, and everywhere alike, to no code or creed confined. A remarkable instance of their machinations may for a season concentrate attention upon a given locality, but the next startling outbreak may be thousands of miles away. The offenders vary in character from the smooth and polished and educated scoundrel to the coarse and vulgar and illiterate outlaw. Some of the actors in the drama rise to the higher realms of comedy or tragedy, while others are never lifted above the low level of the brutal villain of the play. If this book shall in any measure be helpful in diminishing the number of sensational scenes on this stage of action, it will more than serve its purpose. End of preface.
Section 1 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies, an authentic record of remarkable cases by John B. Lewis and Charles C. Baumbaugh. Pretended Death, Part 1. Counterfeited Death, Forged Certification, False Personation, and Fictitious Substitution. Stratagems and conspiracies to defraud life insurance companies may be grouped under certain general heads: counterfeited death, pretense of death under the forms of forged certification, false personation, and fictitious substitution, speculative and graveyard insurance, mysterious disappearances with their inferences and presumptions, poisoning and other forms of homicide, deliberately planned suicide, problematical and disputable appearances, perplexing identification, and self-mutilation in accident insurance. This classification comprehends only those actively aggressive forms of fraud which contemplate speedy realization of the atrocious end in view, and which therefore are broadly counter-distinguished from less tangible sorts of imposture, such, for instance, as material concealment or misrepresentation in the answers recorded in the application. It is in the nature of these latter deceptions that for possible results they can only look remotely to the chances of the future and the natural course of events, while their flagrancy is generally mitigated by individual unselfishness. But though in the armamentaria of fraud there are no weapons which more urgently call for the watchful scrutiny of life insurance executive officers, the scope of this volume limits us to the consideration of the assaults of deeper desperation and more remorseless cupidity. Counterfeiting death by means of the hypnotic or cataleptic state, whether induced by mesmeric agency or by recourse to anesthetics or somnificants, which suspend sensation and motion, is so extremely rare that it need not be seriously considered as a factor in the machinations of the assailants of insurance companies. Curiously enough, the most striking illustration of the trance condition, and indeed, so far as we are aware, the only case of successfully simulated death, is the first recorded fraud in the history of life insurance. According to Mr. John Francis, who tells the story in his very entertaining Annals, Anecdotes, and Legends of Life Assurance, it occurred in the year 1730. Mr. Francis says, 2 persons resided in the then obscure suburbs of St. Giles's, one of whom was a woman of 20, the other a man whose age would have allowed him to be the woman's father, and who was generally understood to bear that relation. Their position hovered on the debatable ground between poverty and competence, or might even be characterized by the modern term of shabby genteel. They interfered with no one, and they encouraged no one to interfere with them. No specific personal description is recorded of them beyond the fact that the man was tall and middle-aged, bearing a semi-military aspect, and that the woman, though young and attractive in person, was apparently haughty and frigid in her manner. On a sudden, at night-time, the latter was taken very ill. The man sought the wife of his nearest neighbor for assistance, informing her that his daughter had been seized with sudden and great pain at the heart. They returned together and found her in the utmost apparent agony, shrinking from the approach of all and dreading the slightest touch. The leech was sent for, but before he could arrive, she seemed insensible, and he only entered the room in time to see her die. The father appeared in deep distress. The doctor felt her pulse, placed his hand on her heart, shook his head as he intimated all was over, and went his way. The searchers came, for those birds of ill omen were then the ordinary haunters of the deathbed, and the coffin with its contents was committed to the ground. Almost immediately after this, the bereaved father claimed from the underwriters some money which was insured on his daughter's life, left the locality, and the story was forgotten. Not very long after, the neighborhood of Queen Square, then a fashionable place, shook its head at the somewhat equivocal connection which existed between one of the inmates of a house in that locality and a lady who resided with him. The gentleman wore mustaches, and though not young, affected what was then known as the macaroni style. The lady accompanied him everywhere. The captain, for such was the almost indefinite title he assumed, was a visitor at Ranelagh, was an habitué of the coffee houses, and being an apparently wealthy person, riding good horses and keeping an attractive mistress, he attained a certain position among the mauvais sujets of the day. Like many others of that period, he was, or seemed to be, a dabbler in the funds, was frequently seen at Lloyd's and in the Alley, lounged occasionally at Garraway's, but appeared more particularly to affect the company of those who dealt in life assurances. His house soon became a resort for the young and thoughtless, being one of those pleasant places where the past and the future were alike lost in the present, where cards were introduced with the wine, and where, if the young bloods of the day lost their money, they were repaid by a glance of more than ordinary warmth from the goddess of the place, and to which, if they won, they returned with renewed zest. One thing was noticed: they never won from the master of the house, and there is no doubt a large portion of the current expenses was met by the money gambled away, but whether it were fairly or unfairly gained is scarcely a doubtful question. A stop was soon put to these amusements. The place was too remote from the former locality. The appearance of both characters was too much changed to be identified, or in these two might have been traced the strangers of that obscure suburb where, as daughter, the woman was supposed to die, and his father, the man, had wept and raved over her remains. And a similar scene was once more to be acted. The lady was taken as suddenly ill as before. The same spasms at the heart seemed to convulse her frame, and again the man hung over her in apparent agony. Physicians were sent for in haste. One only arrived in time to see her once more imitate the appearance of death, while the others, satisfied that life had fled, took their fees, shook solemnly their powdered wigs, and departed. This mystery, for it is evident that there was some collusion or conspiracy, is partially solved when it is said that many thousands were claimed and received by the gallant captain from various underwriters, merchants, and companies with whom he had assured the life of the lady. But the hero of this tradition was a consummate actor, and though his career is unknown for a long period after this, yet it is highly probable that he carried out his nefarious projects in schemes which are difficult to trace. There is little doubt, however, that the soi-disant captain of Queen Square was one and the same person who, as a merchant, a few years later appeared on the commercial walks of Liverpool, where, deep in the mysteries of corn and cotton, a constant attender at church, a subscriber to local charities, and a giver of good dinners, he soon became much respected by those who dealt with him in business or visited him in social life. The hospitalities of his house were gracefully dispensed by a lady who passed as his niece, and for a time nothing seemed to disturb the tenor of his way. At length it became whispered in the world of commerce that his speculations were not so successful as usual, and a long series of misfortunes, as asserted by him, gave a sanction to the whisper. It soon became advisable for him to borrow money, and this he could only do on the security of property belonging to his niece. To do so, it was necessary to insure their lives for about £2,000. This was easy enough, as Liverpool, no less than London, was ready to assure anything which promised profit, and as the affair was regular, no one hesitated. A certain amount of secrecy was requisite for the sake of his credit, and availing himself of this, he assured on the life of his niece £2,000 with, at any rate, 10 different merchants and underwriters in London and elsewhere. The game was once more in his own hands, and the same play was once more acted. The lady was taken ill, the doctor was called in and found her suffering from convulsions. He administered a specific and retired. In the night he was again hastily summoned, but arrived too late. The patient was declared to be beyond his skill, and the next morning it became known to all Liverpool that she had died suddenly. A decorous grief was evinced by the chief mourner. There was no haste made in forwarding the funeral. The lady lay almost in state, so numerous were the friends who called to see the last of her they had visited. The searchers did their hideous office gently, for they were profitably bribed. The physician certified that she had died of a complaint he could scarcely name, and the grave received the coffin. The merchant retained his position in Liverpool and bore himself with decent dignity, made no immediate application for the money, scarcely even alluded to the assurances which were due, and when they were named, exhibited an appearance of almost apathetic indifference. He had, however, selected his victims with skill. They were safe men, and from them he duly received the money which was assured on the life of his niece. From this period he seemed to decline in health, expressed a loathing for the place where he had once been so happy. Change of air was prescribed, and he left the men whom he had deceived, chuckling at the success of his infamous scheme. It need not be repeated that the poverty-stricken gentleman of the suburbs, the gambling captain of Queen Square, and the merchant of Liverpool were identical. That so successful a series of frauds was practiced appears wonderful at the present day, but that the woman either possessed that power of simulating death, of which we read occasional cases in the remarkable records of various times, or that the physicians were deceived or bribed, is certain. There is no other way of accounting for the success of a scheme which dipped so largely into the pockets of the underwriters. A Chicago sham. In pursuance of a swindle concocted in Chicago by Richard Rainforth, Dr. C.B. Kendall, and T.W. Fuller, it was prearranged that the principal actor should feign death following typhoid fever, and that previous to burial another body should be smuggled into the coffin. The particulars of this case are as follows. In the month of February 1867, a will purporting to have been made and signed by Richard Rainforth, deceased, was filed in the Cook County Court, Chicago, for probate. The will was duly executed and witnessed, and contained 3 separate bequests, one for $1,000 to Dr. Charles B. Kendall, Fullerton Block, one of $1,000 to Timothy W. Fuller, 133 South Clark Street, and the rest of Rainforth's property to Bertie, the daughter of T. W. Fuller. The will provided for its own execution and named Kendall and Fuller, the legatees, as executors. The will was on file till March 21st, no measures having been taken to prove it until that date, when a rule of court was obtained to compel the executors to do so. When the demise of Rainforth was made public, Miles Rainforth, his brother, went to Chicago to see how matters stood in his favor in the will. After having obtained an interview with M. F. Heenan, the lawyer who had been employed to draw up the will, he was led to believe the will was a forgery, or that deceased had been dealt with foully. Impressed with this doubt, he arranged with a legal firm to investigate the subject. Efforts were then made to have the will proved, but failed until a rule of court was had compelling the executors to show cause why they did not prove the will. On the 21st of March, Fuller and Kendall appeared in court to answer the summons issued, and in the absence of Mr. Heenan, renounced the executorship. Miles Rainforth then filed a petition asking for an examination into the merits of the will. The petition was granted, and the executors placed in the witness box to answer relative to their stewardship of the property of the deceased and the manner of his death. Dr. Kendall was first examined and refused to answer when he was committed for contempt. Fuller was then placed on the stand, and to the question, "Is Richard Rainforth dead?" replied, "No, he is not dead. He still lives." He then testified that Rainforth, Kendall, and himself had matured a plan to defraud the Aetna, St. Louis Mutual, and Mutual Benefit Life Insurance Companies, in which he had effected policies for $15,000. The plan consisted in Rainforth assuming death, while Kendall was deputed to procure a body for the interment, and after the skilled substitution of the body, Rainforth was to seek some place of concealment. In pursuance of this arrangement, a few days before Rainforth's alleged death, he pretended to feel unwell, and Dr. Kendall was called in and pronounced the patient suffering from typhoid fever. 2 days afterwards, by direction of the patient, his will was drawn up, and another physician called on to visit the sick man. He decided that he only had about 36 hours to live. The same day, a barber was procured who shaved off Rainforth's mustache and whiskers. An hour afterwards, his will was signed in the presence of Heenan and 2 other witnesses. While Fuller and Kendall were in the room, the latter said, "Poor Dick is dead." On the following day, the pretended corpse was apparently and presumably coffined and buried in Graceland Cemetery, Chicago. Fuller, moreover, stated that he was not aware of the fraud practiced upon him by this pretense of death until some time after its occurrence. He afterward learned that the letters had been received at Chicago from Rainforth and Fuller's daughter Bertie, dated as late as March 18th. Fuller was then held for a further hearing in $12,000 bail, and Dr. Kendall was arraigned for fraud and held in jail to answer. Search was made for Rainforth after the plot had been discovered, but no clue to his whereabouts was obtained until sometime in April, when it was ascertained that he was in New York. On the receipt of a telegram to that effect by Superintendent Kennedy from the Detective Agency of William Tuttle and Company, Chicago, Detectives Vaughn and Niven were detailed to find Rainforth. They worked assiduously, and after a deal of difficulty, they learned that he was at the DuPont House, corner of Hudson and Lake Streets. They proceeded to the place at 2 o'clock at night, and there he was discovered in bed. He was taken to police headquarters and delivered to the custody of Detective Kennedy of Chicago, who had been sent to New York to convey the accused to that city. Rainforth had been a quartermaster in the Army, Dr. Kendall an Army surgeon, and Mr. Fuller a detective in the service of the government during the war. Fuller after his exposure of the Rainforth conspiracy furnished the Chicago Tribune with an autobiographical sketch of his life and adventures, in the course of which he made a revelation which, however startling or sensational, savored so much more of the fanciful than of the probable, that it did not produce a very profound impression. He said, "The origin of this insurance business is not here. There are parties connected with it who stand high in society and who have great influence. It would not benefit me to say who these parties are, nor would it now benefit the insurance companies, and the public will not be injured by having the names kept a secret for the present. It is enough to say it is an organized company with its headquarters in New York. It has its ramifications throughout the principal states, and the persons engaged are in such positions that if attempted the frauds will be seldom discovered, because the doctor and the man who is reported to die have no knowledge outside of the patient or case in which they are engaged." Whatever the object of this singular statement, it was deemed prudent, in view of possibilities, to give it some consideration, for if, upon investigation, there should be found a shadow of truth in so remarkable a declaration, the life companies were bound to assume a defensive attitude. But whether true or not, the experience of the English companies and the numerous cases of convicted crime in this country sufficiently prove to our life corporations that they have an ugly foe to encounter, and that it is necessary to be unceasingly vigilant. End of section 1. Section 2 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies, an authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Pretended Death, Part 2, Forged Certification. With regard to forged proofs of death without auxiliaries in reserve, it will be found that though at first glance such fabrication would seem to open an inviting field for knavery, it is comparatively rare because comparatively easy of detection. Take, by way of illustration, a recent case of false certification in France. A young teacher named Charles Auguste Desbois in Nevers was the beneficiary of policies on the life of his mother, a widow living in Tournai in the company named Le Monde, to the amount of 50,000 francs. Toward the end of January, Monsieur Desbois notified the agent of Le Monde in Nevers that his mother was dead. The agent forthwith communicated the information to the company, and shortly afterward the officers received a letter from the family announcing the fact. Also, the mayor's official certificate of the death of the widow Desbois and the usual certificates of the physician and the undertaker. As these certificates were upon ordinary paper, the company thought they had a suspicious look, and called upon Monsieur Desbois to furnish certificates upon stamped paper. This he did a few days afterward. A comparison between the new certificates and those previously furnished strengthened the suspicions of the company. Notwithstanding a favorable report from the agent in Nevers, they sent one of their inspectors to Charente in western France to institute an investigation, the result of which was the discovery that the widow Desbois was in good health and blissfully ignorant of her son's fraudulent maneuvers. The next time the young man called at the Home Office in Paris, he was arrested. Crimination of the examiner. The occasional collusion of medical examiners with men of loose morals and lack of principle who engage in schemes to rob insurance companies leaves a dark shadow upon one of the noblest of all professions, a vocation and a mission as noteworthy for the honor and integrity of its membership as it is for humane and charitable and philanthropic work. When a physician accepts a bribe to give a false certificate of acceptability for insurance, the question arises whether his act is an outgrowth of depravity or of poverty, whether it springs from moral obliquity or the res angusta domi. To show how hard it is from a distant viewpoint to reach a correct conclusion, take a recent case. In September 1895, Doctors Bingham and Ferguson and Crown Attorney Farwell of Whitby, Ontario, under instructions from the Attorney General's Department, exhumed the body of Mary Ellen Alger, wife of Elisha Alger, a farmer near Pickering who died in August. This procedure was in consequence of information which led to suspicion that a conspiracy had been formed to defraud the Equitable Life and the Home Life Insurance Company of New York. The former had issued a policy on the woman's life in December 1894 for $7,000, and the latter in July 1895, within a month of her death, for $5,000, on the recommendation of Dr. Francie of Whitevale, Ontario. Mrs. Alger had been married 15 years, and the post-mortem examination showed that she died of pulmonary consumption. On the 17th of November, Alger was committed for trial on the charge of attempting to defraud the Equitable Life. The Free Press of London, Ontario, published the following account of the testimony of Dr. Francie, the criminated medical examiner. The examination of Dr. Francie was one of the most extraordinary in the history of criminology. He told without any reserve whatever how he had gradually been led into this business. Henry Troll, Oshawa, local agent for the Equitable Life, came to see him in September 1894 and wanted him to take him around canvassing for risks, offering 25% commission on his first premium. We went to Alger's. He was digging post holes around his barnyard. Troll talked life insurance. Alger was disposed to discuss the question, but at another time when he should have leisure. He came to me afterwards and spoke of the subject, wanting to place insurance on his wife. At first I said it would hardly do. I asked him why he had not got insurance on both himself and wife in the mutual reserve. Alger said it was too late now to talk about that. He did not know that his wife was likely to die. In April 1894, I had made a careful examination of her. I was attending his daughter Nellie at the time. I made a naked chest examination of Mrs. Alger. I told him his wife had consumption and was almost certain to die before many years. He had talked to some people about the Mutual Reserve, he said, but they had not spoken well of that company. I said to him if he should insure her, it would likely be a profitable policy, as she was unlikely to live long. Alger said I was to get $1,000 of the insurance if I'd pass her, and I could make what I could out of the premiums. It was finally decided to insure her for $5,000 in the Equitable Life. It was explained by me that the insurance would be certain if she lived out the year, as the policies of that company are incontestable. In making the examination, the questions as to family history were skipped by Francie, and she was led to believe the application was but for $1,000. Francie examined her for the home life, but she knew nothing about it. Francie going to Toronto and copying the Equitable policy application. Mrs. Alger's name was forged to this one. The name of the forger has not been given. James Hortop was named by Francie as being offered $150 with himself if the insurance money on the last policy was obtained. Francie insists that he came back from Buffalo of his own accord and has since been promised his liberty if he gave evidence in this trial. He swears he wished to get Alger to settle. Other parties implicated were afterward indicted, but the disquieting and deplorable feature of the case was the faithlessness of a trusted medical examiner and his willingness, whether from need or from greed, to involve the companies which employed him in the large expenditure of time, trouble, and money which necessarily attends such contests for justice and right. The Sure Frauds. In the spring of 1888, Henri Castelnau, a doctor of shady reputation, Alexander Martinet, a chemist, and Marie Proteau, Castelnau's servant, were placed on trial at Versailles on a charge of concocting a false certificate of death. Another woman, Juliana Metz, was included in the indictment as a particeps criminis, but her case was separately disposed of at Vienna. The facts, as detailed by a leading English insurance journal, The Review, are substantially as follows. A German adventurer named Schurer married an American wife at Brooklyn, but not finding her rich as he had expected, deserted her. He came to Paris in 1883 with his mistress Juliana Metz, and being reduced to great shifts, conceived the idea of insuring his life in English offices and of pretending to be dead so that Juliana might receive the insurance. He had formerly been an agent for insurance companies and was well acquainted with their working. He accordingly effected insurances for £8,500, and some months afterwards, the certificate of death at Meudon being sent in, the companies, after some demur, paid the policies. Marie Proteau, however, after a time, gossiped to the servant who had succeeded her at Castelnau's. The latter repeated the story, and an anonymous letter reached the companies. It was then discovered that Scheurer was still living, that the man who had died was really named Karl Glockner, that Castelnau, a doctor and anarchist orator at Paris, was a party to the fraud, and that the chemist Martinet had received 23,000 francs for having secured the consumptive patient Glockner, a journeyman brewer who was to be passed off at death as Scheurer. The last named, meanwhile, had naturalized himself in Canada, had taken the name of Clarence Percy Robert, had bigamously married Juliana at Brighton, and had gone with her to Austria. On hearing that the fraud had been detected, Scheurer went to Italy, but learning that Juliana had been arrested with £8,000 in her possession, he committed suicide at Como. He left a paper avowing his guilt and exonerating Juliana. Castelnau, on being interrogated, acknowledged that he had made Scheurer's acquaintance in 1878, that he himself was then in pecuniary straits, and that he agreed to assist in Scheurer's plan. He was promised 100,000 francs, but received only 23,300 francs. He went and asked Martinet to find him a sick man. Glockner was not only a German, but had some resemblance to Scheurer. Glockner was taken to a house at Meudon, and Castelnau maintained that he was well cared for. No doctor, however, saw him till a few days before his death, when the medical man called in found him in the last stage of consumption. Castelnau received the money through Martinet, and he gave 10,000 francs of it to his daughter. He admitted having, at Scheurer's dictation, drawn up the certificate of death. Martinet, while obliged to admit that he had provided the invalid Glockner for Castelnau, insisted that he had known nothing of the fraud, but believed that Castelnau wished to test a new cure for consumption. Marie Proutot also maintained that she did not at the time know of the fraud, and did not know who the patient at Meudon was, though Scheurer afterwards induced her to make a declaration that the patient was Baron Scheurer. On the conclusion of the trial, Marie Proutot, the servant who, after signing documents certifying Scheurer's death, ultimately made disclosures which led to the detection of the fraud, was acquitted. The jury found the two other prisoners guilty, but with extenuating circumstances. Castelnau was sentenced to 8 years, and the chemist Martinet to 5 years' imprisonment. The trial of Juliana Metz, the accomplice of Scheurer, who swindled 7 British insurance companies, took place in Vienna. The accused, Scheurer's mistress, was born in Galicia, and at the time was 30 years of age. She was accused of having, in concert with several accomplices, between December 1883 and June 1884, obtained large sums under false pretenses in London and Paris from various life associations. Among the companies defrauded are the Provident Clerks Mutual Life Association, the Imperial Life Assurance Company, the Sun Life Assurance, the Union, and the Scottish Widows' Fund. It was pretended that Scheurer died at Meudon in November 1883, whereupon Juliana Metz, to whom all Scheurer's insurance documents had been given, obtained £13,800. The accused, until 19, could neither read nor write, and at the age of 22 was in domestic service as a nursemaid. Yet when she lived in Austria, she assumed the airs of a lady of social distinction, keeping a carriage and a train of servants, and was treated with great respect. Her marriage with Scheurer, which was contracted in England, was bigamous because the American wife, whom he deserted after squandering her money, was still living. In the indictment, it was asserted that the man who died of consumption under Scheurer's name was aware of the fraud. Juliana lived in England, and fearing to betray the secret by letter, often crossed the Channel to consult with Scheurer when difficulties arose from the insurance companies suspecting foul play. She was an accomplished actress, and passed herself off as Scheurer's afflicted widow everywhere, even in his family in Hamburg. And in consequence of her part being played so well, she obtained the money. Her appearance gave no clue to her talents. She was small and apparently timid, and seemed like a lady's maid. When Scheurer heard of the arrest of Castelnau and Martinet in Paris, he withdrew his money from the banks where it was deposited, and gave some to Juliana and some to friends to keep for her. Then they both left Vienna in different directions. Before shooting himself in Como, he sent all he had with him to Vienna, where a total of £9,000 was secured after Juliana's arrest, so that the losses were, to some extent, repaired. During the examination, she put all the blame upon Scheurer, and pretended to be too simple to know she was committing a fraud, when she did all in her power to obtain the insurance. Although the advocate for the defense urged that his client acted under the influence of pressure, the jury found the prisoner guilty and sentenced her to 4 years' hard labor. A clumsy Philadelphia scheme. One of the clumsiest and stupidest attempts ever made to defraud a beneficial order came to light in Philadelphia in December 1889. A Dr. Murray undertook to swindle the Order of Fraternal Guardians out of $625, the amount of insurance on the life of Miss Annie McIntosh, aged 22. Though the girl was alive and well, he caused to be published in the daily papers a notice of her death at the house of a Mrs. Bame, and the statement that the interment would be at Media. The attention of the coroner was called by skeptical parties to the matter, and the facts were gradually developed in the course of an official examination. Dr. Murray, when called to testify, stated that he had been called upon to attend the patient who was formerly in his employ as a servant, and that on the 22nd of November, a man alleging to be Robert McIntosh, the brother of the deceased, called upon him for a death certificate, which he gave him. The doctor said that he wrote it on a prescription blank, giving the cause of death as peritonitis. He also claimed that the brother was accompanied by a man who was connected with Quimby's undertaking establishment at Media. He admitted that he had not seen the body of the deceased, but had issued the certificate solely upon the information of the brother that she was dead. An effort was then made to ascertain what disposition had been made of the body, the services of all the attachés of the coroner's office being called into requisition, but nothing could be learned on that point. Feeling convinced that a crime of some kind had been committed, the coroner placed Mrs. Bame under arrest. After a night in prison, she acknowledged that her previous story was untrue. When the hearing was resumed, Murray was again called to the stand. He detailed circumstantially the facts about Annie's illness and told of the issuing of a certificate by him on learning from her brother that she had died. Then Mrs. Bayne was placed on the stand, and in answer to questions, she said that Annie McIntosh had not died at her house and that she never knew such a person. Dr. Murray, she testified, had promised to reward her handsomely for allowing her house and name to be used. Murray then broke down and confessed that he had manufactured the story of the girl's death in order to defraud the Order of Fraternal Guardians out of $625, the amount for which her life was insured. He said that Annie McIntosh was alive and well at her home in the northern section of the city. The doctor's discomfiture was complete, and after a scathing rebuke from the coroner, the case was turned over to the district attorney. A Colorado false pretense. In May 1889, two crooks, mother and son of Pueblo, Colorado, devised a scheme to defraud the Washington Life Insurance Company of New York out of $15,000. A policy for that amount was issued at Denver by F.E. Busby, manager of the company, to one Daniel Stevens, who claimed to be a resident of Sheridan Lake, a small town in Bent County near the Kansas line, the policy being made payable to his mother, Mary E. Stevens. Nothing more was thought of the matter by Mr. Busby until more than a month afterward, when he received a letter from the bereaved mother, postmarked at Pueblo, Colorado, notifying him that her son Daniel had suddenly departed this life and requesting him, between her sobs, to send her the proper blank proofs of death so that she could collect the amount for which his life was insured. The tone of the letter and the fact that the insured had died so soon after getting the policy excited Mr. Busby's suspicions, and he concluded to inquire into the matter. In her letter, the mother stated that her son had died at Sheridan Lake of pneumonia, having been taken sick on the 26th of March and died on the 2nd of April, the death occurring about 5 weeks after the policy was issued. She also stated that she was then at Greenhorn in Pueblo County attending a sick friend who was very low. Mr. Busby promptly forwarded the blanks to Mrs. Stevens and then proceeded to investigate the particulars of the son's death on his own account. Inquiry developed the fact that no such man as Daniel Stevens had lived, died, or been buried at Sheridan Lake, that no one had died or been buried there within a year, and that no one in that locality could be found who had ever heard of such a man as Daniel Stevens. Convinced by this discovery that Daniel was a deceiver and still living, Mr. Busby put the matter into the hands of his attorney, F.A. Williams of Denver, and Sheriff McCarthy of Pueblo, and after a consultation with them, immediately determined upon a course of action. The proofs of death not having been yet received, Mr. Busby wrote to Mrs. Stevens at Pueblo in regard to the matter, and she at once replied, forwarding the proofs and stating that she herself had been quite sick at Greenhorn, which accounted for the seeming delay in forwarding the proofs. The promptness with which this decoy letter was answered proved that Mrs. Stevens was at Pueblo and not at Greenhorn, and Sheriff McCarthy and Under Sheriff Abbey then began the work of locating Mrs. Stevens and Daniel, feeling assured that the latter was still living and that both were in Pueblo. Mr. Busby learned that Daniel Stevens had rented a box at the Pueblo post office about March 20th, paying for it in advance and instructing the postmaster to put all mail matter coming to his address in said box, implying that he would get the mail when he came to town. Sheriff McCarthy and Under Sheriff Abbey then began to watch for Mrs. Stevens, or anyone else that might call for the mail put into Daniel Stevens's box, and they soon noticed that a young man answering the description of Daniel called for the mail. It was also discovered that he was rooming in a building on West 7th Street, formerly occupied by D.C. Montgomery. On further investigation, the bereaved mother, Mrs. Mary E. Stevens, was found at Mrs. Lane's on South Santa Fe Avenue, where she had a room and was frequently visited by the young man supposed to be her son, but who answered to the name of John Morgan in Pueblo. On learning these facts, though no one was able to identify the insured, Mr. Busby decided to remain in Pueblo until the guilty parties were brought to justice. He was accompanied by his attorney, Mr. Williams, and Mr. E.D. Haig of Thiel's Detective Agency, Denver. In the meantime, a registered letter had been sent to the address of Mrs. Stevens, and the usual notification was dropped in Daniel Stevens's box. The man supposed to be Stevens went to the post office about 9 o'clock in the morning to see if there was any mail, and Mr. Busby, who was stationed in a convenient locality, saw the man and at once recognized him as the assured. One of Sheriff McCarthy's force had shadowed him to the office, and when he came out, he was followed by another shadow. Mr. Haig was following him, and from that time until his arrest, he was not lost sight of for 1 minute, except when he was in his own room or that of his mother, and even then he was not out of sight of the officers. Leaving the post office, young Stevens went to his room and later went to his mother's room on South Santa Fe Avenue. Later, they both went to the post office, and Mrs. Stevens secured the registered letter, which informed her that the insurance money was in the Stockgrowers National Bank, where she could get it upon giving a proper receipt. They then returned to her room and determined upon a plan of action. About 2 o'clock, they walked uptown together on the other side of the street from the Stockgrowers Bank. When opposite the bank, young Stevens crossed over and went inside and inquired if there was some money there to the credit of Mrs. Mary E. Stevens in payment of a life insurance, and was told that there was. He then stated that she was in town and would be in before the close of banking hours to get the money and receipt for same. It might be well to state here that Mrs. Stevens had previously, about a week before, deposited $100 in the Stockgrowers Bank, taking a certificate of deposit and leaving her signature for the purpose, and with the intention, no doubt, of preventing any trouble about identification when she came to draw the insurance money, which she evidently thought would be sent to her through some bank. When Daniel Stevens went into the bank to ask about the money, Sheriff McCarthy and Mr. Busby were sitting in the front office where they could watch all proceedings and hear all that was said. They had been there since 9 o'clock, waiting for the game to walk into the net, confident that they would bag them before the day was over. When Stevens went out of the bank, he followed his mother up the street. She went up Santa Fe Avenue as far as Paul Wilson's dry goods store and stepped inside. The young man walked up the street a block or more, eyeing everybody he met warily, evidently on the lookout for officers. He then walked back to Mr. Wilson's store, got his mother, and started for the bank. Just ahead of them was Under Sheriff Abbey, who did not look as though he could tell a saint from a sinner, whilst just behind them walked Mr. Hegg, the Denver detective. Across the street was Deputy Sheriff Barnes, and half a block down stood Lawyer Williams, evidently taking in Andrews and Denman's show of carpets and furniture. The conspirators were surrounded and could not have got away had they desired. Mrs. Stevens and her son walked into the stock-growers' bank as unconcerned as though they were going to a meal. Mrs. Stevens was clad in the deepest mourning, and the man whose death she was apparently grieving over walked beside her with his head erect, carrying in his hand an empty satchel, which was evidently intended to receive the long-expected $15,000. When they entered the bank, Mrs. Stevens drew her deposit check for $100 from her pocket, and after endorsing it, gave it to the cashier, who handed her the money, and she in turn gave the money to her son. She then inquired regarding the insurance money, and President George H. Hobson asked her to step into his private office. He then told her that she must receipt the original policy in full before she could get the money. She expressed her willingness to do so, produced the policy, was given a pen, which she took with a firm hand, and receipted the policy in full, which she handed to Mr. Hobson, who then stepped into the bank, apparently to get the money for her, which the young man stood ready to lug off. Sheriff McCarthy and Mr. Busby had watched the whole proceeding from their position in the front office, and at this point stepped forward and passed quickly into the rear office, McCarthy presenting his pistol as he entered, remarking to Daniel Stevens, "I am the sheriff of Pueblo County, and I arrest you on a charge of conspiracy," at the same time slipping a pair of handcuffs on the prisoner's wrists. Stevens offered no resistance and sank down into a chair. Mrs. Stevens arose as if to leave, but the sheriff remarked, "Sit down, madam. I want you also," and she sat down. In the meantime, Under Sheriff Abbey, Detective Hegg, Deputy Sheriff Barnes, Mr. Williams, and a newspaper reporter had arrived on the scene, and any attempt on the part of the conspirators to resist or escape would have resulted very seriously. A carriage was promptly called, and the prisoners were taken to the county jail, where they were confined on a charge of conspiracy and forgery, with the prospect of a long time in the penitentiary at Canyon City. The young man was then asked his name and replied that it was Brooks, but his mother corrected him promptly and said it was Stevens. Later, however, she made a partial confession to Sheriff McCarthy and Mr. Busby, and begged the latter piteously to let her son escape, even going so far as to offer him the $100 she had drawn from the bank if he would do so. She also confessed that their real names were Herbert Brooks and Mrs. Sarah A. Brooks, formerly of Silver Cliff, Colorado, and that she is Herbert's own mother. Parties in Pueblo who knew them said that they formerly moved in good society at the Cliff and were well thought of there. Mrs. Brooks was then a woman about 45 years of age and apparently of some education and refinement. Young Brooks was about 25 and was a fine-looking fellow. Mrs. Brooks claimed that she was led into this trouble by other parties, but she would not say who they were. There is no doubt that she and her son made out all the proofs of death, though they were seemingly sworn to before J.W. Krieger, a notary public at Lamar, all the documents bearing the imprint of his seal. A physician named Lewis was made to testify that he attended Daniel Stevens, alias John Morgan, alias Herbert Brooks, in his sickness. The coroner testified to his death, the undertaker to his burial, and various friends to the fact that they knew him when alive and saw him dead. And Mr. Krieger, who is a well-known lawyer at Lamar, apparently took the acknowledgments of all these people, but his signature on file in the Secretary of State's office proved conclusively that all the documents were forgeries. Hence the conclusion that Mr. Krieger's seal was stolen for the occasion. End of section 2. Section 3 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies, an authentic record of remarkable cases by John B. Lewis and Charles C. Bomball. Pretended Death, Part 3. False Personation of Applicant. False impersonation in making application for insurance and in undergoing the requisite medical examination is a dangerous form of fraud. Here, both agent and examiner may be innocent victims of deception. On the other hand, both may be in rascally collusion with other parties to defraud the agent's company, or again, the agent may conspire with others to deceive the examiner. Mr. Francis, in his Annals, gives an account of the earliest known instance of such deception. Application was made in the year 1780 to a London office to insure the life of a lady for £2,000. Her health was sound, constitution excellent, references satisfactory, and the policy was issued. Within 6 months, a claim was made for the money. In the proofs of loss, which were found to be regular, the disease was certified to be pulmonary consumption. Thereupon, directors looked grave and questioned the secretary, and the secretary looked rueful and questioned the doctor. There was no accounting for such a termination of the risk. It seemed en règle. No fraud could be alleged, and the policy was paid. Information subsequently given to the office, however, led to inquiry, and it was ascertained that one sister being an incurable invalid, the other personated her at the assurance office, deceived the medical examiner, sent in the certificate of her sister's death, and obtained the money. Thereafter she disappeared, and no thought of restitution was entertained. To lessen the risk of this vicarious portraiture, this impersonation mutato nomine, the companies lay more stress than formerly upon means of comparison and identification, exactitude in height, weight, chest measure, complexion, color of eyes and hair, and personal peculiarities. Moreover, they employ the checks and guards of systematic inspection and the machinery of detective agencies. Even when these instrumentalities are at fault, the gamesters frequently defeat themselves in one way or another. In a case reported from Montreal, for example, certain creditors of a consumptive named La Ferrière were anxious to reimburse themselves in advance of his prospective death. A healthy substitute was provided for examination, and policies were issued by 3 life companies to the amount of $20,000. These policies were assigned to the creditors. Within a month after the payment of the first premium, the invalid died, a little too hurriedly for the success of the game of the conspirators. The proofs of loss revealed the nature of the fraud, and the companies concerned naturally and properly refused to be victimized. On the other hand, in a case reported from Boston in April 1891, the rascals succeeded in swindling the New York Life out of $2,000. The particulars, as published, showed that the policy had been issued 2 years before to a citizen of Boston, and at his death the money was paid to his widow. It was discovered that the man himself did not make application for the policy, being a consumptive, and that another, named John J. King, personated him at the medical examination and other preliminaries to the issuance of the policy. King, it is alleged, acted throughout in conspiracy with the wife of the consumptive, and received half of the amount of the policy from her. When the fraud was discovered, a warrant was issued for the arrest of King, who was traced to the house of his brother in Brooklyn, where he was captured. Among the Molly Maguires, the case of Catherine White against the United Brethren Mutual Aid Society, tried before Judge Handley in Scranton, Pennsylvania, in 1879, brought out the facts in an attempt to falsely personate an applicant. In 1878, Patrick Waldron of Scranton was the agent in that city for the UB Mutual Aid. On the 16th of August, 1878, he forwarded an application for a $3,000 membership on one Mary White of Scranton in favor of her sister Catherine White. Dr. Horace Ladd was the examining physician for the society at Scranton, and his certificate showed the applicant to be a woman in excellent health and a first-class risk. The society issued its certificate of membership on the application for benefit to the amount of $3,000 in favor of Catherine White, sister of Mary White, and late in November, notice was received that Mary White had died on the 22nd of November, 1878, of pneumonia. About the same time, a letter was received from Andrew White, the husband of Mary White, giving warning that the transaction was fraudulent, that neither he nor his wife had known anything about it, that his wife was taken sick in April 1878, had severe hemorrhages of the lungs in June 1878, and died of consumption. The society investigated the case, found the facts exactly as stated by Andrew White, and thereupon refused to pay the claim and dismissed the agent. Catherine White brought suit to recover the $3,000. At the trial, Dr. Horace Ladd swore that he did not know Mary White nor her sister, Catherine White, personally, that the woman whom he examined as Mary White was at the time August 15, 1878, a stout, healthy, robust woman weighing not less than 146 pounds, and that when asked to sign the application, she stated that she could not write her name, but made her mark. Dr. Connell swore that as early as June 1878, he was called to attend Mary White professionally, that she, during that month, had frequent hemorrhages of the lungs, that he visited her at least 8 different times prior to August 1878, that she was very much emaciated and would not have weighed over 100 pounds, and that he prescribed the remedies usually administered in pulmonary consumption. Andrew White swore that his wife, Mary White, was taken ill in April 1878, that in June 1878 she became dangerously ill, had hemorrhages of the lungs and a severe cough, that they called in Dr. Connell, that she was then already very much reduced in flesh and would not have weighed over 100 pounds, that his wife could readily write her name and never signed by making her mark, and that neither he nor his wife knew anything of the insurance on her life. 3 of the neighbors swore that in June 1878 they were several times called into Mr. White's house on account of her bleeding at the lungs, that they hourly expected her death, and that she was so reduced that she would not have weighed over 100 pounds. For the prosecution, Patrick Waldron, said to be Molly Maguire, swore that the Mary White who died, wife of Andrew White, was the identical woman whom he took to Dr. Ladd's office and had examined. A police officer of Scranton, said to be a Molly Maguire, swore that he saw Patrick Waldron and Mary White, the identical woman who died, go into Dr. Ladd's office that day, and that he talked with them on their way. Another Irishman, said also to be a Molly Maguire, swore to the same thing. Dr. Haggerty, a Molly Maguire, the attending physician, swore that Mary White died of pneumonia and not of consumption. After this exhibition of Molly Maguireism, there was no resource except to carry the case to a higher court beyond the baleful infection of an atmosphere of perjury. The personality of a yellow dog. About the time that the Belfast conspirators were palming off on the English managers of an American life insurance company an uninsurable Negro for an insurable Irishman, as narrated elsewhere in this volume, a gang of gamesters in South Carolina had a yellow dog insured under the name Jim Brown, presumably a gentleman of the colored persuasion. The gang implicated in this comedy, as well as in other fraudulent transactions, numbered 19 persons, black and white. For a considerable period, their operations crudely conducted as they were, resulted successfully, the total sums out of which the companies had been swindled amounting to over $100,000. The leading sinners were a family of whites named Bond. Their plan was to insure the life of a fictitious person, then to hire lodging rooms, place an alleged wife in possession, and announce to the neighborhood that her husband was dying. The announcement was followed by the news of his death. Bodies were smuggled from the potter's field, secretly conveyed into the premises, and in due time buried in the cemeteries. Then the insurance money would be collected. One of the Bonds was a physician, another was an agent of the insurance companies, and the third acted as buyer of the corpses. The conspiracy was finally unearthed by Pinkerton detectives sent to the scene of action by the Travelers Insurance Company of Hartford and the United States Mutual Accident Company of New York. Many of the rascals fled from the state and escaped. The case which led to discovery was that of a colored person named Joseph B. Dudley, who was insured in 2 accident companies in the sum of $5,000 each. In the process of investigation, a confession was obtained from trustworthy parties that no such person as Dudley ever lived, and that the corpse, alleged to be that of the fictitious Dudley, was obtained in a graveyard for colored people. Among the discoveries made by the detectives was that concerning Jim Brown. This party, on whose life the amount of a policy held by the Bonds and their agents, prominently the colored woman Mary Dudley, was paid at maturity, turns out to have been a yellow dog. It was learned that one and the same Negro corpse was, with noteworthy economy, utilized 5 times in making up proofs of loss in as many different cases of alleged death. If anyone up to this period thought that the limit of diabolical ingenuity had been reached, he must have been surprised to learn from the Bonds that the harp strings were capable of being attuned to new melodies. They showed that even the element of facetiousness may be successfully introduced in the game. They demonstrated that for practical purposes a yellow dog may personate a man, that he may be insured as a man, that his human owners may have an insurable interest in his life, and that when the dog dies, as die he must and will under such circumstances, the beneficiaries may present a valid claim which the insurance companies will duly recognize and pay. All of which is, in one sense, extremely funny. But these fun-loving adventurers extended the range of their profitable amusement. They concluded that it was troublesome to obtain a disinterred corpse. It was only fair that the one they procured should reimburse them by serving 5 times over in the way of substitution for the individuals, or rather the dummies, that had been insured for their benefit. The funny part for them and the serious feature for the companies was that the claims thus set up were paid without question or investigation. But the comedy came to an untimely end. One of Pinkerton's sternest detectives, Gustav Frank, appeared on the scene of action and rang the curtain down. A German-American wife murderer. In October 1892, Hugo Waller, a German, 30 years of age, and his wife removed from Indianapolis to Toledo, Ohio. In the following March, the police were after him on the charge of poisoning Mrs. Waller, the motive being collection of an insurance amounting to $5,000. It appears that Mary Neese, a domestic, 26 years of age, was engaged to do housework for them, and that a short time afterward Mrs. Waller proposed a trip to Chicago via Detroit and persuaded Miss Neese to accompany her. At Detroit, the two women visited the office of the Equitable Life, and Mrs. Waller persuaded her companion to have her life insured for $5,000. She also induced the girl to pass herself off as Mrs. Hugo Waller, and the policy was made out in that way. Shortly after, the family moved to South Bend, Indiana, and Miss Neese went with them. Suddenly, Miss Neese became ill and complained of nausea with painful swelling of her face. She suspected that she was being systematically poisoned, and becoming frightened, left the house and went to Chicago. Waller and his wife returned to Toledo in February. Here, Mrs. Waller was taken sick, the symptoms being the same as those suffered by the girl. On the night of February 20th, Mrs. Waller died. Mr. Waller notified the insurance officials at Detroit of his wife's death, enclosed a copy of the death certificate, and demanded the $5,000 insurance due on the death of his wife. Insurance agents went to Toledo and investigated the matter. They examined the corpse at the cemetery vault and were astonished at the discovery made. It was not that of the woman that was insured in the name of Mrs. Waller, and an autopsy of the body disclosed the presence of strychnine in the stomach. Waller suddenly left town and made his escape. End of section 3. Section 4 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies. An authentic record of remarkable cases by John B. Lewis and Charles C. Baumbaugh. Pretended Death, Part 4. Substitution of a body or padding. That history repeats itself is frequently shown in the substitution of another body or of padding in a coffin at the time of burial. There, for example, was Franz Tomacek in Berlin in 1848, who had been heavily insured and who, impelled by irresistible curiosity and disguised beyond recognition, attended his own funeral. But when the police were put upon the trail and disinterment took place, the contents of the coffin was found to consist of stone and straw. There was the case in 1874 of Uhling, a New York physician who was convicted of an attempt to swindle a local life company and sentenced to Sing Sing, where he served out his term. He certified to the death of an insured woman, and the company was called upon for payment, but suspicion led to an examination, and it was disclosed that instead of a dead woman, there were 100-and-odd pounds of bricks in the coffin, for the death of the contents of which payment was demanded. In another case, the coffin was filled with sand. This occurred in 1880 at Fillmore, a village in Andrew County, Missouri. The coffin was supposed to contain the remains of James Riggin and was exhumed in consequence of well-grounded suspicions of fraud. Some time before, Riggin had insured his life for the benefit of his aged mother and then left for the West. Soon afterward, his brother-in-law received a letter announcing his death at North Platte, and going thither, he returned with the coffin, which was not opened because of the supposed decayed condition of the remains. Application being made for the insurance, investigation led to the discovery of the sand and exposure of an intended fraud, Riggin being still alive and the principal agent in a conspiracy to defraud a life insurance company. A case which merits more than a passing notice is that of Vital Duas. One of the most remarkable of the London police is Sergeant Druskovich. No one looking at the short, blonde-mustached, and rather dandified young man would suspect him of being the cleverest of detectives. He speaks any number of languages, and is therefore nearly always sent abroad when any case occurs in a non-English speaking country needing the services of an English detective. In London, his special work is among foreigners who go there as fugitives from justice. Druskovich was engaged to work up this case. In 1865, Vital Duas, a Bordeaux wine merchant, insured his life to the amount of 100,000 francs in one of the insurance offices of Paris, after which he returned to his place of business at Bordeaux. Shortly afterward he went to London in order to escape the consequence of a fraudulent bankruptcy. Some time later, his wife, clad in widow's weeds, presented herself at the insurance office with the legal documentary proofs of her husband's death. Suspicion was aroused in the minds of the insurance officials at Paris. The money was not paid, and the case was forwarded to the British authorities for investigation. Sergeant Druskovich was called in and succeeded in ascertaining the following extraordinary facts. Arriving in London, Duas took up his residence at Ford's Hotel, giving the name of Roberti, where, after remaining for a few days, he desired a French waiter at the hotel to write him out a certificate in English, purporting to be signed by Dr. Petit, to the effect that one Vital Duas had died on the 29th of November, 1865, of aneurysm of the heart. On the 1st of December, this certificate was presented to the Register of Deaths at Plaistow by Duas, who now assumed the name of Bernardi, and the death was registered in the usual way, it being stated that the body was then lying at number 32 Ann Street, Plaistow. On the same day, he procured a certificate from the Register of Deaths, and thereupon the sexton of St. Patrick's Cemetery, Low Leighton, ordered a grave to be dug. Duas, alias Bernardi, paid the regulated burial fees and appointed the following Sunday for the funeral. Having made these arrangements, he then went to the undertaker, to whom he gave the name of Rubini, and purchased a full-sized ready-made coffin in which he caused to be placed a thick lining of lead and the handles altered from the sides to the ends of the coffin in the manner usually adopted in France and other continental countries. Duas had the coffin conveyed to the cemetery, himself being the chief and only mourner. The coffin and supposed body were taken into the chapel of the cemetery, where the burial services were read over it by the Reverend Mr. McCoy, and with all the ceremonies of the Roman Catholic Church, the ostensible remains of Duas were consigned to the earth. The whole of these circumstances, which in themselves were highly suspicious, induced Sergeant Druskovich to apply for a license to exhume the coffin said to contain the body of Vital Duas. This having been obtained, Sergeant Druskovich and two persons who were personally acquainted with Duas proceeded to the cemetery. Upon being exhumed, the coffin was opened in the presence of the officers and the two witnesses who had attended for the purpose of identifying the body of Duas, and was found empty. The whole of the burial was a sham. The weight of the supposed body of Duas had been made up for by the introduction of an additional quantity of metal to the lead lining. Upon these facts, a warrant was granted for the apprehension of Duas. A search was immediately instituted by the officers, and the result was that they discovered the delinquent had taken his departure for America, and was thus beyond the pale of English law. Some time afterward he returned to Europe and went to Antwerp, where in November 1866 he was arraigned before the criminal court for attempting to obtain sums of money from insurance companies by setting fire to goods he had insured at high rates. 2 barrels of tar and the debris of cases which contained resin, chips, alcohol, powder, and charcoal were produced in court. An Antwerp underwriter had insured this property for $24,000 against sea risks. The prisoner represented that the cases and barrels contained laces and clocks valued at $50,000, for which he produced invoices. The cases, however, ignited in the quay before they were shipped on board the Duc de Bourbon, the ship chartered to convey the cargo. The jury, after a lengthy trial, found the prisoner guilty, and sentence of death was passed on him. But the French government claimed him under its Extradition Act, and he was handed over to be dealt with by the tribunals of that country for his fraudulent bankruptcy, and also for his attempted fraud on the Paris Life Insurance Office. For the latter offense he was tried, found guilty, and sentenced to penal servitude. The Ohio Broom-Corn Case. Toward the close of the year 1866, a plot was contrived to rob 2 or 3 life companies by a gang at Eaton, Preble County, Ohio, composed of B.M. Batchelor, an apothecary and local insurance agent, William Abbott, a class leader and mayor of Eaton, Dr. N.S. Richardson, who on a previous occasion had successfully swindled a life company out of $4,000, and his brother Frank, who lived near Lebanon. These confederated scamps invented a fictitious personage whom they named W.T. McFadden. This dummy, personated by the pious abbot, was insured for a large amount, and when the plan was fully matured, managed to die on Christmas Eve of cholera, conveniently introduced at that unusual season because of the rapidly fatal collapse incident to the Asiatic malady. This part of the tragic farce was enacted in Frank Richardson's house in Lebanon. His wife, innocent soul, had been conveniently sent to visit her own people that the coast might be entirely clear for the conspirators. Frank called at an undertaker's and ordered a coffin for a gentleman who had died at his house of cholera. Thence he went to the telegraph office and dispatched this message to Eton in care of bachelor. Mrs. Sarah McFadden, your husband died here this morning. Answer. Hasty preparations were made for departure with the corpse to Eton, where it was deemed advisable to have an immediate funeral. Chloride of lime was freely sprinkled about the premises, and cautious avoidance was enjoined upon the neighbors. The coffin lid was screwed down, and the mournful satisfaction of gazing upon the remains was denied. The only assistance solicited was to lift the coffin into a wagon early on the following morning, which was done by friends and neighbors cheerfully, but not without a twinge of suspicion of foul play. The Richardson brothers, there were 4 of them, were all clouded with a bad reputation. If they had borne a better character, the good people of the vicinity would not have suspected criminal taint even under such strange and singular circumstances. But after the wagon had been driven off, they freely discussed among themselves these unusual proceedings, and the more they compared notes, the more they became convinced that the interference of the legal authorities was demanded. Accordingly, Dr. H. White, the coroner, started in pursuit to Carlisle Station, whither Frank had said he intended to take the body for shipment to Eton. Arriving at Carlisle, the coroner failed to obtain any tidings whatever of the funeral party, and the suspicion that a very serious crime had been committed was strengthened hour by hour. Frank Richardson's house was searched by an eager crowd. Officers were dispatched to Eton, and telegrams from the latter place disclosed the fact that no man of the name of W.T. McFadden had ever lived there, though, to complicate matters, a woman called Sarah McFadden, professing to have a husband named W.T., had spent some weeks in Eton shortly before, but had gone away no one knew whither. Frank Richardson turned up at Winchester, near Eton, where he was met by a hearse and a carriage containing 2 women closely veiled. The coffin was transferred to the hearse, and the little procession proceeded on its way with a solemnity befitting a funeral occasion. The movement was timed so as to reach the churchyard at midnight. Dr. Richardson, in order that his dear friend Mac might have the full benefit of Christian burial, had engaged the attendance at the grave of his beloved pastor, and at his special request the clergyman delivered a brief discourse upon the uncertainty of life. Dr. Richardson was a member of the church and, though not in good standing, was recognized as such. This dramatic scene occurred on the night of December 25th, 1866. Early the next morning, the Lebanon officials arrested the actors who had thus devised and performed their parts in the midnight burial. They then endeavored to employ the sexton in the work of disinterment, but found that personage rather shaky. He had had the cholera once, and he was afeard of it. "The blamed thing," said he, "smelt powerful bad last night," and its disturbance, in his view, would be attended with dangerous consequences. A greenback, however, overpowered his resistance, and, swallowing his aversion, he went vigorously to work. The grave was opened, and the coffin was raised, but on lifting the lid, the searchers found not a body, but a few sacks filled with broom corn seed. Upon this unexpected discovery, the two Richardsons and bachelor were taken to jail. The other conspirators escaped, the woman returning to Cincinnati, where she was a notorious Cyprian, and as Abbott, the personator of McFadden, was declared to be dead, and as there is no warrant of authority to arrest a man for being dead, the scamp was allowed to go unnoticed. A trick that did not succeed. In the month of July, 1865, the body of a dead woman in the advanced stage of decomposition was discovered in a field adjoining the town of Richmond, Indiana. A coroner's jury was at once impaneled, and the evidence taken before it went to show that it was the body of Mrs. Mary Davis, wife of John B. Davis, a shoemaker who resided in Richmond. Mrs. Davis had been missing from home for some time and could not be found. The clothing upon the dead body was recognized as that of Mrs. Davis. The decayed condition of the body was such that it could not be determined whether or not there were external evidences of violence upon it, but it was generally conceded that she had been murdered. It subsequently appeared that Mrs. Davis was insured in the Connecticut Mutual Life Insurance Company for $2,500 and in the New York Life Insurance Company for $3,000. Proofs of death based upon the evidence brought before the coroner were furnished to each company, and the New York Life paid the amount of its policy to the guardian of Mrs. Davis's children. The Connecticut Mutual would not pay on the evidence of death produced, and suit was brought to recover the amount. The company instituted a thorough investigation of the case and was soon able to expose what proved to be a conspiracy to defraud. The missing Mrs. Davis was hunted down and found living in the town of Greensburg, Westmoreland County, Pennsylvania. Affidavits, one of a photographer who sent with it a photograph of the woman, one of a physician who had known her many years and who saw and conversed with her at the date of his affidavit, and one of the identical Mary herself, dated January 7th, 1867, were filed in court by the company, whereupon the suit was discontinued. The New York Life at once brought suit against the Guardian for the amount of insurance paid to him under their policy and recovered the amount less court charges and an allowance to the Guardian who had acted in good faith. Mr. Davis had rejoined his wife in Pennsylvania, and when found, both were preparing to go south as soon as the money on the Connecticut Mutual policy was paid to them. Luckily for the New York Life, the money paid by that company went into the hands of a guardian instead of into the hands of Mr. Davis, who was the principal party to the conspiracy beyond a doubt. The Radloff Conspiracy. On the morning of the 16th of April, 1892, the house of William Radloff, situated about 4 miles north of Seattle, Washington, in the woods and remote from neighbors, was found to have been burned to the ground. In the ruins were the charred remains of a man. The natural inference on the part of the neighbors was that Radloff, who had been sleeping there alone more than a week, had perished. Radloff was a German, 28 years old, and had married 2 or 3 years before an American wife with whom he had not been happy. For 3 or 4 months, a handsome young Austrian, Louis Kostrock, lived with the family and was on very good terms with the wife. At the time of the fire, she and her baby were visiting her parents near Tacoma. Kostrock was also absent, and the authorities jumped to the conclusion that Kostrock had murdered Radloff in order that Mrs. Radloff might be free to marry him. Kostrock was arrested. In his possession were found a love letter from Mrs. Radloff and a money order made out for her by her husband. Kostrock was at first reticent and denied having talked with Radloff the day before the fire. At last he said that perhaps he might tell what he knew if he were assured that he would not be hanged. The police were convinced that they had the criminal in their hands and searched no further. The case was then complicated by the discovery that within 2 months Radloff had taken out $55,000 life insurance, $20,000 in the New York Life, $20,000 in the Equitable, and $15,000 in the Mutual Life. The insurance men inclined to the belief that Radloff was not dead, but had entered into a conspiracy to defraud the companies. A cemetery near the Radloff house was examined and evidence was obtained that the body in the ruins had been taken from one of the graves there. The chain of proof was so complete that at the inquest the whole story came out by Kostrock's confession. Kostrock said that he and Radloff and Mrs. Radloff planned the whole affair. Radloff on March 9th applied for insurance in the 3 companies named and was passed by the physician as a first-class risk. In the Mutual Life, he paid an annual premium on his policy, and in the 2 others, he arranged to have the payments made quarterly. In each case, he made payment within 2 weeks of the fire. The amount of the insurance was considered by the agents as rather remarkable, but Radloff, who had lived in this country for over 8 years, had made a snug fortune in real estate and also professed to have a steady income from family estates at Mecklenburg in the old country. He said his wife had consulted a fortune teller who had predicted his death, and he had taken out the life insurance to allay her nervousness. A few days after the medical examiners had passed him and the applications had been sent to the home offices for acceptance, Radloff and Kostroch went by night to the cemetery and dug up the body of R.D. Lewin, a neighbor of about the same age as Radloff, who had died of consumption on February 17th. They took out the coffin but left the wooden box that had enclosed it. The coffin with the body was buried again in the chicken yard near Radloff's house. Then the conspirators waited for the insurance policies. When they were received and everything was ready, Mrs. Radloff was sent away to her parents, and Radloff and Kostroch dug up the body, stripped it, and put a pair of Radloff's old trousers on it and laid it in Radloff's bed. Then they filled the room with shavings, poured coal oil all about the house, placed an axe near the bed, and set 2 lighted candles in the midst of the inflammable materials. The candles burned down in about 3 hours, and the men, who had by this time got well away from the scene, saw the flames light up the sky. Radloff, as was afterward learned, started the same night for San Francisco, but Kostroch remained behind. He played a clever part after his arrest, hoping to be considered a murderer and to divert the officers so that no description of Radloff would be telegraphed abroad. He was, however, prepared to prove an alibi later. The grave of Lewin was found to be empty, and the handles of the coffin were picked up in the ruins of Radloff's house. Mrs. Radloff denied any knowledge of the conspiracy, although Kostroch says they were all to meet in Germany and enjoy the life insurance money. A few days after these revelations, another sensational phase in the case was developed in the arrest of Dr. Frank R. Ballard of Fremont, a suburb of Seattle. The arrest was made on the confession of Mrs. Radloff, partly through fear of Radloff on account of Ballard's intimacy with her. Ballard entered into a plot with Radloff and Kostroch to defraud the life insurance companies out of $55,000. It was arranged that Ballard would swear that the cadaver found in the burned ruins of the Radloff house was William Radloff's body. This he did. He was also to assist Mrs. Radloff, who was to remain at Seattle, in collecting the insurance from the life companies. For his aid, he was to receive $10,000. The police were already on the track of Radloff and soon had him, as well as the rest of the gang, in custody. End of section 4. Section 5 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Stratagems and Conspiracies to Defraud Life Insurance Companies, an authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Pretended Death, Part 5. A Belgian Monster. The case of a Belgian murderer dating back to 1888 furnishes a remarkable instance of false personation and of subsequent substitution of a body. A man styling himself Hoyos Bijou, the latter being the name of his mistress, applied to the Phoenix Company, Paris, to insure for 100,000 francs a cousin, Hippolyte Hoyos, a commercial traveler. The company requiring a medical examination, he suggested that as his cousin was rarely in Paris, he might be examined at Chartres. This was done, but Hoyos personated his supposed cousin. Shortly after, a dead body was discovered in the wood at Chantilly and was identified by Hoyos as that of his cousin. It turned out that Hoyos enticed to Chantilly a workman in his employment named Louis Béron, a Belgian, and murdered him. Hoyos was arrested on suspicion at Valenciennes, and the body exhumed. The clothes were recognized as having formerly been worn by Hoyos, who is believed, therefore, to have given them to the victim. The body was found on the railway, and a train had gone over one leg. This was apparently arranged because Béron limped, in order that the malformation of the leg might not be detected. The body of the man murdered at Chantilly was admitted by Hoyos to be that of his workman Béron. Hoyos, however, denied that he murdered him, and he at first pretended that he had never been at Chantilly, but on a publican identifying him as a customer, he acknowledged having visited the village. Besides the insurance for 100,000 francs, he had added to it in another office 80,000 francs. Such was the report as first published. It afterward appeared that instead of substituting a murdered body for the living body of his cousin, he changed his plans. He had his own life insured in various offices for 250,000 francs, and as Louis Béron bore a strong resemblance to himself, he selected him as a victim, as stated, but with the change in his purpose, the body of Béron was made to pose as his own. He dressed the body with his own clothes, left in the pockets various documents belonging to himself, Hoyos, and a will drawn up by the murderer, leaving everything to Louis Béron. The victim was buried as Hoyos, and then Hoyos, under the name of Béron, attempted to collect the insurance money. Fortunately, he did not prove as effective an actor as a murderer, and suspicion having been aroused, Hoyos was arrested and taken to Chantilly for trial. The revelations of his previous career that then ensued were startling. 14 years before, the desperado insured his wife's life for $20,000. A few weeks afterward, she was killed by a horse's kick, Hoyos said, but it was proved that he had just previously bought a horseshoe and fastened it to the end of a mallet. He was a man of enormous physical strength, and there is little reason to doubt that he killed the woman with the strange weapon. But Hoyos was acquitted in the absence of actual proof. The following year, he killed a Belgian judge, but again escaped punishment, owing to imperfect evidence. After a term of imprisonment for forgery, he went to France, where for years he led a mysterious life, constantly changing his name. In 1885, he returned to Belgium, was convicted of swindling, and sent to prison for 2 years. At the expiration of his sentence, he returned to Paris with a young woman whom he had persuaded to elope with him. He ill-used and finally deserted the girl, and then he became a land steward and was dismissed for attempting to strangle the gamekeeper. A Hungarian assassin. Somewhat similar to the procedure of Olyos was that of a cattle dealer named Grunbaum living at Nusol in Hungary, who disappeared from view. As he was known to be in fair circumstances and good health, it was naturally apprehended that he had fallen a victim to foul play, and a diligent search was instituted. The result was that in a wood not far from the town a mutilated corpse was found, in the pockets of the clothes of which were letters addressed to Grunbaum, and which at once recognized by Grunbaum's wife as the body of her husband. Not very long before his disappearance, Grunbaum had insured his life to the amount of 10,000 florins in one office and 5,000 florins in another in the city of Pest. Soon after the funeral, in fact, in quite indecent haste, these sums were claimed by his widow, to whom everything was left by the will of the deceased. Before the policies were paid, however, the suspicions of one of the offices were excited by some chance. Inquiries were made, and finally it was discovered that Grunbaum was still alive. He was at once arrested, and it was discovered that he himself murdered a stranger he met in the wood where the body was found, dressed the corpse in his clothes, putting on himself those of the dead man, and placed his letters in the pockets of his victim. His wife was to draw the policies payable on the death of her husband, and the two then intended to emigrate under another name to America. A double impersonation. In a recent case reported from New York City, an alleged wife failed to obtain a recommendation from a suspicious examiner of a prominent company. On the principle, if at first you don't succeed, try again, the husband undertook to impose another woman on another company, and this time he succeeded. It appears that in the early part of May 1895, a woman who gave her name as Mrs. Annie Silverman and said she was the wife of Wolf Silverman of Broome Street called on Dr. George E. Steele, medical examiner for the New York Life Insurance Company. She wished to take out a policy of insurance and asked the doctor to make the usual medical examination. He did so and found her to be a strong, healthy woman. She was, in fact, in such excellent physical condition that the most careful insurance company would have readily accepted her as a risk. Dr. Steele, however, notwithstanding the satisfactory medical test she had undergone, was not satisfied with appearances. For one thing, she told the doctor she was of German nationality when she was obviously Irish, and there were other things that confirmed his unfavorable impressions, and hence he advised rejection. A few days later, Wolf Silverman, accompanied by a woman who he alleged was his wife, visited the office of the Empire Life Insurance Company, formerly the Home Benefit, and negotiated for an insurance upon her life. Everything was apparently regular, and on May 13th, a policy for $3,000 upon the life of Mrs. Annie Silverman was issued. On June 29th, after a lapse of only 46 days, Silverman informed the company that his wife had died and made a claim for the insurance money. that so healthy a woman as the presumed Mrs. Silverman should die so soon after being insured naturally created doubts in the minds of the Empire officials, and in the course of inquiry into the history of the case, they consulted Dr. Steele. Comparisons failed to point to any resemblance between the woman Dr. Steele examined and the one who accompanied Wilf Silverman to the Empire Life Office. Thereupon, the latter company contested Silverman's claim and, through its attorneys, obtained an order for the taking up of the body. On behalf of Silverman, an injunction to restrain digging up the body was secured. The attorneys for the company, however, persisted in their efforts to have the body taken up and eventually succeeded in having Silverman's injunction set aside. When the exhumation took place, it was discovered that the body which had been buried was not that of either of the women who had previously figured as Wilf Silverman's wife. But while there seemed to be little room for doubt that a deliberate attempt to deceive had been made, there was no ground for suspecting that the woman whose body was exhumed met her death by foul play. The probable view is that Silverman's legitimate wife was attacked by serious illness, and he, knowing that no insurance company would accept her in that condition, had her falsely impersonated by someone else. An East Indian trick. In October 1895, a Brahmin named Rajkeesto Chatterjee was charged in the police court at Calcutta with having defrauded the Oriental Life Assurance Company of 16,000 rupees and with having committed forgery for that purpose. It appears that about 2 years ago, accused, who gave his name as Susti Das Roy, insured his life in the company for the sum mentioned. After premiums had been paid on the policy for 12 months, Jogabandhu Roy, a well-to-do Bengali residing in Ballygunge, addressed a letter to the Bengal representatives of the Oriental Life, informing them that Susti Das Roy was dead, that deceased had assigned the policy to him, and asked that arrangements should be made for the payment of the amount due. The letter was accompanied by a certificate from a native doctor named Rutikanta Gosa, who testified to having attended Susti Das Roy, giving the address of the house of the supposed deceased, for 2 months, and to being with him when he died. Jogabandhu also sent a certificate of identity of the supposed deceased. Some time afterwards, it was discovered that the Susti Das Roy, who had insured his life and was supposed to be dead, was still alive, that his real name was Rajkeesto Chatterjee, and that in collusion with the other Babu and the native doctor, the fraud had been perpetrated. A warrant was then applied for, and after 7 months, the supposed Susti Das Roy was arrested at Etawah in the northwest provinces. The prisoner pleaded guilty, and after formal evidence had been recorded, he was remanded. Afterwards, warrants were obtained for the arrest of Jogabandhu Roy and Dr. Rutikanta Gosa. Unsuccessful counterfeit presentment. In February 1889, old Mr. O'Brien, a quiet and retired citizen of Mahanoy City, Pennsylvania, became so ill that he was not expected to live. His son, who was a justice of the peace, and the latter's friend Pat Foley, who was a constable, thought that this was an opportunity which ought to be improved. To obtain insurance, they hired a man named Gallagher to personate Mr. O'Brien for the medical examination. Dr. H.A. Clark passed Gallagher under the name of O'Brien as an acceptable risk in the Prudential Mutual Aid Association. Dr. Clark was not deceived by the false personation inasmuch as he was a party to the intended fraud. Fictitious proofs of loss were submitted to the association, and the sum of $1,200 was paid to Squire O'Brien. In the division of the money, one of the conspirators was left out. After repeated threats of exposure had failed to bring him any return, he squealed. His revenge took the shape of a letter to the Prudential. The company hired Captain Doherty, a Pinkerton detective, to investigate the case. He spent a few days in Mahanoy City and got to the bottom of the scheme. The result of his work was the arrest of Squire O'Brien, Constable Foley, Dr. Clark, and Mr. Gallagher as parties to the fraud. All four were taken before Squire Cutner, who, after a brief hearing, put them under $1,000 bail each. Gallagher at the hearing was pointed out by the detective as the man who was examined. The affair created a great sensation, as all the parties concerned were prominent in political circles. End of section 5.
Section 6 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Larry Wilson. Stratagems and Conspiracies to Defraud Life Insurance Companies, an authentic record of remarkable cases by John B. Lewis and Charles C. Bamba. Speculative Insurance, Part 1, Gambling. Kent, in his commentaries, says, the necessity of an interest in the life insured, in order to support the policy, prevails generally in this country, because wager contracts are almost universally held to be unlawful, either in consequence of some statute provision or upon principles of the common law. In the early history of life insurance, this disregard of the question of insurable interest led to gambling of the most pernicious sort. Although the abuses incident to this speculative practice in England, as graphically described by Mr. Francis, have yielded to prohibitive statutes, it appears that in some countries it is not unusual, even at the present day, to effect insurances upon the lives of individuals not connected in any way with the wagering parties. Among illustrative cases may be cited the following curious instance. Swedish gambling. In 1855, one Svensson of Karlskrona insured the life of an old soldier named Hofstedt, of the same place, in the Mentor Company of London for 8,000 rix dollars, and in the Paternelle Company of Paris for 7,500 francs. In August 1856, Hofstedt died, and Svensson claimed the amount insured in the two offices. The Mentor Company paid at once, but the Paternelle thought it advisable to institute an investigation respecting the death. It then turned out that Hofstedt was a confirmed drunkard, and that Svensson supplied him money to enable him to drink brandy in excess, his object being, it was affirmed, to hasten his death. The old soldier at last died very suddenly, and the rumor was spread that Svensson had poisoned him by putting arsenic in the brandy. The dead body was examined, and arsenic was found in it. Svensson was consequently arrested and brought to trial before the criminal court of the district on the charge of poisoning. But the charge could not be established. He was acquitted. As, however, he was proved to have had arsenic in his possession, and in Sweden this is illegal for a private person, he was fined 16 rix dollars. On appeal, the judgment was confirmed. The public prosecutor then petitioned the king to cause the man to be imprisoned in a fortress on the ground that there was no moral doubt of his guilt. In August 1857 His Majesty refused this petition, and at length the man was released. Meantime he had become bankrupt. The assignees now instituted proceedings for payment against the Paternelle Company in Paris. The ground on which they based the action was that the judgments of the Swedish courts proved clearly that no murder had been perpetrated, and that the company could not prove that Hofstedt committed suicide, so the insurance remained valid. The company, however, contended first that the judgments of the Swedish courts were not binding in France, and consequently that this acquittal of the man amounted to nothing in the eye of the law. Next, that as Hofstedt had undoubtedly died of poison, it was clear either that he had committed suicide or that he had been poisoned by the man who was to benefit by his death, either of which cases in France rendered an insurance invalid. The civil tribunal, adopting the arguments of the company, rejected the action. A theatrical manager's venture. The English statute of 14 Geo. 3, c. 48 prohibited insurance on lives when the person insuring had no interest in the life, and it prohibited the recovery of a greater sum than the amount or value of the interest of the insured in the life. As Angell remarks, insurance upon lives, as well as upon other events in which the person insured has no interest, not only inevitably tends to introduce a pernicious sort of gambling and speculation, but it is pregnant with serious mischief. Notwithstanding the statute referred to, the criminal annals of England furnish a number of cases of this sort of gambling, even to the extent of murder, in order to recover under a fictitious claim of interest. In this country, as already quoted from Kent, the necessity of an interest in the life insured to support the policy generally prevails. Of the various instances of wanton disregard of an insurable interest which have occurred in the United States, one of the most noteworthy cases is that of Robert Fox, proprietor of a variety theater in Philadelphia. The history of this case shows that in May 1872, Mr. Fox made application to the Penn Mutual Life Insurance Company for a policy of $20,000 on the life of John Clark Lee, which was accepted. The premium was to be paid partly in cash and partly by note. Mr. Fox paid the amount required in cash, $460.86, but never executed or delivered the note for the balance. On or about May 20th, less than a week after date of the policy, the President heard some reports relative to the character and habits of Lee, so entirely at variance with his statements made in the application and in his medical examination, that an investigation was at once ordered, and in a few days it was ascertained that all the reports referred to were entirely trustworthy. The President immediately wrote to Mr. Fox, requesting him to call at the office of the company, which he did. He was informed of the results of the investigation and charged with knowledge of the facts. To this he made no denial. The President then stated to him that the policy would never have been issued had not the truth been concealed and facts misrepresented, and proposed to return him the premium which he had paid and cancel the policy. He refused to take the money and declined to surrender the policy. The President then had prepared and served upon him a formal notice, of which the following is a copy. Philadelphia, June 8, 1872. Robert Fox, Esquire. Dear Sir, having recently learned some facts in connection with the habits of John Clark Lee, upon whose life a policy of insurance was issued by this company, May 15, 1872, number 13,544, for $20,000, in your favor and for your benefit, the knowledge of which facts I have reason to believe was designedly withheld by the assured from the officers of the company, and which, had they been known to the company, would have prevented the issue of the policy. I deem it to be my duty to notify you at once that the company does not consider itself bound by this policy, and desires to cancel and annul the same. I herewith tender to you the amount of cash paid for the premium, the interest on the credit, and the policy fee, in all amounting to $460.86, and request a return of the policy for cancellation. In default of your accepting this view of the matter, I hereby give you notice that the company refuses to consider itself responsible for said policy, or for any liability under the same, and will hereafter refuse to accept any future premium for such insurance. Yours respectfully, Samuel C. Huey, President. The policy was then ruled off the books of the company, and the premium received, $460.86, passed to the personal credit of Mr. Fox, where it stood subject to his order. Of this action Mr. Fox was fully advised. No further steps were taken in the matter, nor was any tender ever made by Mr. Fox of the balance of the premium. Before the next annual premium would have been due, Mr. Lee died, and Mr. Fox demanded the amount of the policy. Payment was refused, and the officers of the company were satisfied that the insured members and the community at large, when acquainted with the facts, would fully justify their course in resisting this claim, based as it was upon a policy obtained originally by fraud and misrepresentation, and formally repudiated by the company in a few days after its issue. Upon the trial of the cause, the plaintiff put in evidence the policy, proved the death of Lee some 9 or 10 months subsequent to the date of the policy, and attempted to prove an insurable interest simply by his own oath. He admitted that he had no note, check, receipt, entry in cash book or check book, or scratch of pen of any kind to substantiate his statement, and that he had no witness to the existence of the indebtedness except himself. The defense set up their reasons for resisting the claim. 1. A cancellation of the policy as already detailed. 2. The total want of insurable interest on the part of Robert Fox in the life of Lee. 3. Gross and fraudulent misrepresentation in the application for the policy and to the medical examiner. And 4. Preparation of Lee for the medical examination by means of Turkish baths, suspended drinking, clean clothing, etc. They put in evidence the application, in which Lee stated, among other things, that he had always been sober and temperate, that he was an advertising agent, that he was in good health, and that he had concealed nothing with which the company ought to be made acquainted, and the certificate of the examiners, to whom Lee had stated that he did not use any spirits, opium, or tobacco, except an occasional cigar. They then, by witnesses, traced Lee step by step for the 10 or 15 years previous to his death, in New York, Washington, and Philadelphia, and showed that he had been an habitual hard drinker, a man of notoriously dissipated habits, a man whose employments had been those of keeping bar and distributing theater bills, and that at the date of the insurance he was a doorkeeper and distributor of playbills at the plaintiff's variety theater. Over 40 witnesses testified in the most positive manner with reference to his intemperate habits, and the proof was of the most convincing character. Witnesses were then produced to prove by Lee's own declarations that he had been attacked by mania apotu, that he was sick and suffering from dissipation, and that prior to effecting the insurance, Mr. Fox had for a short time kept him from liquor, supplying its place with other stimulants, had sent him to the Turkish baths, had given him clean clothing, and thoroughly prepared him for the medical examination, with the character of which he, Fox, was himself perfectly familiar. The court declined to admit this testimony on legal grounds. Employers, associates, his roommate, police officers, all united in describing John Clark Lee as a debauched, dissipated man, but one who, by his naturally good constitution and robust build, could stand more liquor than most of those with whom he associated. The plaintiff attempted to break the force of this evidence by calling attachés of his own and other variety theaters and asking them the simple question, "Did you ever see Lee drunk?" No other question was hazarded, and Fox himself did not dare to go on the stand and testify as to Lee's habits. The facts relative to the cancellation of the policy within a few days of its issue, and with the full knowledge of both Fox and Lee, were not disputed. Medical testimony relative to the condition of the body of Lee after death was submitted by both plaintiff and defendant. Both sides having addressed the jury, the judge delivered his charge, and the case was given to the jury. Few, if any, aside from the plaintiff's immediate friends, imagined a possibility of hesitation in finding for the defendant, and yet the next morning a verdict was rendered for the plaintiff, and the damage assessed at $20,691.25. The company at once applied to have the verdict set aside, and a new trial granted, and were successful in their application. The case, however, was wisely abandoned by Mr. Fox. End of section 6.
Section 7 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Avai in January 2022. Stratagems and Conspiracies to Defraud Life Insurance Companies. An authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Speculative Insurance Part 2. The Pennsylvania Graveyard Epidemic. The Pennsylvania cooperatives, which for a period of several months in 1880 confined their infamous traffic in human life to portions of Lebanon, Berks, Montgomery, York, and Luzerne counties, were emboldened by a mania for speculation to enlarge the area of their operations until public attention at last became aroused to the facilities and incentives they offered for the commission of crime. To give the public definite ideas of the freedom and latitude allowed to the deviltry which these concerns created and fostered, the Philadelphia newspapers published lists and particulars of cases of speculative insurance, furnished by trustworthy reporters and correspondents. Some of them disclose mere purpose to defraud by gambling on the lives of consumptives, or octogenarians, or tramps, or paupers. Others reveal deliberate conspiracy to hasten their claim to maturity by murder. An instance of the former was that of Mrs. Emma Reinhardt in Amity Township, Berks County, while staying in her father's house. She had been living with her husband near Phoenixville for some time, but when in the last stage of consumption she returned to her father's home and there died. It was then learned that her life had been insured to the amount of $26,000 in various cooperatives, the policies being mostly in favor of one Samuel Shirey, a first cousin of the woman, a person who had no more insurable interest in her life than the man in the moon. She was passed by the examiners, who were either quacks of the lowest grade or despicable scoundrels, and accepted as a sound risk. Another example was that of Daniel L. Wagner of Burnville, 15 miles from Reading. This man, a farmer, 71 years of age, had been debilitated by chronic diarrhea, for which he had been under treatment for months, and while lying insensible under an apoplectic seizure, a rascally representative of some of the cooperatives tempted his son into consent to the issue of certificates upon the life of the dying man, upon promise of a handsome divvy. After the latter's death, it was discovered that some of the certificates had been altered, hundreds being changed to thousands, until they called for an aggregate of £15,000. Mrs. Mary Fry of Donnelly's Mills, Perry County, Pennsylvania, aged 63, died November 10, 1888, of disease of the heart and general dropsy. She had been confined to her bed during the last year of her life, and her suffering was so great as to attract the sympathy of the neighborhood. Within 5 months of her death, her son, Samuel S. Fry, without her knowledge and consent, obtained certificates of insurance on her life to the amount of $27,500 in 12 assessment companies. Presentation of the claims led to investigation and subsequent discovery of the fraud. Fry was indicted for perjury in making the affidavits accompanying the proofs of loss. The grand jury ignored the bill on the assumption that there was no legal perjury in making out the proofs of death, whatever moral perjury there might have been in the transaction. The scoundrelly son, who was thus anxious to gamble upon the lingering remnant of his mother's life as she lay upon her death-bed, was assisted in his villainy by the local physician, the local preacher, and other village magnates. It was a sad story of utter insensibility to the sacredness of family ties, not only on the part of men fitted by nature and training for the penitentiary, but among a class to whom society had a right to look for better example. An illustration of the darker side of the picture is furnished in the case of Martin Callahan, a poor miner in the neighborhood of Scranton. He was 70 years of age, lived in great poverty with his family, and 9 days after he was insured for $1,000, he was a corpse. Suspicion led to exhumation of the body, and a post-mortem examination gave evidence of a blow upon the head by a blunt instrument sufficient to cause death, coupled with signs of a fierce struggle. More brutal and more tragic was the murder of Joseph Raber, a feeble old man who lived among the wood choppers and the charcoal burners of the primitive forests of Lebanon County. Half a dozen of his neighbors, ruffianly and semi-civilized wretches, after selecting him as a victim, effected an insurance of $30,000 through an innkeeper named Brandt. On completing their arrangements, they decoyed him to a plank over a small and narrow stream not more than 20 inches deep, tripped him over into the water, and then jumped upon him and pressed him down until he was drowned. Their names were Henry Wise, Israel Brandt, Isaiah Hummel, Charles Drews, Frank Steckler, and George Zeckman. The crime was discovered, and the assassins were brought to trial and convicted, the testimony for the prosecution being sustained by the confession of Drews and Steckler. All of them were executed, except Zeckman. The disclosures of this scandalous roguery showed that in some cases paupers were insured to the amount of $60,000 or $80,000, that drunkards were insured for large sums, and then supplied with rum enough to kill them, that dying men and women were passed as good risks by collusive agents and examiners, and the policies were put upon the market by desperate gamblers anxious to realize money before the call upon the undertaker. In brief, that the worst forms of wagering in the history of gambling insurance were carried to an extent never before attempted. Whenever the doomed wretches lingered for an inconvenient length of time, they were in danger of assassination by the impatient vampires. As no insurable interest was required, no one's life was safe. The fact that it was possible to perpetrate such frauds with temporary success and impunity is surprising enough, but the other fact that under such a system it was not only not for the interest of the officers of the companies to ferret out such villainy and crush it, but that it might be made to increase their own emoluments by adding to the expense funds of the companies, was yet more startling. That thousands of members might be made to contribute to the payment of large policies, only a small portion of which went to the family of the deceased, while the lion's share went to unprincipled speculators, showed the rottenness of the system itself. Conversations, like the following, at Pottstown, were frequently reported. "Do you want to put yourself on your feet?" "I'd like to, if I only knew how." "I'll tell you. There's old man Richardson. He'll die soon. He can't last 3 months anyhow. Now, if you want a $2,000 policy on him, I'll let you have it. Make up your mind soon, for the old man is as likely to go off in a couple of days as in 3 months. And letters like this are still preserved as memorials of this dark period. Dear blank, I have just got old Mr. and Mrs. Blank's insured. He is 74 and she is 73. Will you join me in paying assessments? If you will, write me immediately, and I will get the assessments fixed. The old lady will never go out of doors again." These transactions were usually traced directly to the agents and solicitors. There is no question as to the blameworthiness of a large number of this class. The hideous revelations that were made fastened more especially upon them the stigma of playing with this sort of loaded dice. Nevertheless, these miscreants were indirectly, if not directly, assisted and reinforced by the loose practices of the Home Office, its easy acquiescence and uninquisitiveness, and its stubborn disregard of the interest required to sustain a contract. If the officers and directors were not directly chargeable, so far as known, with consent or connivance in this criminal traffic, they were guilty of a form of thievery which ought to have condemned them to penal servitude. By levying excessive and fraudulent assessments, they were enabled to coin money to an extent which, in some cases, is almost incredible. Speaking of the rings which grew rich in this way, a Lebanon newspaper correspondent said, "Directorship in a company of this character would not be supposed to be much more than an honorary position, but it is, in this neighborhood at least. The Home Mutual Life Association, one of the companies which has been operated upon by the Reading and Pottstown ringsters, has its head offices in this place. It does not publish a list of its directors, and there are hundreds of its policyholders who know no more concerning the identity of the parties who are to sit in judgment upon their risks when they have given up the ghost than they know about the man in the moon. Such individuals may now learn, for the first time, that one of the directors is Joseph Krause, who a year and a half ago purchased his seat from D.J. Thompson for $1,500. That another is E.D. Kroll, who bought P.F. Macaulay's place this past summer for $2,500 or thereabouts, and that another is Grant Whiteman, who put up a similar sum when C.H. Killinger ceased to be a director not many months ago. Not much more than a year before, Killinger had bought his seat for from $1,200 to $1,500 from Ezekiel Wright, the present actuary of this corporation. It would be interesting to learn the circumstances which caused this position to double its value within the period specified. But you can't buy a seat in the Union Beneficial Mutual Aid Society, which also has its headquarters here. Reason why? Seats are not for sale. The last transaction of the kind which can be traced in connection with this corporation occurred in 1876, when Ezekiel Wright, before mentioned, vacated his seat in favor of J.B. Hirsch for a consideration which, so far as folks can remember after this lapse of time, was between $3,000 and $5,000. Today, no director, it is said, would give up his seat for double the latter amount. How much is a seat worth anyhow? I asked a responsible resident today, and the answer came, "Put it at $15,000 and you will have it near the mark." The UBMAS is what you would call a close corporation. Few of its directors die and none resign. They elect all the officers, save actuary, medical examiner, and solicitor, from among themselves, and they fill all vacancies caused by death. Hence, the board is self-perpetual. But success sometimes emboldens gamesters to more desperate ventures. The greed of these Pennsylvania raiders turned their attention to the accumulated reserves of the regular life companies. A noteworthy example occurred in Selinsgrove, Snyder County, where the swindlers selected a cautious and conservative company, the Mutual Benefit Life of Newark, New Jersey, as presenting a larger field of operation, financially, for their traffic in human life. 2 applications were made to the company for policies of $10,000 each upon the lives of 2 residents of Snyder County. The applications were regular, disclosing no disqualifications, and the blanks were filled out by the agent and medical examiners. The company in due time passed upon the risks, wrote the policies, issued them, and received the premiums on account of them. A short time afterwards, suspicion was aroused, and the company sent, according to its custom, an inspector to investigate the matter. Imagine his surprise on finding that the persons insured were not only not the sound, healthy risks represented, but each of them of the very worst sort, with one foot already in the grave and the other trembling on its verge. One of the policies was found to be upon the life of a man in the last stages of consumption, and the other upon that of a party suffering from an aggravated type of kidney disease. Both were certain to die speedily, and the arrangements for the division of the $20,000 of which the company was to be defrauded were all perfected. The alarming feature of the discovery was that the gamblers were gentlemen of high repute and physicians of good standing in the company. The astonishment and dismay that followed led to extended investigation. Case after case was ferreted out. In some localities it was found that a fierce desire for this form of speculative insurance upon the aged and dying had invaded all orders and conditions of society, until the infection rendered the public dumb to the enormity and the baneful and corrupting influence of a scheme in furtherance of which all classes, merchants, mechanics, farmers, professional men, held wagering policies, and frauds of the most outrageous character were conducted and encouraged as warrantable matter of speculation. The authorities were strangely tardy in responding to a growing and earnest demand for suppression. More than 200 of the death-rattle cooperatives, as they were called, had actively organized for this cold-blooded and disgraceful traffic in human blood before the Insurance Commissioner of the State, the Attorney General, and the courts commenced the work of extermination. Retributive blows finally drove the ghouls into exile, but with characteristic defiance they resumed their mercenary operations in adjacent states. A chronicler of the period remarked that the professional confidence operators, bunco men, sawdust swindlers, shovers of the queer, and the fraternity of adventurers generally appeared to have discovered that the assessment insurance game paid better than any other at the time, and to have gone, all over the country, into the cooperative business. They were most offensively demonstrative in Maryland, Ohio, and Indiana, and in Fall River and New Bedford, Massachusetts. But sooner or later they were confronted with legislation outlawing them and imposing severe penalties, with interference of the post office authorities with their misuse of the mails, and with checkmating by courts of justice. End of section 7. Section 8 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Avai in January 2022. Stratagems and Conspiracies to Defraud Life Insurance Companies, an authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Speculative Insurance, Part 3, The Pennsylvania Graveyard Epidemic, continued. After a lengthened disappearance from public view, those who thought that the infamous scheme had disappeared forever were surprised to learn that there was an outbreak of the infection in North Carolina, which dated back several years. From the report of the preliminary trial of the Tar Heel conspirators at Beaufort, it appears that the prisoners had conducted their graveyard operations successfully, year after year, without intervention of local magistrates or county courts. The defendants in the case were 13 in number, of whom 7 were white men and 6 were Negroes. When the swindlers commenced their fraudulent operations, the conditions for successful adventure were favorable, but, as often happens, success encouraged them to widen the range of development, and thus to spread the net for their eventual capture and arraignment. The companies chiefly interested were such assessment associations as the Mutual Reserve Fund, the National of Hartford, the Massachusetts Benefit, the Fort Wayne of Indiana, and the Old Peoples of Elkhart. It appears that attempts were also made to defraud the life insurance clearing company of St. Paul, and, at one time, even the Michigan Mutual Life. The ringleader was a desperado named C.R. Hassel, who acted as an agent for some of the cooperatives named, and in that capacity was enabled to facilitate the devilish work of the gang. When individual cases, one after another, were brought to light, and newspaper accounts of them were published, it looked as if some very respectable people were involved in the infamous transactions. It turned out, however, that they were a low pack, as vile and vulgar as they were villainous, as despicable and debased as they were murderous. Hassel, who had been a horse trader, was, it was said, a man of such smooth presence, self-control, aptitude of speech and argument, as to deceive the very elect. What his associates lacked in his intellectual gifts was made up in craft and cunning. The cases reported were so numerous, so varied in character, and so ingenious in plot and execution, that if they were detailed at length, they would furnish material for the most interesting chapter in the history of graveyard insurance. It seems incredible that such a multitude of paupers could be insured for large sums, that so many Negroes could be passed off as whites, that intelligent invalids and cripples could be insured and used for speculative purposes without knowledge or suspicion, and that the plainest requirements of insurable interest could be so long disregarded and defied. The discovery of these frauds was made in October 1894. Colonel John W. Hinsdale, a leading attorney of Raleigh, was employed by the companies to conduct the prosecution. He engaged a corps of detectives to unearth the roguery of the gamblers. They, in turn, enlisted on their side the machinery of intimidation and malediction. One of their counsel was editor of a newspaper, and its columns were filled with coarse abuse of Colonel Hinsdale. Undeterred by the difficulties and obstacles which were constantly thrown in his pathway, the self-reliant attorney pressed on until success finally crowned his efforts. In August 1895, the conspirators were bound over to court after a preliminary examination by a magistrate. At the October term of the Carteret County Court, 11 bills were found against 12 of the conspirators, and no one bill including them all. 2 of the cases came to trial, but although the evidence was clear and convincing, the jury brought in a verdict of acquittal. Thereupon the judge, who remarked that he was not responsible for such a miscarriage of justice, removed the other cases to the Trenton Court, in Jones County, away from local influences and prejudices, and the governor of North Carolina called a special term of the court for the trials. These lasted 9 days, and all of the defendants were convicted except those who pleaded guilty and those who were not prosecuted in order that they might testify for the state. Among those convicted were the defendants who had been acquitted on the charges tried in the Carteret County Court. Aside from C.R. Hassel, the chief operators were Levi T. Noe, Selden D. Delamar, and J.C. Delamar. They started an insurance agency at Beaufort about 18 months before the trial, and employed solicitors to look up very old or very sick people upon whose brief tenure the speculators might rely for speedy maturing of their ventures. The cat's paws were taken from the ignorant classes, who were easily duped by the sharpers. Dr. T. B. Delamar, the medical examiner, being a member of the gang, recommended the lame, the halt, and the blind for acceptance as first-class risks. No matter how hopeless and beyond remedy, all cases were passed as desirable cases for insurance, without the slightest suggestion of disease or injury. By way of illustration of the character of the testimony for the state that was offered on the witness stand, we copy the following statements of Mr. J.C. Davis, a citizen of Beaufort and former Register of Deeds for Carteret County. I know Shepard Davis. He was raised on Davis Shore, but lives in Beaufort now and has lived there since the war. I think he is in the neighborhood of 80 years old. The application for $4,000 insurance states that he is 56 years old. I am acquainted with Perry Chadwick. He was the son of a Negro in our family. I was told that he had been in the penitentiary. The last time I saw him in Beaufort was perhaps a year and a half ago. He was in a very low state of health. His appearance as to health was very thin. He was a beggar. He was very weak. That is the whole of it. I heard him cough. He was a sickly-looking object. I thought he had consumption. I know Melissa Guthrie, saw her here Saturday. She is in a very low state of health. I have looked upon her as a sickly girl all her life. I have known Samuel Windsor ever since I was a boy. He is in my best judgment 75 or 80 years old. I have known Mrs. Sarah M. Gabriel all her life. I have not seen her in 2½ years. She was at that time suffering with rheumatism. I think she had long been suffering with that trouble. I called to see her, and she came in her parlor. I looked upon her then as a woman in bad health. She did not tell me she had rheumatism. She is living yet. I know Maria Hamilton. In my judgment, she is in the neighborhood of 65 or 70 years. I have known William Rice ever since he has been in Beaufort. In 1894, time of application for insurance in Massachusetts Benefit Company, he was a drinking man, drank excessively. He was very dissipated. I do not know of my own knowledge that he used any other stimulant than whiskey. He had been a dissipated man for a number of years. He was not able to work. He is a white man. His dissipation ran back 4 or 5 years. The application for insurance stated that Rice had used liquors freely 5 years before, but not since that time, and that he did not use narcotics. Dr. Delamar stated in his medical examination that he considers the risk in every way a first-class one. The agents stated that he did not use liquors, though he had used them freely some years ago, that he was in every way a proper subject for insurance, and they therefore unqualifiedly recommended the risk. Dennis Jones corroborated the testimony as to the age and condition of the health of Shepard Davis, Perry Chadwick, Samuel Windsor, Maria Hamilton, William Rice, Alfred Pigott, whose lives were insured in amounts varying from $2,000 to $6,000. The cases upon which convictions were obtained were Jacob C. Delamar and Selden D. Delamar, forgery. Levi T. Noe and William Fisher, forgery. Selden D. Delamar, forgery. C. R. Hassel and T. B. Delamar, false pretense. C. R. Hassel, Albert Wigfall, Silas Blount, and David Parker, false pretense. C. R. Hassel and S. W. Perkins, conspiracy. C. R. Hassel, David Parker, Silas Blount, Albert Wigfall, and T. B. Delamar, conspiracy. W. H. Turner, Stephen B. Turner, Levi T. Noe, Selden D. Delamar, and T. B. Delamar, conspiracy. In pronouncing judgment upon the conspirators, Judge Graham said, "If the evidence in these cases be true, the most stupendous crime ever committed in North Carolina has been unearthed. I suppose there is nobody that had any conception of the degree to which this rascality had gone. I can see how people could be drawn into this nefarious business of procuring or buying these policies upon these dying people, and people who are likely to die, but few could be innocent. In order to procure these policies, forgery, false pretenses, and conspiracy were all committed. In the criminal annals of our whole country, a more gigantic conspiracy than this. Here we have the greatest crimes known except rape, murder, arson, and burglary. It seems to have been going on for years, and it has drawn in a great many unsuspecting people, and these, in order to make money, either by the commissions or out of the policies, have committed these crimes. There has been enough forgery proven against Dr. T.B. Delamar to send him to the penitentiary for 150 years, if all the cases for forgery were prosecuted against him and the extreme punishment inflicted on him in each case. I regret circumstances are such that these men have not all been convicted of crimes for which I could impose punishment adequate to the offences proven, many cases of forgery and false pretense being proven though not charged. But the crime of conspiracy is a misdemeanor and punishable only by imprisonment in jail and by a fine. The crimes of false pretenses and forgery are both felonies and can be punished by imprisonment in the penitentiary, and though I regret the same punishment cannot be meted out to all the defendants alike in these cases, still, when this conspiracy is proven, when false pretenses are proven, when forgery is proven to have been committed, then I must discharge my duty in each one of the cases under the law of North Carolina, as I find it laid down in our statute books. It has been proven that these men, Levi T. Noe, J.C. Delamar, and Selden D. Delamar, were agents doing this fraudulent business, that Dr. T.B. Delamar was their medical examiner, that David Parker and William Fisher were their henchmen, and went out and got the names of those people who were in the last stages of disease, as Parker said, would die soon, in order, as one of the witnesses said, they might make a little quick money. In the case of C.R. Hassel, if the evidence is to be believed, he is the arch-conspirator of the whole lot. He seems to have been engaged in this business for years, and his success for a time seems to have induced others to go into it. Then Noe took it up, and after pursuing it for a year, he takes the Delamars in with him. They are all induced by the success with which he has met to engage in his disreputable business. Then Bill Fisher comes in and forged the name of Florence Chadwick and others, and David Parker also appears as an agent and one of the conspirators. Their particular conspiracy was to defraud in probably 25 cases by the use of the names of a large number of people who were in the last stages of disease, many of whom were produced before the jury by the state. As much as I sympathize with the families of these defendants in the misfortunes that have overtaken them, as much as I regret the disgrace that will have to attach to them the balance of their days, and as hard as it is for me to pronounce sentences in cases of this kind, for this is the hardest part of a judge's life, I am bound to do my duty. The judgment of the court is that C.R. Hassel be confined in the state penitentiary at hard labor 7 years, that Bill Fisher be confined in the penitentiary at hard labor 5 years, that Selden D. Delamar, T.B. Delamar, J.C. Delamar, and Levi T. Noe be confined in the common jail of Craven County for a term of 2 years, and pay a fine of $300 each, that being the limit of imprisonment allowed by law. End of section 8.
Section 9 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Anna Goss. Stratagems and Conspiracies to Defraud Life Insurance Companies, an authentic record of remarkable cases by John B. Lewis and Charles C. Baumbach. Speculative Life Insurance, Part 4. The Belfast Scandal. In the early part of the year 1888, the London office of the Equitable Life Assurance Society of the United States received intimations of crookedness in the conduct of the agency in Belfast, which called for prompt interference and stern correction. Thereupon, the then secretary, now manager of the London branch, Mr. Alexander Munkittrick, proceeded to Belfast, and with the aid of personal friends and acquaintances, succeeded in unmasking a plot to defraud the Equitable out of many £1,000s. The conspirators were Chestnut Smythe, the general agent, James Spears Orr, a sub-agent, Dr. James Cammack Smythe, medical examiner and brother of Chestnut, Robert Dunlop, Hugh Knox Matthews, and William Press, respectable citizens of Belfast. Their plan of procedure was modeled on the Pennsylvania graveyard system, with all of its recklessness and as little pretense of insurable interest. To that system they tacked improvements of their own, which were correspondingly dangerous to society. They were men of excellent standing in social and business life, in religious association and club connection. They were altogether beyond suspicion of the practice of insuring other people without their knowledge or consent. They were well equipped for a successful campaign of villainy, and they had a large and liberal company on the other side of the Atlantic to deal with, instead of depending on the fluctuations of the hat-passing style of collection. Their plans were so well contrived that if a cat's paw known as Black Joe, a Negro who had been insured as an Irishman, had not shuffled off his coil prematurely and paved the way to detection, they would eventually have swindled the Equitable out of a large amount, the policies representing which were recovered. Recovery was easy, because the policies were void. They had been obtained through forged signatures to the proposals and forged medical certificates. Several respectable citizens had been insured in this way without their knowledge, and the policies were assigned by the conspirators to themselves as beneficiaries. In other cases, selected from the worthless classes, consent was obtained and assignment made for a trifling consideration. Arrest followed in the first week of May, with a lengthy preliminary hearing in the Recorder's Court before Colonel the Honorable W. F. Forbes, R.M. There was a great deal of discreditable sparring between the counsel for the prosecution and the counsel for the accused. Of the latter, the counsel for Dunlop, Mr. O'Shaughnessy, was conspicuously vicious and vulgar in his abuse of the Equitable and its management. How much of an impression was made on Colonel Forbes by this unwarrantable form of digression was seen when he expressed his readiness to remand the prisoners for trial. The bail for Dunlop, the wealthy grocer and town councillor, was fixed at £12,000, while in the other cases it was comparatively light, and Dr. Smythe was allowed to go on his own recognizance. To ensure fairness and freedom from local partiality and prejudice, the trial was transferred to the Wicklow Assizes, and fixed for the closing days of July. The 6 prisoners, to quote the language of the indictment of the grand jury, did wickedly, designedly, and feloniously combine, conspire, confederate, and agree together, by divers false pretenses and subtle means and devices, to obtain and acquire to themselves from the Equitable Life Assurance Society of the United States large sums of money against the peace and dignity of Our Lady the Queen. The prosecution of these scoundrels, originally in the hands of the counsel for the Equitable, had been assumed exclusively by the counsel for the Crown, and the Attorney General was ready to proceed with the case with a large array of witnesses, who had been brought from distant points at considerable expense and great inconvenience. Those who were familiar with the testimony to be offered confidently expected speedy conviction and commensurate punishment. To the surprise of all, the trial collapsed through discovery of an informality. The counsel for the Traversers challenged the array of special jurors under the Crimes Act on the ground that the panel had not been properly summoned in rotation of the names on the jury book as provided by the Act. It appeared that the sheriff, in preparing the panel, had summoned 48 special jurors for the trial of civil cases only, and had also summoned a panel of 200 jurors under the Criminal Law Amendment Act for the trial of the prisoners. After a day's skirmishing between opposing counsel, Justice O'Brien expressed the opinion that the panel had been irregularly and illegally summoned, and upon the request of the Attorney General he made an order quashing the panel, directing the sheriff to return a new panel pursuant to the statute, and adjourning the court to August 16th. Thereupon, a special juror made a strong appeal to the justice against the date selected, on the ground that it would be the middle of the harvest season, and enforced absence would cause very great loss. His lordship sympathetically assented, and the date of adjournment was eventually fixed for the 15th of October. It was a matter for profound regret that after the machinery of the law had been set in motion with such care and precision, it was abruptly stopped by one of those quiddities which, however sufficient and satisfying to the legal mind, provoke impatience on the part of those who cannot reconcile the uncouth forms and the antiquated adjuncts which cling like mold to modern jurisprudence, with verities which are obvious, and with even-handed justice whose demands are unquestionable. In view of the extent of the disclosures of the Belfast crimes, and of the urgent need of making in a short, sharp, and a decisive way a memorable example of such transgression, the sacrifice of substance to shadow was all the more vexatious and disappointing when contrasted with the usual promptitude in disposing of British criminal cases. The trial of the conspirators at the Wicklow Assizes before Justice O'Brien commenced on the 20th of October, 1888, and terminated on the 27th. The justice, who appears to have been of a humorous turn, of which he gave several indications during the proceedings, remarked, while Mr. Munkittrick was under cross-examination, "We have had a very large experience of American insurance in this country, and they have had a very large experience of us." In this little off-hand pleasantry there was probably more length and breadth than his lordship was aware of. Shakespeare was right when he said, "More water glideth by the mill than wots the miller of." The first two conspirators placed on trial were Robert Dunlop and James Spiers Orr. They were indicted on the charge of feloniously altering a certificate of the death of Joseph M. Wilson, otherwise known as Black Joe, by inserting a false entry representing the duration of Wilson's illness as 1 month instead of 2 months. This colored tramp was insured as an Irishman for £2,000, annual premium £96, 16 shillings, 8 pence, for Dunlop's benefit, without insurable interest, November 2nd, 1887. Dr. Smythe, brother of Chestnut Smythe, and one of the conspirators, pronounced a mere wreck a first-class life. Wilson died December 20th of heart disease and dropsy, a complication of maladies of long standing. Fearing exposure through such a suspiciously sudden death, the conspirators changed the certificate accompanying the proofs of death so as to bring the period of illness within the period of insurance. Orr, who was the instrument of Dunlop in the execution of his rascally designs, was the ready and capable forger. Dunlop's solicitor, Mr. Walker, tried to make it appear that he was the dupe and tool of Orr, who was engaged in fraudulent transactions against the company of which he was an agent in the morning, and in lecturing on temperance in the evening. It was easily shown, however, that the impecunious Orr, who had a large family, was in debt to the rich grocer, and to that extent in his power, and obliged to serve him, and to facilitate his schemes for further enrichment. If he deceived Dunlop at all, it was in the single statement that insurable interest is not required by American law. Sergeant Hemphill, for the Crown, said, "The action of both prisoners in the case went to prove their moral depravity, for they both joined in the same crime, and now each one sought to throw the whole responsibility of the violation of the law on the other. He believed it would require golden scales to weigh the comparative degree of depravity and immorality between the two prisoners." Orr made a full confession of his guilty transactions through his solicitor, Mr. Young. He pleaded guilty to a charge of misdemeanor only, and not to the more serious charge of felony. Referring to these admissions at the close of a lengthy charge to the jury, Mr. Justice O'Brien said, first addressing himself to Orr, and afterward to Dunlop, "It is undoubtedly a very great offence against the law, and not merely an offence against the law, but an offence committed by you in pursuance of and in aid of a vast conspiracy of fraud, and it is further a violation of the duty that you owed to your employers, as well as a duty you owed to the law of the country. I still recognize in your station and in your position as an humble man that you were to some extent dependent for pecuniary aid upon Robert Dunlop, and I recognize some ground of distinction between the cases of each of you. And you, Robert Dunlop, if you were cast down from a high station, from the reputation of an honest man of great wealth, I am told even colossal wealth, it was by your own act in violating the law. There was no other conclusion for the jury to come to than that you were guilty, and you were in the higher station and of greater wealth, and I believe you to be the more guilty. Your sentence is 9 months' imprisonment with hard labor, and you, Spiers Orr, are sentenced to 6 months' imprisonment with hard labor." The extreme lightness of these sentences was in broad contrast with the measure of expectation. Those who were more or less familiar with the testimony to be given, and the confessions to be made, expected a term of at least 15 years imprisonment as the appropriate penalty. The judge himself, in speaking of the uttering of the false statement in the certificate, in the course of his extended review of the evidence before the jury, said, "It is hardly necessary to state to you that the person who does any criminal or other act by the hand of another does it himself, and it makes no kind of difference in the legal contemplation whether the person who altered the certificate was Orr or Dunlop, if Dunlop was a party to it. The offence charged is one of great gravity, for though you might consider that the alteration of a document might be trifling, still you must have regard to the circumstance that the legislature, in enacting the law, determined that under certain circumstances the person convicted of a violation might be sentenced to penal servitude for life." In an editorial comment upon the sentence, a leading insurance journal of England, The Review, said, "When the tones of his lordship's voice died away, a look of astonishment, bordering on incredulity, crept into every face, and none appeared more surprised than the jury themselves. The lightness of the sentences became the subject of general remark. Certainly, they were altogether different from what was expected. It is difficult to say what view Mr. Justice O'Brien took of the affair. Probably, he thought, for men occupying the positions which the prisoners held, 9 months and 6 months respectively of picking oakum, the plank bed, and all the other accessories of hard labor in a county jail, besides the disgrace of the thing, he was making the punishment fit the crime in every respect. Be that as it may, public opinion is altogether at variance with his lordship's decision." The Dublin Daily Express, which echoed the general feeling, said, "We believe that the public, who have read the accounts of the frauds, and reflected upon the circumstances and the position of the prisoners, will be disposed to think that justice has been very inadequately vindicated by sentences which fall so far short of what the law affords for such criminality." Other Irish and English journals showed a consensus of opinion as to an inadequacy of punishment totally irreconcilable with the facts and the demands of justice. An effort was made by Dunlop's counsel, Mr. O'Shaughnessy, to entrap a witness into severe reflection upon the management of the equitable life, and to convert into the appearance of settled conviction a hastily formed conclusion as to the home management, which was corrected upon proper representation of the facts. The judge promptly and vigorously rebuked the offender. Said he, "I cannot allow the company to be attacked. The prosecution is being conducted by the Attorney General for the Crown, and not for the insurance company. It was not the equitable that was on trial, it was its assailants, its worst enemies, a gang of thieves who, if they had been undetected in their audacious rascality, would have plundered its treasury of a large amount of money." On the 24th, the case of Hugh Knox Matthews and William Press, in which Chestnut Smythe was implicated, was called up. At the time first set for the trial, nearly 3 months before, it was known to a few persons that Smythe was ready to turn informer, and, to save his own neck, reveal the story of the drama in which he enacted the part of the big villain. On the present occasion it was generally understood that he would be accepted as Queen's evidence. After a lengthy and detailed recital of the tricks and devices to which he and the gang combined with him resorted in order, as the indictment said, to obtain from the Equitable Life Assurance Society of the United States large sums of money, the property of said society, the following colloquy occurred on cross-examination. Q. Were you secretary of a religious association? A. I was connected with various religious associations. Q. And I suppose you are trained in these societies in religion, virtue, and morality. A. I suppose so. Q. Were you secretary of a religious society? A. Now don't be smiling, there is nothing to smile about. I was secretary of the Congregational Association, etc. The informer is always an object of distrust and disgust, and Smythe's case was no exception. Matthews and Press were condemned to 9 months' imprisonment with hard labor. While they, with Dunlop, Orr, and Dr. Smythe, were breaking stone in the prison yard at Belfast, Chestnut Smythe, the biggest rascal of the gang, secured his liberty by turning Queen's evidence and escaping to America. People in general, and the press in particular, look at passing events through lenses of differing refractive power. Here is the Dublin Freeman's Journal, for instance, which looked through political spectacles at Smythe's irregularities. It said, The next sensational pamphlet may well be one bearing the title Unionists and Crime. Mr. Chestnut Smythe, the gentleman from Belfast who confessed on Tuesday in the witness box at Wicklow as an informer against his Confederates, that he had committed forgery upon forgery, that he had reduced forgery to a system, that he had forged Mr. Finlay McCants's name and Mr. Matthew's name, and that in fact he did not know how many forgeries he had been guilty of, and all for the purposes of fraud, was the appointed secretary of the Liberal Unionist Association, under whose auspices the Marquis of Hartington, Mr. Chamberlain, and other lights of the Unionist party have been invited, received, entertained, and feted in loyal Belfast. In fact, Mr. Chestnut Smythe was the Liberal Unionists' right-hand man. On the other hand, the Belfast Evening Telegraph dealt with the wretched business from the viewpoint of the moralist. Remembering Chestnut Smythe's prominence in the work of the Young Men's Christian Association, and his high standing in the church and the Sunday school, it thus pronounced judgment. The disclosures he made, as far as he himself is concerned, and we deal only with those, are sorrowful in the extreme. He confessed to wholesale forgery. He had been a Christian professor. His evidence merely shows how mere profession is to be distrusted, and how solid worth should be sought rather than the mere tinsel of hypocrisy. We speak of this unfortunate gentleman more in sorrow than in anger. He was beset by many temptations. Suddenly thrown from a sphere in which he had the protection of Christian friends into the maelstrom of the world, of whose treacherous waters he knew nothing, he fell an easy prey. His confessions are as painful as they could well nigh be, and it is to be hoped that he is an exception to those who have received so excellent a training and yet are failing in the moral sense which judges between right and wrong. Among the citizens of Belfast who were insured by the rascals on a forged proposal and forged medical certificate, without consent or knowledge, was Mr. Finlay McCants, manager of the Ulster Spinning Company. Mr. McCants was one of the numerous witnesses on the stand, and he testified that he knew Matthews slightly, but did not know Press, that neither had any insurable interest in his life, and that he had no knowledge of a policy for £5,000 taken out on his life until these proceedings commenced. When his testimony closed, he turned to the justice and said, "I would like to learn from your lordship on what ground Mr. Henderson holds on to a policy on my life which was obtained by fraud, and which gives him an interest in my death." This gave his honour an opportunity for one of his jocosities. He replied, "Mr. McCants, when you have joined the majority, which I hope will not be for a distant time from the present, I will then be in position to answer your question, and you will then be able to understand all about it." The judge's charge to the jury in the case of Matthews and Press was lengthy, about 3 hours, but, as Horace Greeley would have said, it is mighty interesting reading. It was enlivened by flashes of characteristic jocularity. For instance, in speaking of the great activity in the life insurance work, he said, "The flush of the insurance business in the year 1887 in the town of Belfast almost bore some analogy to the spreading of scarlatina." And a little further on he said, "These transatlantic, American, companies appeared to regard Ireland as a kind of Golconda mine, and they seemed sometimes to go out to gather wool and come back shorn." In reviewing the cases selected by the gamblers for speedy realization on their investment, such as that of Coulson, suffering from attacks of delirium tremens as the result of excessive drinking, together with ulcerated legs, or that of Jackson, with threatening consumption and other maladies, the judge vigorously denounced the offense with which the prisoners were charged. He characterized the act on the part of one or more individuals of presenting a bad life to an insurance company as flagrantly dishonest and criminal. He had his own opinion, and doubtless the jury had theirs, as to the conduct and the moral condition of the men who could coolly watch a life on which they were speculating, rapidly descending by vice, like Coulson, into a dishonorable grave. On this last point, Sergeant Hemphill, counsel for the Crown, had said in his address to the jury, "A great deal has been said about insurable interest. What did the jury suppose Matthews or Press embarked in this traffic in insurance for? Why did they not stick to their ordinary legitimate business pursuits? Could they believe that these men were so innocent as not to know they had no right to gamble in human life? An Act of Parliament was passed over 100 years ago in England to put a stop to the terrible results ensuing from this form of gambling, and the law was subsequently extended to this country, Ireland. It was a horrible reflection, no matter in what light the transactions in Belfast appeared. It was a horrible idea to be sitting at the same table with a man on whose life they had an insurance in their pockets, watching with interest every bit he ate and every sup he drank, to see how far it might shorten the term of his existence. The last case to be disposed of was that of the medical examiner Dr. James Cammack Smythe. The evidence of his active participation in the conspiracy was brief but conclusive. In the course of a comprehensive summary, Justice O'Brien, turning to the prisoner, used the following forcible language. If you had not been guilty of this offence, no other person could have been found guilty. The crime could not have been committed without your concurrence. You were placed in a position of great trust by the insurance company. You were expected to perform your duty, to represent truth and right. You betrayed your trust, and you are morally responsible for the fact that 4 persons are now imprisoned under the degradation and punishment of a sentence, which, if you had done your duty, would have been averted. Dr. Smythe was sentenced to 6 months' imprisonment, a small matter in itself compared with his professional and social ruin. The following extract from the Dublin Daily Express will serve as a specimen of the newspaper comments of the time, October 1888. After a trial which occupied the court for 4 days, the prisoners, Matthews and Press, who were indicted for conspiracy to defraud the Equitable Insurance Company, were found guilty and sentenced to penal servitude, it may be thought, or at least 2 years' imprisonment. No, but to 9 months' imprisonment with hard labor. We venture to say that the punishment will excite as much astonishment from its lightness as did the frauds themselves by their enormity. Many and inscrutable are the mysteries of the law, but its proverbial uncertainty is surpassed in this sentence. The frauds which have been revealed in this case were not absolutely novel in their main features, but their magnitude and turpitude were greater than any which have been brought to light within living memory in Ireland, and, having regard to the position of the swindlers who were engaged in them, and the circumstances under which they were committed, we think it would be hard to find a parallel for them. It was not the case of a set of desperate adventurers who had to live by their wits, and were under the pressure of want without any regular employment or means of earning an honest living. The prisoners who were convicted on Saturday occupied respectable positions as traders in Belfast, and one of them is possessed of considerable property. Smythe and Orr, as well as Matthews and Press, set to work to obtain every bad life which could be found in the city in order to insure them. A wretched oysterman was insured for £2,000. A clerk of the markets, who was dismissed for intemperate habits and neglect of duty, was insured for £5,000, and Matthews hoped to bring the insurance up to £20,000. A respectable merchant of the city happened to take ill and had to go abroad. This was a chance for the swindlers, and accordingly an application and medical certificate were forged and a policy for £5,000 obtained in his name. But when he returned in good health, the enterprising Matthews broke off the bargain. It would not do to insure such a life, and the policy was transferred to another. Some of the insured persons died in a short time, but the frauds having been discovered, no claim was made by the holders of the policies, and, on the contrary, policies to the amount of £16,000, on which over £500 had been paid as premiums, were surrendered without any compensation. So widely ramified and heinous a system of fraud has not been discovered for many years. The public were shocked at the revelations and expected that after an imposing trial at the special assizes, which seemed to indicate that the Crown attached great importance to the vindication of the law in such a case, such a punishment would be inflicted upon them as would deter others from committing a similar crime. But oh, most lame and impotent conclusion! A sentence of 9 months' imprisonment will, it is to be feared, rather encourage other adventurers to speculate in the same way. The tendency to make political capital out of such a miscarriage of justice was nowhere more notable than in that Home Rule journal, the Dublin Star, the paper of a very lively member of Parliament, Mr. T. P. O'Connor. In connection with the case, the following breezy editorial is worth preserving. It sometimes seems a pity that there is no method of overhauling the conduct of judges. Enthroned in a position almost of omnipotence, these gentlemen are able often to overthrow the law they were intended to administer, and, as in the recent outburst of Mr. Justice Grantham, to violate all the decencies of life and all the conventions of fair play. The House of Commons remains as the great court of appeal for all the nation, though whenever an inconvenient inquiry is raised, the minister is always ready to get up and declare the incompetence of the House to discuss the decisions of the courts. Nevertheless, we sincerely hope that attention will be called to the scandalous conduct of Mr. Justice O'Brien in reference to what are known as the great insurance frauds. This whole story is one of the most startling in all criminal history. A number of men in Belfast conspired to rob the Equitable Life Assurance Society of New York. The plan was to hunt up some poor devil who was drinking himself quickly to death, or who was already in the last stage of disease, to forge an application without his knowledge for an insurance, then to forge the certificate of the doctor, and when the tippler or the consumptive came to his early end, to pocket the policy. The conspiracy was gigantic and widespread in its operations. Not satisfied with Belfast, it went through the whole county of Antrim, until the policies taken out reached the enormous figure of £40,000. At last, through some accident, a clue was given, it was followed up, and this tremendous network of fraud was unravelled. The discovery of the kind of persons involved was as astounding as the gigantic nature of the operation, for at the head and front of this vile plot were men of great wealth, of conspicuous piety, and, without exception, they were pillars of the Loyalist party. Mr. Chestnut Smythe, who was the leading figure in the conspiracy, was secretary of the reception committee that welcomed Mr. Chamberlain, and doubtless was in the mind of that renegade when he was pointing to the contrast between the poverty and dishonesty of the Southern Nationalist and the sturdy honesty and stable prosperity of the Northern Loyalist. The name of Mr. James Henderson, the proprietor of the Belfast News Letter, the chief organ in Ulster of the Orange Party, has been mentioned in a way and with a frequency that suggests that either he ought to be in the dock or somebody else ought to be the defendant in an action for libel. Mr. Dunlop, another of the foremost conspirators, is reported to be a man worth £80,000, and several others of the swindlers are also men of large means. The guilt was brought clearly home, for Mr. Chestnut Smythe, the companion and patron of Mr. Chamberlain, was admitted as informer and revealed the whole story. And now comes the most scandalous feature of the whole business. If there were ever a pack of ruffians that deserved to be sent to a prolonged period of penal servitude, they were the men engaged in this conspiracy. They had not the temptation of poverty. They acted from pure, unadulterated, wicked greediness. Some years ago, a few Americans, men of desperate fortunes and clement needs, entered into a conspiracy to rob the Bank of England. They were all sentenced to penal servitude either for 20 years or for life, and only one, so far as we know, has ever been released, and he was a broken man. If these men, being Irishmen, had also been nationalists, they would have fared as ill. The same judge who tried them sent a few years ago an unfortunate young bank clerk who stole under the influence of bad, dissolute companions to 7 years penal servitude. What think you was the sentence of Dunlop, the scoundrel with £80,000, who grasped at more and robbed and forged to obtain it? Just 9 months. One of the other conspirators got off with 6 months, and Mr. Chestnut Smythe, the friend of Mr. Chamberlain, having played the Judas part one would expect from his alliances, escaped scot-free. This scandalous result has proved too much even for the Daily Express, whose friends and supporters were implicated. The frauds, it rightly declares, of a magnitude and a turpitude greater than any which has been brought to light within living memory in Ireland, and it adds that a sentence of 9 months' imprisonment will, it is to be feared, rather encourage other adventurers to speculate in the same way. To make this part of the story complete, we should add that Mr. Justice O'Brien, whom all the journalism of Ireland, with the exception of the Belfast News Letter, Mr. Henderson's paper, have united in denouncing, is an intimate friend of Mr. Wilson, the chief calumniator of the Times, and is credited in Ireland with some share in the production of the articles which, being under judicial investigation, we cannot now adequately describe. 2 or 3 things finally must be said as to this case. We have no desire whatever to make all Belfast responsible for the villainies which have at last been exposed, although the judge did make the significant remark that all Belfast seemed to be more or less concerned in the fraud. But it is permissible to observe that if a wholesale fraud had been exposed in which nationalists were the guilty parties, as extensive as that which has just been revealed in Belfast, it would have been utilized on every unionist platform in England as a final and convincing argument against Home Rule. In the absence of any such bonne bouche, the loyal inhabitants of Belfast are still represented as too loyal, too honest, too virtuous, too law-abiding to be put under the foot of a dishonest, immoral, disloyal, Parnellite Parliament in Dublin. Have we not, in the face of such disclosures, heard enough of those eulogies of the north of Ireland at the expense of the rest of the country? And, finally, one of the great arguments on which the Unionists support coercion is the impossibility of getting verdicts even when the guilt of the accused is palpable. We defy any Unionist to point to a single case in which a nationalist jury has refused to convict a swindler such as any one of those concerned in the great equitable fraud. But so much were the Crown afraid of the loyal, and the law-abiding, and the moral, and the honest, and the virtuous, and the Unionist jurors of Belfast, that they transferred this case to the Wicklow Assizes held in another county and in another province. The less we hear of the loyalist Belfast in the future, the better. End of section 9. Read by Anna Goss.
Section 10 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Doyle Sanders. Stratagems and Conspiracies to Defraud Life Insurance Companies, an authentic record of remarkable cases, by John B. Lewis and Charles C. Bombaugh. Speculative Insurance, Part 5. The Blackburn Gamblers. Nearly 3 years after the nefarious transactions in Belfast, a concerted purpose to revive them on a larger scale, and with even greater audacity, was discovered in Blackburn, a Lancashire town. Mr. Bain, the editor of the Belfast Insurance and Financial Gazette, who was one of the prime movers in unearthing the memorable conspiracy in his own city, was largely instrumental in exposing the Blackburn copyists. He published a list of cases, September 1890, the record of which came into his possession, and his comments upon them, some of which we subjoin, are amusing. In the proposal forms, one of the lives referred to was described as a coal dealer, and very naturally the companies with whom the assurances were affected assumed that a man carrying 1,900 pounds of assurance was in a good way of business. The description was literally true, but who would have dreamed that the coal dealer insured for 1,900 pounds was a hawker of odd bags of coal, and to all intents and purposes a pauper? The gentleman insured for 4,000 pounds was described as an undertaker and coach proprietor, his only claim to such designations arising from the circumstance that he was employed in an undertaker's yard in the capacity of a cab washer and a stable assistant. The magnate of Blackburn, upon whose life the assurance companies were interested to the extent of 9,000 pounds, was introduced to their notice as a poultry salesman. But how this occupation was selected, unless simply at random, it is impossible to say, unless that in his actual vocation of a loiterer about the market he was of service in watching that the poultry did not escape. He was aware of the fact that death would materially increase his commercial value, but so long as his income of odd shillings was enhanced by fees for signing insurance papers, he did not care how long the thing went on. To put it plainly, the man carrying 3,880 pounds of insurance is a pauper, but the fact that he hawked churchwardens in a basket when he could raise sufficient coppers to purchase a stock, which suggested that his proposal would be acceptable when he assumed the role of a pipe manufacturer. When trade is depressed, or his funds are at a low ebb, this life, insured for thousands, takes refuge in the workhouse, but his extreme poverty and misery, instead of exciting sympathy and compassion, created a desire to coin money on his deathbed. Next in order comes a builder and contractor who, as his own worst enemy, presented admirable features for speculative insurance, which were rather enhanced in value than otherwise by the secret knowledge of the Blackburn gamblers, and which, for obvious reasons, was concealed from the companies, that the unfortunate man was in reality a steeplejack. No doubt it was aggravating to the gentleman who owned the policies that, when in a suitable condition of mind and body for transforming the policies into cash orders, the builder and contractor was not permitted to ascend and sweep chimney stacks, although to persons of a different constitution it would be a comfort to know that, as a consequence, blood did not lie at their threshold. A laborer and a working tailor are two other subjects from whose deaths handsome profits might have been realized. It is scarcely necessary to say that all these unfortunate creatures are the victims of intemperate habits, but it is dreadful to have to add that there is a good reason to believe that every facility was being afforded to some of them by the owners of the policies for indulging in their craving for drink. Insuring men's lives with the knowledge that they were drunkards and subsequently supplying them with drink is an outrage which can only reflect credit upon the ingenuity and rapacity of a heathen community. A donation party and what came of it. The rector of an Episcopal church in a thriving town in the West had a donation party early in the month of January 1866, and divers good gifts fell to his portion upon that occasion. The wishes for a Happy New Year were not conventional or empty-sounding, but were pronounced with an emphasis full of substantial meaning. With the replenishment of his scanty purse, the good rector's heart was full of love toward all his parishioners. More than that, parish boundaries do not limit the overflow of his benevolent feelings, and thus he bethought himself of Brother Ferrand, a resident Presbyterian clergyman who, poor fellow, had sustained a severe accidental injury to his hip and spine the November previous, and who was now barely able to limp around upon crutches. To think was to act with our worthy rector, and he immediately sought out Dr. Blank, who was present at the party, and consulted him as to the probabilities and possibilities of Brother F.'s recovery. The doctor was prepared to say at once that, in his opinion, Brother F. had sustained such injuries as would cause his death ultimately. Possibly he might live for many months, or long enough to die from other causes, but in any event he was at all times liable to accidental aggravation of his injuries, such as surely would carry him off. The rector had been revolving in his mind a course that seemed to be advantageous, and his reflections assumed still greater importance upon learning the doctor's prognostications. It had occurred to him that Brother Ferrand should be insured, and that without further delay, and he concluded to pay the required premium out of the proceeds of his donation party. The doctor suggested that Brother Ferrand was scarcely in condition to undergo a favorable medical examination for a life policy of insurance. The rector replied that he understood that perfectly well. An ordinary life policy, of course, was out of the question, but would not an accident policy answer the purpose? Had not Brother Ferrand met with an accident, a serious and ultimately fatal accident? Was it not for such as he that an accident insurance policy would be of special value? He would ask Mr. M., who was present at the party, and with whom they both well knew as a worthy and wealthy member of the rector's flock. He knew that M. held the agency of an accident insurance company, and furthermore he had seen it advertised in his paper that for such insurance there was no medical examination required. Surely, if ever there was a case in which no medical examination was required, or even compatible with insurance, it must be that of Brother Ferrand. Notwithstanding the cheer and chatter, the interruptions and the gaieties of the occasion, the rector, the doctor, and the agent were soon in conference, and engaged in the consideration of the proposition suggested by the rector. It was speedily determined that an insurance policy might issue properly against subsequent injury, and it was then and there decided that such a policy should be written. The rector was a man of prompt action, and he at once announced his willingness and his determination to pay the premium, and directed Agent M. to write a policy in the principal sum of $5,000 for the benefit of Brother F.'s wife. The agent was more dilatory in his action, however, and it was not until after poor, unfortunate Brother Ferrand had sustained a second fall in injury that the policy was finally written and delivered, though dated back to February 1st. The later accident and injury occurred February 19th, several weeks subsequent to the donation party. As was fully expected at the time of writing the policy, death soon terminated the sufferings of Brother F., and the policy became a claim for $5,000. Affirmative proofs of death in support of the claim were duly prepared and forwarded to the Travelers Insurance Company, wherein it was fully set forth how and whereby the injury of February 19th was the proximate and sole cause of death. The little scheme occurred during the early history of accident insurance in this country, and as the parties presenting the claim were of that high-toned respectability which ought to carry unchallenged honesty with it, the company saw no reason to question its validity. The sum insured was promptly paid by the company by means of a check for $5,000 to the order of Mrs. Ferrand, the beneficiary named in the policy, which was forwarded through the hands of Agent M., who was instructed to deliver the check and obtain the usual discharge of the policy and claim. Then commenced a little game, an inkling of which coming to the knowledge of the company several months afterward. An investigation was set on foot which soon unearthed the whole matter. It appeared that although Agent M. did not concoct the scheme, He was well aware that he was a party to the fraud from the first. And as he intended and tried to swindle Mrs. Farran, the widow, out of a part of the insurance money after he got possession of it, his motive was apparent. Of the proceeds of the $5,000 check, which Mrs. F. entrusted him to collect for her, she received, in cash, $90, notes and mortgages, $2,000, due and due of doubtful value, $2,000, county bond, $200, total $4,290. Agent M soon found himself in unpleasant business relations with his company, together with a criminal prosecution staring him in the face. No escape was open to him save through full, complete restitution to the company he had defrauded, and this he was able to make, and did make. The entire sum was refunded by him to the company, together with a sufficient amount in addition thereto to defray all costs, expenditures, and outlays of every description which the company had incurred in consequence of this conspiracy to defraud its treasury. Moreover, he could not go into a court of law or equity against the widow and exhibit clean hands. Therefore, he could not recover any portion of the sum he had paid her, and he did not attempt it. He professed sincere penitence and promised thereafter to lead a life of honesty. End of Section 10. Read by Doyle Sanders, Atoka, Tennessee, October 21st, 2021.
Section 11 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Veronica Mead. Stratagems and Conspiracies to Defraud Life Insurance Companies. An Authentic Record of Remarkable Cases. By John B. Lewis and Charles C. Bombau. Inferences and Presumptions of Death. Universal preference for the drowning trick. Under the comprehensive term, mysterious disappearance, may be classed a majority of the frauds upon life insurance companies. Adventurers who hesitate at the commission of capital crimes are quite willing to leave behind them, through the dramatic effect of dissolving views, reasonable conclusions or presumptions of their death. There is a remarkable monotony in the recurrence of these disappearances, the favorite method in most cases being by immersion and pretended drowning in some convenient stream of water. It is a trick which is usually planned with a good deal of art and executed with a good deal of skill, yet there is almost always an earmark or trail which, however insignificant to an untutored eye, is sure to lead to eventual capture. The case of a Massachusetts merchant, as related by W. G. Davies, Esquire, in an address before the New York Medico Legal Society, may be taken as the type of a large class. He had embarrassed his affairs by a long-continued series of forgeries, had become somewhat apprehensive of the result to himself, and endeavored to solve his difficulties by a mysterious disappearance from a Fall River boat. He was known to have left New York on it, but was not seen the next morning, and on examination his outer clothing was found in his stateroom, but no trace of himself. His life was heavily insured, he was known to be financially embarrassed, and the first supposition naturally was that he had committed suicide. Unfortunately for the success of his well-laid plans, the victims of his crimes were sufficiently skeptical of his death to secure a large detective force to trace him, and their efforts resulted in his arrest at San Francisco as he was about to embark for Australia. His plan of operation had been very simple. He merely left the suit of clothes he had worn in his stateroom. Taking another from his valise, shaved his beard and whiskers, and stepped forth so altered that no casual observer the next morning recognized him as the man he had seen the night before. Mr. Davies also gives the following particulars of an attempt to defraud 3 insurance companies by 2 men named Shepard, who, in the construction of their plot, exhibited more care and greater attention to details. A Potomac River Case. About the middle of July, 1873, one George Shepard called at the house of a farmer in Maryland, living near the Potomac River, nearly opposite Alexandria, and asked and obtained permission to spend the night. One of the family was a boy of about 16 years of age, apparently a simple, well-meaning creature, not overburdened with brains, who seemed to Shepard a fitting tool for the scheme he had in mind. In the course of the evening's conversation, he suggested to the farmer, who spoke of his desire for additional help in harvesting, that he had a brother living with him in Alexandria who would be glad to accept a short engagement. The proposal was accepted, and James Shepherd entered into the farmer's employ, his brother visiting him almost daily, and thus continuing his own acquaintance with the family. After a week of these preliminaries, James, who had by this time become quite well acquainted with the boy already mentioned, proposed to him one evening to go out on the river for a fishing excursion with his brother George, and the two together went to the water, where they found George in a boat. This latter had some peculiarities of construction which are entitled to a special mention. It was an ordinary working boat, about 12 feet in length, having 2 seats in the center, but none in the bow or stern. On the latter was fastened a platform which projected out over the water some 10 or 12 inches, and almost as much on each side, and a rope ran along the outside of the boat from the bow to the stern, and dragged some additional length in the water. The weather was warm, but George wore a rubber coat over his other clothing. In this boat, thus prepared, the party started about dusk, James and the boy each pulling an oar, and George sitting in the stern. They stopped twice and anchored to fish, and having consumed the time until it was quite dark, the night being cloudy, the shepherds proposed to pull up the anchor and go ashore. They were then on the flats between the channel and the shore. The moon was obscured by thick clouds, and the only light visible proceeded from a lighthouse on the Virginia shore opposite to them. On the return trip, the position of the parties was somewhat altered. George sat in the bow of the boat, the boy in the center, pulling both oars so that his back was towards him and his attention fully occupied, and James on the other seat. Suddenly, as the boat was proceeding quietly without any jar or shock, a splash was heard. James cried out that his brother had fallen overboard, and the boy, turning his head, saw him for one brief instant near the boat on the surface of the water, beneath which he immediately sank. The two rowed about for some time, and poked with their oars on the bottom of the river, but of course did not find what one of them, at least, knew very well was not there. After 15 minutes spent in this useless employment, they proceeded to the shore, when the boy was at once sent to the distance to inform a neighbor of the accident, thus giving George an opportunity of coming out from under the stern of the boat, where he had supported himself by the rope, and betaking himself to a place of security. The neighbors were told the story and urged to search for the body, but the rogues were inferior to their English prototypes in neglecting to procure a corpse to personate the absent one, and no body was ever found. James remained in the farmer's employ for a few days longer, until he had recovered from his grief sufficiently to enable him to take the boy before a notary public in Alexandria and have him swear to an affidavit detailing the circumstances of the death of George, as he understood them, and then to disappear from view for a while. About this time, the police of Alexandria became very much exercised about the mysterious movements of some men who appeared to be living in a swamp near the town, and as it was feared that they were plotting burglaries at least, it was decided to effect their capture. A sudden and unexpected movement resulted in the discovery of the shepherd's boat, containing 2 men, one of whom escaped at the first alarm, but the other, who proved to be James Shepherd, was taken prisoner. He was found to be heavily armed, and to have on his person 3 policies of insurance, which had been issued by as many companies upon the life of his brother George, and the affidavits of the latter's death made by the boy and himself. In his first fright and alarm, he confessed the whole fraud, but subsequently decided to contradict his statements, and to plead not guilty to the indictment which was found against him for perjury and swearing to his brother's death. The event proved his wisdom, for the jury before whom he was tried were unable to make up what they were pleased to call their minds, although several witnesses disposed to having seen George Shepherd since the time of his alleged death, and their disagreement was a virtual discharge of the prisoner. He was so emboldened by this success that he had an administrator of his brother's estate appointed in Richmond, and commenced a suit on the policies in his name. It is needless to add that this is not one that gave the company's interest much anxiety, familiar as they are with the extraordinary vagaries of petite juries. The curious case of Sergeant Allen. For boldness of conception, for ingenuity in execution, and for unblushing perjury in its support, this conspiracy to defraud is one of the most remarkable of its kind. The facts are not numerous, but are full of interest, and they may be related briefly as follows. On the 16th of November, 1865, a man calling himself John H. Sargent applied to the agent of the Travelers Insurance Company of Hartford in Beloit, Wisconsin, for 3 months' insurance against death by accident, and obtained a policy in the sum of $3,000. This man came from Rockford, Illinois, the day before, in company with a woman named Mrs. Asa E. Follett, a widow who lived near Pectonica, Illinois. He registered their names at the Bushnell House, Beloit, on the 15th day of November, and they were assigned to separate rooms. They were married the next morning by Reverend S. H. Stocking of Beloit, in presence of Mrs. Stocking, Miss Stocking, and Mrs. Purcell, all residents of Beloit. Sargent applied for his insurance policy about 9 o'clock a.m. after his marriage, stating that he was in a great hurry to take the 10 o'clock train. The policy was written and delivered to him, and was made payable, in case of loss, to his wife, Asa E. Sargent. Both parties to the marriage were strangers in Beloit. The newly wedded couple immediately left the place, and we heard nothing further concerning them until on the morning of December 15th, when the people of the village of Pecatonica were notified by Henry J. Allen and his brother-in-law Samuel A. Corwin of that place, and Emmanuel Hill of Rockford, that John H. Sargent, who had been skating, in company with Corwin, on the Pecatonica River during the afternoon of that day, had fallen through an air hole and disappeared under the ice. Thorough search for the body was immediately instituted and continued during the next 2 days by a large number of citizens, but no trace of it was discovered. Proofs of the death of Sargent and the widow's claim which had arisen under the accident policy were forwarded without delay to the insurance company. The proof papers consisted of the affidavits of Allen, Corwin, and Hill, all of whom swore positively to the drowning of Sargent at the time and in the manner above stated. Soon after receiving notice of his loss, a special agent of the company visited Pecatonica, and upon inquiry of the citizens as to the facts and circumstances surrounding the accident, he came to the conclusion that, although the body had not been found, there was no good reason to doubt the death of the insured. The people generally expressed their belief in the occurrence as alleged, though there were a few persons who held a different opinion. The officers of the company, not being fully satisfied, directed further investigation, which resulted in their determination to withhold immediate payment of the claim, although there was nothing but vague suspicion to justify delay. The suspicion was founded mainly upon the bad character which the parties, especially Allen, bore in their own neighborhood, and the singular circumstance that Sargent, who had been married only 4 weeks, every day of which had been spent away from his bride, did not, on his return to the town where she was living, first visit her before skating with his friends upon the Pecatonica River. It was decided to resist at law, if need be, what appeared to be an attempt to defraud the company. A search for John H. Sargent, living, was then commenced, and the inquiry pursued diligently, and into distant regions, for some 3 months without success. No one outside of the Allen clan had ever seen Sargent, and no trace of the man could be found except through them, or through the unsatisfactory information which they were willing to give. In the course of this search, an agent of the company visited Beloit and interviewed the clergyman and the witnesses who were present at the marriage of Sargent and Mrs. Follett. He then visited the insurance agent at Beloit, who issued the policy, and learned from him that Sargent pawned a silver watch of little value for the premium of his policy. The watch had been sold, but was hunted up and secured. The hotel register was examined, and it was found that Sargent had registered his name with initials transposed, thus, H.J. instead of J.H. Sargent. The latter circumstance led to the belief that Sargent was a myth, and that the name was adopted for fraudulent purposes by the person who contracted the marriage and took out the insurance policy. While one might transpose the initials of another's name by accident, it was thought impossible that such a mistake would occur in writing one's own name. The circumstance recalled the fact that the initials of Allen's first names were H.J., and the thought suggested itself that he might have registered the name, and that in doing so unwittingly committed the blunder. Some of Allen's handwriting was sought and obtained, and lo, the counterpart of the letters forming the signature of J.H. Sargent to the application for insurance, and of H.J. Sargent on the hotel register, was unmistakably there. It was also ascertained that the watch had been repaired at a shop in Rockford for Henry J. Allen some 3 weeks before the time when it was pawned at Beloit for the insurance premium. Measures were then taken to procure a sight of Allen by the clergymen and witnesses to the marriage, and by the agent who issued the policy. One of these identified Allen positively as Sargent, while all the others confirmed this identification with more or less certainty. In due time, the case of Asa E. Sargent versus the Travelers Insurance Company was called for trial in the Circuit Court for Boone County, Illinois. The plaintiff testified that she had been married to John H. Sargent on the 16th day of November, 1865, that immediately after the marriage Sargent took out the insurance policy and then left for the oil regions of Pennsylvania, that on the 15th day of December following, Sargent arrived in Pecatonica upon the westward bound train, that on that afternoon he was skating on the Pecatonica River in company with Samuel A. Corwin, and that while so skating, and in the presence of Henry J. Allen and Emmanuel Hill, who stood on the bank of the river at the time, he fell into the air hole and was drowned, and that his body never had been recovered. On cross-examination, Mrs. Sargent was unable to give any facts leading to the identity of her alleged husband. She did not know his nationality, she did not know his place of birth, and she was ignorant of father, mother, brother, or sister, or any other relative near or remote. She had simply married him, and that was all, for the same day he left her, and she never saw him again. Being requested to describe his personal appearance, she drew from her bosom a photograph, which she swore was a true and correct picture of her husband, John H. Sargent. Allen, Corwin, and Hill each testified to their acquaintance with John H. Sargent, and to the particulars of his accidental drowning, of which they were eyewitnesses, as has been stated. Mrs. Elmira Allen, wife of Henry J. Allen, testified that Sargent took dinner at her house in Pecatonica on the day of the alleged drowning, and that she heard of the drowning at about 5 o'clock that afternoon. Abram D. Allen, father of Henry J. Allen, testified that he knew Sargent and gave a description of his personal appearance. He was shown the photograph and expressed his opinion that it was the picture of Sargent. Anne M. Redfield testified that a man once visited Mrs. Follett's house, where the witness was living, and that Mrs. Follett told her the man's name was John H. Sargent. Witness had a distinct view of the man at the time and retained a clear recollection of his appearance. Upon being shown the photograph, she identified it as the picture of the man called Sargent by the plaintiff, Mrs. Follett. Mary A. Larkin testified that she was in Beloit on the 16th day of November, 1865, and was then and there introduced by plaintiff to a man whom she called her husband and by the name of Sargent. On being shown the photograph, she said that to the best of her recollection it was the picture of the man introduced to her as Sargent. Many other witnesses were examined upon minor points for the plaintiff. The defense to the action was stated to be, in substance, that no such man as John H. Sargent ever existed, that the action was based upon a conspiracy to defraud in every stage of which Henry J. Allen was the chief actor. That said Allen himself, under the assumed name of John H. Sargent, went through the ceremony of marriage with the plaintiff at the time of the alleged marriage at Beloit, and that it was Allen who signed the application and took out the policy of insurance under the assumed name of Sargent, that no person, in fact, was drowned, that the pretended drowning was but another stage in the development of the original scheme in which Allen, Hill, and Corwin were the sole actors, and that no other person was with them at the time of the alleged drowning. Allen skillfully making use of Hill, who was a stranger in Pecatonica, as the party who was alleged to have been drowned, and further, that on the 23rd day of May 1866, a little more than 6 months after the marriage, the plaintiff was delivered of a child, and that her motive in participating in this conspiracy was to conceal the presumed criminal intimacy of plaintiff with Henry J. Allen, as well as to obtain money fraudulently on the policy. For the defense, Reverend S. H. Stocking testified that he performed the marriage ceremony between a man calling himself John H. Sargent and a woman calling herself Mrs. A. E. Follett, that according to the best of his recollection, and without any reasonable doubt, he identified Henry J. Allen as the same man and the plaintiff as the same woman. Mrs. E. A. Purcell testified that she was present at the marriage of the parties, that she next saw the same man in Pecatonica about 4 or 5 weeks previous to the trial of this cause, and he was then and is now known by the name of Henry J. Allen, that she had no doubt in her recognition of him, that no one pointed him out to her, that she had seen him since in Beloit, and that she had no doubt he was the man whom she had seen married under the name of Sargent. A clerk to the insurance agent at Beloit testified that, to the best of his recollection, Allen was the man who applied for the insurance. Another clerk identified Allen, and had no reasonable doubt that he was the man who applied for the insurance under the name of Sargent. This witness also identified the watch. Joseph Britton, agent for the company, testified to issuing the policy and receiving the watch in pawn for payment of the premium, identified the watch, and identified Allen as being, in his judgment, the man who obtained the policy, and signed the name of John H. Sargent to the application. The clerk of the hotel at Beloit identified Lee from the hotel register and testified that signatures H.J. Sargent and Mrs. A.E. Follett were written by the man who called himself Sargent. A watchmaker in Rockford identified the watch as one which had been left with him October 19, 1865, for repair by Henry J. Allen, to whom he delivered it again October 22nd. The handwriting of Allen, as it appeared in the signature to the application for insurance, and in the names upon the hotel register, was recognized and identified by no less than 5 citizens of Rockford, all of whom had had correspondence with Allen and knew his handwriting. Up to this stage of the trial, which had occupied more than 3 days, both plaintiff and defendant had presented strong points in support of their respective relations to the cause. The evidence for the witnesses for the plaintiff would seem, certainly, to have been of such a nature that it ought to have been conclusive, and although some of these witnesses, in public estimation, did not sustain a first-class reputation for truth and veracity, it was not probable that they could have been impeached through the evidence of other witnesses upon that fact. The defendant insurance company did not attempt to do this. In fact, it became unnecessary. On the 4th day, the defendant produced the following witnesses, whose brief but overwhelming evidence will best tell its own story. Loren M. Whitney testified that he lived in Batavia, Illinois, and that he was a photographer by occupation. The photograph heretofore introduced in evidence by the plaintiff, as the picture of the drowned sergeant, was shown to witness, who said, "This photograph is of my make. I have the negative from which this picture is made. I took the negative, and know the person who sat for it." Witness here produced the negative, which was admitted in evidence to the jury. The name of the person who sat for this negative is James Clure. He lives in Batavia, Illinois, is a tailor by trade, and is still living. I've seen him nearly every day, and I last saw him about an hour ago. Profound amazement pervaded the courtroom, and amidst almost breathless silence the name of James Clure was called. From a retired seat, the unmistakable original of the plaintiff's photograph at once stepped into the presence of the court, jury, and the plaintiff's astonished counsel. He took the stand and testified as follows. "I live in Batavia, Illinois, and am a tailor by trade. I had some photographs taken last fall by Whitney and Kendig photographers in Batavia." Witness was here shown the photograph introduced in evidence by the plaintiff as that of her husband, Sargent, and said, "This is one of the photographs I had taken. I am acquainted with Henry J. Allen, and at one time served under him in the army. He was then captain of my company. At Allen's request, I sent him this photograph about the 1st of November. I was never known or called by the name of John H. Sargent. I was never married to the plaintiff. I was never drowned in the Pecatonica River." At the conclusion of Clure's testimony, the counsel for the plaintiff made a feeble attempt to use Weller's infallible recipe and proved an alibi for Allen at the time of his mock marriage with Mrs. Follett, but signally failed, and in freely exhibited disgust withdrew the suit. The discovery of the final and conclusive evidence was made during the trial. Upon examination of the photograph introduced by the plaintiff as the picture of her husband Sargent, the defunct, it was observed quietly that there were certain marks upon the back of it indicating the name and residence of the photographer, and a shrewd man was sent at once to investigate the matter, with the result as stated. It required pretty lively work on the part of the person in pursuit of knowledge under difficulties, for he had not the photograph itself to take with him. The defendant's counsel had to manage adroitly to protract the trial during the absence of the person sent. When the witnesses were produced in court, the sensation was intensely exciting, and the conspirators' cause hopelessly crushed. Henry J. Allen and the widow Sargent were subsequently indicted by the grand jury of Rock County, Wisconsin, in which Beloit is situated, for bigamy. Allen had absconded but was found in Iowa, where he was laid up with serious bodily injuries, which he had sustained by a falling tree which he was cutting. He was brought away by the officers of justice on a cot or stretcher as soon as he was able to travel, and was committed to jail in Janesville, Wisconsin, in default of bail, as was also the widow. After remaining in jail some time, and thereby punished to some extent, though not so much as their crimes deserved, they were released on nominal bail, which was, of course, forfeited, and they escaped further punishment. This was the result of humane consideration for the widow, who was Allen's dupe, and for her children, and for Allen himself, whose confinement really endangered his worthless life. End of section 11.
Section 12 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information, or to volunteer please visit LibriVox.org. Read by Piotr Natter. Stratagems and Conspiracies to Defraud Life Insurance Companies, an Authentic Record of Remarkable Cases, by John B. Lewis and Charles B. Bombo. Mysterious Disappearances, Part 2. A Boston Scamp. This individual was a young man of about 25 years of age when, in 1866, his mysterious disappearance caused a momentary flutter in the financial pulse of several life and accident insurance companies, which recently had written risks upon his life to an amount exceeding $40,000. Alva K. Herter was senior partner of the firm of Herter & Dewey, at that time doing business in Boston as cotton brokers, and resided in Chelsea with his father, who had been connected with some missionary station in Syria as a printer. Young Herter was born in Syria, and there spent his early boyhood. The family returned to this country, and in due course of time Herter became engaged in business as stated. In the summer of 1866, in company with friends and acquaintances, he went to Scarborough, Maine. Upon a certain Friday evening, several days after his arrival, he was apparently enjoying a sociable game of euchre until about 10 o'clock. He then wrote a letter to his father, in answer to one notifying him of the arrival of his cousin from Mobile, Alabama, in which he informed his father that he would be home Saturday night, but if anything should prevent, would come by the first train Monday morning. Herter left the letter upon the table, saying to his companions, "I cannot sleep unless I take some exercise before going to bed. I am going out to take a row." The house in which the parties were was within a stone's throw of the beach, where several small boats were fastened near the water's edge. He did not afterwards return. The next day no trace of him was discoverable, but on the second day, Sunday morning, a small dory was found bottom up, partly stove in, and lying near the boat was found one of the oars belonging to it. At an indescribable distance from the dory was picked up a life preserver vest which was partly filled with air, and further search resulted in the discovery of a hat which was identified as one worn by Herter. The place where the boat was found was about half an hour's rowing from the house where Herter had been boarding. At certain stages the tide runs swiftly, and at its ebb leaves numerous rocks above the surface of the water. The disappearance was plausibly accounted for after these discoveries. It was supposed that Herter was rowing at the time in the usual manner, sitting with his back toward the bow of the boat, when the latter ran upon a rock and thereby was partly stove in, upset, and Herter drowned. Search for the body was carefully and thoroughly made. At low water the bottom could be seen distinctly in most places, and every probable place was dragged. It did not seem to surprise anyone that Herter had lost his life, as was apparently the case. The night he went out for exercise was at the time somewhat dark, and resident fishermen declared it dangerous for a stranger to be out upon the water at the hour and in the manner in which Herter had made his venture. Notices of loss under the several insurance policies were duly served upon the companies. Of the sum insured, the Travellers' Insurance Company had written 10,000 in accident insurance, and that company at once instituted an investigation of the matter. It soon afterward came to light that Herter had misappropriated some $2,000 belonging to the firm, that he had borrowed $4,000 for the firm of his father, and $3,000 of other parties, for all of which he had failed to account to the firm. His business partner was in New York during the period of these alleged misdemeanours, and the partial discovery of them was made while Herter was recreating at Scarborough Beach. Herter's partner at once wrote to him requesting him to return and adjust his accounts. No notice apparently being taken of this request, a message was sent to the effect that someone would appear with authority to bring him home, unless he came at once. This message was received by Herter just prior to his feeling the necessity for exercise before going to bed. On following up the search through the agency of the chiefs of police of Boston and Portland, it soon was ascertained that Herter, after suitably arranging the evidences of his drowning, went directly to the nearest railroad station, and thence hastened onward to Canada as rapidly as steam power could carry him. All claims against the insurance companies were speedily abandoned, and the policies surrendered. A Susquehanna River Case. In the summer of 1866 a man named Knox procured an accident insurance ticket of $5,000 in his own favour upon the life of a young man living near Harrisburg, Pennsylvania, bearing the singular name of John Smith. The insurance was written by the Railway Passengers Assurance Company of Hartford. It was to cover a period of 2 days only, and cost 50 cents. As the time, therefore, was short, John made good use of it by selecting the very next day for the bathing and drowning purpose contemplated in the transaction. He took with him a boy who was to bear witness to his final disappearance from earthly scenes and trials via the engulfing waters of the Susquehanna. The boy, properly coached, bore witness to the lamentable fact that he was on the shore watching Smith and saw him drown, after which he carried Smith's clothes homeward. Mr. Knox was distressed and anxious. He even offered a reward of $60 in gold for the recovery of the body, but it was not recovered. In due time proofs of death were made out, and Mr. Knox knocked at the door of the company and asked for $5,000. Its officers scented fraud and declined to pay. Suit was brought, and the cause was to have come to a final trial in the month of March following, but before the appointed day arrived, a detective of the company found Mr. Knox in Philadelphia, and exercised such persuasive powers that he owned up that it was all a fraud. John Smith was not drowned in the slightest degree, but was serving his country as an able-bodied soldier of the regular army. It is clear that Mr. Knox ought to be serving his country in the penitentiary. An Ohio River Case. On the 14th of August 1867 a hearing was had before Justice Walter, of Washington, D.C., of the case of Joseph Le Pen, alias H.A. Dycher, who was charged by his wife, Josephine Le Pen, with having committed adultery. She also charged that she was afraid that the said Le Pen would do her bodily harm. He was further charged with an attempt to defraud the Connecticut Mutual Life Insurance Company out of the sum of $10,000, as the following letter from the president of the company would show. Office of the Connecticut Mutual Life Insurance Company, Hartford, Connecticut, August 12, 1867. Dear Sir, I have noticed today an account taken of the Washington Star of an attempt to defraud a life insurance company by one Joseph Le Pen, alias H.A. Dycher, who is said to be a clerk in one of the offices of the Patent Office Building. As the account corresponds precisely with the proofs of loss and circumstances of a claim made upon our company by Josephine Le Pen for an insurance on the life of her husband, Joseph Le Pen, except as to the time, we are anxious to ascertain if there is or was a clerk in any of the departments by the name of Joseph Le Pen, alias H.A. Dycher, and know of no one to address but you to make this inquiry. The account states that Le Pen was arrested at the instance of his wife for adultery, and he was committed for trial by Justice Walter. This may give you a clue to the case, or, if you have not time for the inquiry, please inform me if there is a Justice Walter in Washington, and give me his address, that I can write to him. Joseph Le Pen was insured in our company in January 1862. In December 1866 claim was made on us that Le Pen was drowned in the Ohio River about the 11th of August previous, as he took passage on a steamer at Parkersburg the day previous, and when the boat arrived at Wheeling he was missing, but his clothes and effects were found in his stateroom, and on the 16th day of August a body was found in the river some 25 miles below Wheeling, and though it could not be identified as Le Pen's, his wife claims, on account of his continued absence, that it was that of her husband, and demands the insurance money. All the circumstances stated in the Star paper correspond with her statement, except in relation to time, and we are inclined to think it is the development of what we had always supposed was an attempt to defraud us of the money. If you can put us on the track of an investigation you will much oblige. Yours truly, Guy R. Phelps, President. To J.N. Pryor, Washington, D.C. Mr. Cash testified that the defendant came to his house 4 months previously and gave the name of Dycher, that he stated that he had left Europe because he had killed his superior officer, and he desired to stay there till he could hear from his family. Subsequently a man came to witness's house, who recognized the prisoner as Mr. Le Pen. The prisoner then told witness that his name was Le Pen, that he was in Parkersburg and got on the steamer to go to Wheeling and go to gambling on the boat. that he lost his money, and himself and another of those engaged got to fighting, and fell overboard; that he got ashore and the other man was drowned. He then placed his pocket trinkets in the pockets of the man who was drowned, thinking he would try and create the impression that he was dead, so that his wife might obtain the insurance on his life, and that, having obtained the money, she might join him and they could go back to Europe. So far as the charge of adultery was concerned, nothing was proved beyond the fact that the prisoner was seen to kiss the wife of the witness. After hearing the evidence of a number of witnesses, the prisoner was remanded for a further hearing. Justice Walter stated that from the facts within his knowledge there was strong suspicion that the prisoner had pushed the man, with whom he had been gambling, overboard, and that he felt justified in holding him in custody until he could obtain the presence here of parties in Willing and Hartford. Leppen, however, was subsequently discharged from custody after having his picture taken for the Rogues Gallery. Dr. Phelps, the president of the insurance company, wrote to Justice Walter, before whom the case was tried, that no valid complaint could be made against Leppen himself, as the claim for $5,000 and representations of death had been made by his wife. If she were in collusion in a transaction to defraud, he could be punished as an accessory if found guilty, but being a complainant against Leppen, it appeared to the officials that she was innocent, therefore all prosecution must be dropped. Dr. Phelps added: "The transaction was adroitly performed, and the circumstantial proofs were quite strong, but we had some suspicion that all was not right, and declined paying the policy, although threatened with a suit, so that we are not actually defrauded." A photograph forwarded from Connecticut, purporting to be a picture of Leppen, formerly of Cleveland, Ohio, and more recently of Wheeling, West Virginia, was identified as the likeness of the accused. The same picture had previously been identified by a coroner's jury as strongly resembling the body taken from the Ohio River after Leppen's disappearance a year before. The accused, at the time of his arrest, was employed as a clerk at the Department of the Interior, and was a native of Bohemia. End of section 12. Section 13 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Piotr Natter. Stratagems and Conspiracies to Defraud Life Insurance Companies. An Authentic Record of Remarkable Cases. By John B. Lewis and Charles C. Bombo. Mysterious Disappearances, Part 3. The Gay Deceiver, Boswell, alias Hoey. In the course of the year 1868, General D. K. Boswell and wife made their appearance in Muncie, Indiana. The General was a little past the middle age, of affable manners and engaging address. His statement in regard to himself was that he had been appointed a brigadier general in the Union service during the war, had amassed considerable property in the course of a long business life, and had come to Muncie to end his days in peace. He reported a moderate amount of property for taxation, was popularly believed to be worth about $50,000, and was considered a valuable addition to the grand list of the town. He devoted considerable time to the order of Masonry, in which he had taken the higher degrees, was very fond of society, and soon became generally popular with the citizens of Muncie. His wife, considerably his junior, kept her house in good order, attended to her own affairs, and made as favourable an impression in her way as her husband did in his. The Muncie people seem to have accepted the Boswells without credentials and without a thought of asking for them. If they had inquired in the right place, they might have obtained information embodied in the following letter, which was written to a party who subsequently became interested in bringing General Boswell to justice. Sir, if the D. K. Boswell who swindled you is the Daniel K. Boswell who in 1845, 1846 left his wife and children in Galena, Illinois, went to Hannibal or Palmyra, Missouri, ran away with old man Ross's daughter, said he was married on a steamboat, took a free negress from Indiana to Lexington, Kentucky, sold her, after she had a child by him, to a Mr. for a slave, was indicted but escaped about 1848 to Memphis, Tennessee, set up a picture gallery, made obscene pictures, perjured himself in a deposition to blackmail a citizen there, went to Holly Springs, Mississippi, in September 1848, stopped some time at a hotel, where he said he was robbed by a servant of $800, had the poor slave whipped nearly to death before it was discovered that he had had no money and had not been robbed, got into many difficulties there, shot a man's mules, committed perjury, ran away to West Tennessee, got religion, joined the Campbellite Church, again got into difficulties and disappeared, but whither this biographer knows not. If this is your man, he is the most unmitigated scoundrel unhung. But information was not solicited and was not volunteered, so that in 1870 or thereabouts, when the Franklin Life Insurance Company of Indianapolis wished to organize a local board in Muncie, Boswell was recommended by men of long residence and of high position in the town as the man above all others who should be enlisted in the matter. He was approached, the plan was talked up, and he finally consented to insure his life for $10,000 and to become president of the local branch. His supposed influence in the town was so great that, for the sake of getting it, the company did not demand a cash payment of any part of the premium of his policy, but accepted his note for 6 months for the entire amount. This note was renewed at maturity for another 6 months. Meanwhile, as a sort of pastime, Boswell had gone into the sale of a patent fruit dryer, and was supposed to be making considerable money. On the 15th of September, 1871, Boswell and his wife started for St. Louis, he having business there, as was supposed. At the Montclair Railway passenger station Boswell purchased 2 insurance tickets issued by the Railway Passengers Assurance Company of Hartford, Connecticut, the tickets being for the principal sum of $3,000 each, and good for 10 days. His second year's premium in the Franklin Life would fall due before his return, and also his note for the first year's premium. Being reminded of this, he gave a note to renew the one following due, not taking up the renewed note, however, as it was not quite due, and remarked that he would attend to the second year's premium on his return. He went to St. Louis, and on the 22nd of September he, with his wife, took passage on the steamer St. Luke for some point up the Missouri River. Boswell and wife went on board the steamer some 2 or 3 hours before she started. The General spoke of not feeling well, received a friend or two in his stateroom, but no one remembers seeing him on board after the boat left the levee. His wife went to the supper table alone, and while at tea remarked to the clerk of the boat that her husband was too sick to come to the table. The clerk offered to send a cup of tea and something to eat to his stateroom, but she said no, he did not then want anything at all. Their baggage consisted of one small trunk, which was taken to their stateroom. About midnight, some little time after entering the Missouri River, Mrs. Boswell gave the alarm that her husband had fallen overboard. The boat was at once stopped, a yawl lowered, and a fruitless search made for the body. Mrs. Boswell's description of the accident, as set forth in her subsequent affidavit in support of her claim under the insurance policies, is as follows. At about 11:30 p.m. that night, Mr. Boswell complained of being unwell and needing fresh air. We went from our stateroom to the guard of the boat. Mr. Boswell seated himself on the rail with one arm around the stanchion, and wished for some water. I could find no servant to fetch it, and started for it myself to the stateroom which we had just left. As I neared the stateroom door, I cast my eyes back, and saw Mr. Boswell falling backward overboard. I sprang to catch him, but could not. I saw him reach the water, there was a splash, and all was over. No cry was made. I immediately gave the alarm, but it was some time before the steamer could be put about. Nothing was ever seen or heard of the body, though diligent search was made, and a reward of $100 was offered for it. He had on his person, in a pocket in his drawers, about $2,000, which he had received at St. Louis. Search for the body being abandoned, the boat proceeded on its way up the river, and the disconsolate widow went on shore at the next landing, where she waited for the down boat, and then returned to St. Louis. Due notice of loss, under their respective policies, was given to the insurance companies, the agent of one company closing his letter as follows: I would state that General Boswell was one of our best citizens, of the best habits, respected and esteemed by all who knew him. An investigation followed which led the Accident Insurance Company to believe the whole thing a fraud. At the time of these occurrences, the Muncie Local Board of the Franklin Life Company expressed their conviction that Boswell was drowned as alleged, but could not see that their policy upon his life was in force at the date of drowning, the policy having lapsed the day previous. The story of the General's accident was reasonable enough, and Mrs. Boswell's narration of it was given in an apparently sincere and earnest manner, with deep feeling, with tears, and in a natural tone of bereavement which enlisted in her behalf the heartfelt sympathies of the good people of Muncie. There was unanimity of sentiment in that community in their high estimate of the departed General, and in their sorrow for the stricken widow. But to the parties investigating the facts there were circumstances which seemed to cast a doubt upon the genuineness of the affair. Disappearances by drowning come to the frequent notice of accident insurance executive officers, and there are certain earmarks which seem to distinguish fraudulent cases from those which are genuine. These were observed in this case. The job, though well done, was overdone, and Mrs. Boswell was able to describe very accurately the precise spot where the General fell over the rail, and the very stanchion around which he had thrown his arm. A visit to this place on the steamer determined the utter impossibility of a person falling into the water from that point. He must have jumped overboard to have got into the water from that place, and a large guy rope would have prevented that, unless he ducked his head for the purpose of avoiding it. Again it was evident that he would have struck the lower deck or its rail, or a brace which at that point projects from the underside of the upper deck. This would have attracted the notice of the labourers who were at that time on duty there. Nothing of the kind was observed. There was no eyewitness to the alleged accident, save Mrs. Boswell, and no one could be found who saw Boswell on board after the steamer started. On the other hand, there apparently was no motive for perpetrating a fraud, especially by a gentleman universally represented as a straightforward businessman, honest, temperate, and widely respected. It was impossible to prove a negative, and the adjuster of the accident company, having on his hands at that time other and complicated cases of mysterious disappearance, concluded to offer to buy a peace with Mrs. Boswell, provided it could be done for a sum not greater than would be expected by the company in an effort to find the missing man. A meeting was therefore arranged, and the widow, through an administrator appointed for the purpose, discharged the company upon the payment of a sum agreed upon. The community generally regarded this action of the company as unjust in the extreme, and the company's agent in Muncie, as an expression of sympathy toward the bereaved, took the widow to his house and kept her for several weeks as the guest of his wife and family. The company's adjuster believed that through this settlement Boswell would be thrown off his guard, as there would be less necessity for his carefully hiding himself, and an arrangement was made with a local attorney to promptly advise the company concerning any future developments, which in the opinion of the adjuster were sure to follow. In due time the widow instituted her action against the Franklin Life Company upon the $1,000 policy above mentioned. The cause proceeded to its first trial and resulted in disagreement of the jury. The company's defence was upon the ground that the policy had lapsed at the time of Boswell's death. A second trial resulted in a verdict for the plaintiff, the jury finding that the third note given by Boswell was in payment of his second year's premium, while notoriously, as a matter of fact, it was a renewal of the note for the first year's premium. The verdict in her favour was for over $11,000. This verdict was set aside and a new trial granted by the Circuit Board. 3 years had now lapsed since Boswell's death, and the above-mentioned cause was pending in the Circuit Court, which was sitting in May 1874, when an unexpected dénouement startled the citizens of that vicinity. A few days prior to the time when this cause would have been reached upon the calendar, an executive officer of the Franklin Life, who had known Boswell personally, was notified that Boswell was alive and might be found in Galesburg, Illinois, under the name and title of Judge I.S. Hoey. He immediately went to Galesburg, and in a very short time after his arrival there, saw Judge Howe playing croquet with some ladies and gentlemen, and recognized him at once as the long-lost General Boswell. Not making himself known, however, he telegraphed to Muncie for another gentleman, who was well acquainted with Boswell, to come on at once to Galesburg. The gentleman did as requested, and the two called on Judge Howe, fully identified him, and compelled him to admit that he was Boswell. His story was that the fall into the river, and the compulsory bath of several hours therein, rendered him insensible, so that he did not know when or where he drifted ashore and was found. His first recollection was of being in the woods among wood choppers, who had rescued him, put him before a fire, and brought him to life again only to find his money and his memory gone. Having identified him, the two gentlemen returned to Indianapolis. From there they sent to Muncie, and had Mrs. Boswell arrested upon a charge of perjury and attempt to defraud. This arrest came upon the Muncie people like a thunderbolt. Mrs. Boswell for 3 years had lived an irreproachable life as a widow among them. No breath of suspicion had stirred the quiet waters. Mrs. Boswell's counsel having read the charges under which she was arrested, went to her and asked her to tell them the truth, the whole truth, that they might know what they must do in her defence. Without a change of colour or a quiver of her lips or eyes, she called on God to witness that if her husband was alive she did not know it, that she had not seen him or heard a word from him since he fell into the river on that fatal night, and that no money which the world contained could have tempted her to live so long away from him. So thoroughly was the sympathy of the people with her, and so suspicious did the alleged discovery of the living Boswell appear, especially as it was made just before the cause of Mrs. Boswell versus the Franklin life was to be tried, and as it was not verified by the production of Boswell's person, that it was with difficulty the prosecutors succeeded in having Mrs. Boswell bound over at her preliminary examination. She was bound over, however, and in default of surety went to jail. Meanwhile, the Railway Passengers Assurance Company was advised of the materialization of the drowned Boswell, and they at once sent a representative to Indianapolis. After consultation with the officers of the Franklin life, he went directly to Galesburg, only to find that Judge Howe had moved. Between 2 days he had been driven in a buggy to a station on the C.B.&Q. Rye, and had gone south. He had left behind him a trunk as security for a loan of $200. This trunk was searched and was found to contain several interesting relics. There were photographic pictures of Boswell and of his wife, books on masonry, Masonic regalia, etc., etc. There were also letters and other papers which fully established not only the identity of the parties, but conclusively showed the guilt of Mrs. Boswell. One of these papers was a receipt dated 3 days after the alleged drowning, and when Mrs. B. was in St. Louis, after her trip up and down the river. It read as follows: St. Louis, September 25, 1871. Received of I.S. Howe $40 for a lot of second-hand clothing and books belonging to my late husband, lost off the steamer St. Luke, on the Missouri River, September 22nd, 1871. Signed M. V. Boswell. It thus appeared that Boswell had left the steamer after changing a portion of his dress in his stateroom, having a change at hand in the small trunk they had brought with them for the purpose. He had gone ashore unobserved before the steamer started, and remained in St. Louis until his wife's return, when she met him as per agreement, delivered to him his clothing left on board, and he at the same time took from her the foregoing receipt, so that in the event of his being caught with his own clothes on, or while reading one of his own books, he could prove by this receipt that he bought the clothes and books of Mrs. Boswell, who in her kindness went so far as to certify they were property of her late husband, who had been lost off a certain steamer in a certain river at a certain date. Exceedingly attenuated. From the correspondence found in this trunk, it was ascertained that Boswell and his wife had been in frequent communication. Her letters to him were addressed as though written to her niece Ida, and signed "Your Aunt Mary." One of these letters reads as follows, but requires a word of explanation to be understood. It is undisguisedly in Mrs. Boswell's handwriting, and written to her husband from Fort Wayne, Indiana. Allusion is made to one of Mrs. Boswell's attorneys, and his wish that she should go to Xenia to take a deposition for use in the suit against the Franklin line. Boswell's letter in reply was to be sent to Xenia, thus to avoid the possible recognition of his handwriting by the Muncie postmaster. The letter is herewith produced verbatim. Fort Wayne, April 17, 1874. My dear niece Ida, I am here yet, hope this will find you well. I just received a letter from Buckles telling me to come on and go to Xenia to take John's deposition. I will be here today or tomorrow. You write me at Xenia. I will, if nothing happens, I will be there by Wednesday next. I have been waiting for money. I hope to get it all right. If I only had plenty here, I could get along, but hope I will get all right before long. I hope to get through, then I will see you just as soon as I can. Hope this will find you in good health. This leaves in good health. I hope to have all things right yet. I live in hopes if I die in despair. Do take good care of your health till I see you. Keep in as close as you can till you get through with my medicine. Then you will be all right, I hope. I got those presents. I was glad to get them. Hope you have my letters in this time. I'm in a hurry. I will write when I get there. I will close. Much love to all and plenty to your dear self. May God be with you and bless you, is my prayer. Take good care of your health. I will direct this to you, so you sign your full name, Ida. Then it will be right. Then if it should be, there are a few illegible words here, it would be sent back to you. Write to Xenia, I will be there soon. Goodbye till you hear again. Your Aunt Mary. With the pictures of Mrs. Boswell found in the trunk, it was easily ascertained that she had visited her husband in Galesburg, boarding for 2 or 3 weeks at a time in the same house with him, and passing herself off as his niece. The rest of the story is soon told. The proof was so conclusive against Mrs. Boswell that when her trial came on, her attorneys admitted the facts as claimed by the prosecution, and she received the sentence of the court for her crimes. Boswell, alias Howie, after a long chase was captured in northern Michigan, taken to Muncie, July 1st, 1874, where he was recognized by everyone who saw him, and thence taken to Indianapolis and lodged in jail. His trial was delayed several months through the efforts of his attorneys, and at last, broken in health and wrecked in reputation, he was released on bail. He finally escaped further punishment through a legal technicality, on the ground that a man and wife could not conspire, and rejoined his wife, who had served out her term of imprisonment. They have gone forth without money, health, friends, or reputation, and are left to meditate upon the results of their attempt to defraud the insurance companies. They suffered prolonged separations from each other, privations and hardships of no light degree, imprisonment and disgrace. They lost all that is worth having in this life, and are able to offset these fearful facts with a knowledge of having realized, for all this, a little more than 400 of the insurance company's money. End of section 13. Section 14 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Piotr Natter. Stratagems and Conspiracies to Defraud Life Insurance Companies. An authentic record of remarkable cases. By John B. Lewis and Charles C. Bumble. Mysterious Disappearances. Part 4. A Savannah River Case. In the county of Scriven, state of Georgia, on the banks of the Savannah, dwelt Captain Martin L. Bryan, formerly of the 25th Regiment, Georgia, Confederate States of America, a well-to-do citizen of about 50 years of age, owner of 1,500 or 2,000 acres of land on the river bottoms, and whose house had been burned by the army that escorted Sherman on his celebrated march to the sea. The captain had lost much of his property during the late unpleasantness, and resolved to protect the interests of his family by obtaining life insurance. He went to Savannah, called on the insurance men, and obtained a $10,000 policy in the Knickerbocker Life of New York, $10,000 in the accident of Columbus, $10,000 in the casualty of New Jersey, $10,000 in the National Travelers of New York, and $40,000 in the Travelers of Hartford, $80,000 in all. Subsequently to the intense grief of deploring friends and relatives, the captain was drowned in the river, but while they lamented his death, they commended his prudence, and in due time a huge bulk of documentary evidence of death, certified to with all official formalities, was forwarded to the companies. The so-called proofs of death cover no less than 40 pages of closely written legal cap paper, wherein is set forth, with minuteness of detail, time, place, and circumstances of the captain's death by drowning, with repetitious asseverations of the high note and gentlemanly character of the deceased. These papers were prepared with great care by the captain's son, a law student, who did himself credit, in a certain way, by the lawyer-like, consistent, and conclusive manner in which the evidence was presented, leaving no reason, apparently, to doubt that the death occurred as stated. The first affidavit is that of Hansford R. Owens, who, being duly sworn, said that he was intimately acquainted with Captain Bryan, the deceased, and had known him familiarly for many years, living within a mile of him; that in the early part of the year 1867, deceased engaged deponent to assist him in the survey of some of his swamplands lying in Savannah River marshes, and that on the 10th day of June of this year, deponent and said deceased, together with Curtis Humphreys Sr. and Joseph C. Bryan, son of said deceased, did proceed to survey said lands; that after said survey was finished, they caught, cooked, and ate a mess of fish, after which deponent and deceased started to remove a bateau belonging to said deceased. They proceeded to said bateau, loosed it, and started down the river in it, getting pretty fast, as said bateau was a new one, and they were in a measure testing its speed; that after going about a quarter of a mile, said bateau struck a snag, not directly with its bow, but on the right side and about 3 feet below the bow, so that the bateau was suddenly thrown right across the current of the stream; that just as said bateau struck said snag, it was elevated by it on the right side, so that deponent and deceased were both thrown across to the left side, which caused said bateau to dip water considerably, and before they could right themselves and regain their seats in the central part of said bateau, their weight on the left side and the force of the current, which was very strong and rapid, the bateau being by this time right crosswise the current and presenting a broadside to it, caused said bateau to be filled with water and almost immediately overturned, by which deponent and deceased were both precipitated into the water and submerged; that as soon as deponent came to the surface, he heard deceased say to him, "Catch the boat," and did not at the time think that deceased was alarmed, but being rather a poor swimmer, instead of trying to save the boat, he began to swim for the bank, thinking that deceased would either follow or would cling to the boat, and accordingly did not look around till he had reached the bank, when to his surprise and alarm he discovered that deceased was neither following him, nor clinging to the bateau, nor could be seen anywhere, and the conviction at once settled upon deponent that deceased had drowned and sunk, for the river was open and at least 150 yards wide, and not a sign of life or motion in the water could be seen anywhere around. Deponent crawled out on the root of a tree which had been blown down in the river, against the top of which the bateau made a temporary halt, and he walked out on the tree for the purpose of fastening the bateau, but before he could reach it, it had become loose and floated down the river. Deponent also says that he was not more than half a minute in effecting his escape from the water, and that deceased, from the position he occupied in the boat, being on the middle seat, was thrown some 10 or 15 feet farther out in the stream than deponent was, so that it was impossible that deceased could have reached the bank sooner than deponent reached it, and there was no place in the river for him to have concealed himself, nor even under the bateau, as that was too full of water when it overturned to leave air enough underneath for a man to have lived in. Therefore deponent is confirmed in the conviction that first seized him, and now feels and knows from all the circumstances that deceased could only have drowned and sunk before deponent reached the bank. Deponent further says that, So soon as he recovered sufficiently from his fright and bewilderment to realise his condition and the state of affairs, he began to cry for help and to halloo for the companions he had so lately left, to wit the said Curtis Humphreys and Joseph C. Bryan, but that he found himself so badly hurt he could with great difficulty cry loud enough to be heard by them, though not more than a quarter of a mile distant; that, failing to make them hear him, he ran as fast as he could to them, and at once communicated the nature of the accident which had happened, and that himself and said Joseph C. Bryan immediately ran back to the place of the accident, and at once commenced a search down the river along the bank, but they could neither see nor hear anything except the bateau, which was found stopped about half a mile below. Deponent further says that in all his acquaintance and dealings with said deceased, which have been long and varied, he has ever known the deceased to be an honest and upright man and dealer, and a gentleman of high tone of character and integrity of purpose, and that the community as well as his family have sustained a loss. Deponent further says he knows deceased owned, in said county of Scriven, between 1,500 and 2,000 acres of good land, several hundreds of which were improved and in a state of cultivation. Next follows the affidavit of Joseph C. Bryan, the eldest son of Captain Martin L. Bryan, 29 years of age. This eldest son of his father proceeds to corroborate the statement of the preceding affiant, and tells how they assisted the deceased to survey the land, and then caught, cooked, and ate a mess of fish, after which deceased and Owens left them in the manner which has been related, first enjoining Deponent in the meanwhile to catch bait for his uncle Kurt, meaning the said Curtis Humphreys, who was still desirous of fishing, but was too aged and unwieldy to procure bait. Some time after they had gone, Deponent heard the feeble shouts of Owen, but was not alarmed by them, as they did not sound to him like cries for help, and therefore, without heeding them, he continued to catch bait, until Owens arrived in person with the startling intelligence that the bateau had capsized, precipitating both himself and deceased into the water, and that deceased, he felt certain, was drowned, while he had barely and with great difficulty escaped. Then this filial Deponent, under the wildness of his bewilderment, started off without loss of time, followed by Owens, who pointed out to him the spot of capsize, and then followed a fruitless search along the river bank, at the same time hallooing instantly, so that if deceased were not dead he might hear them and bring them to his relief. But no response from deceased was heard by Deponent, and night being close at hand, they abandoned their efforts and returned to their homes. The next day Deponent, assisted by neighbours and friends, resumed the search, and grappled and dragged and fished and felt for the body of said deceased, but without recovering the body or finding any trace thereof. Deponent then explained wherefore the body could not be found upon such a river bottom as the place where said accident happened. The locality is thickly crammed and studded with large fallen trees, so that the logs and brush form an almost impenetrable network, and the neighbours and friends finally arrived at the conclusion that a body therein lodged could hardly rise, unless by the motion and concussion of the river caused by the passage of a steamboat. Deponent at great length proceeded to point out the conformity to rational principles which characterized these conclusions, and then, without mental reservation, but knowing whereof he doth depose, he further says, nothing was seen of said body and no tidings had of it until the evening of the 16th of June, when it was seen in the Savannah River, about 8 or 10 miles below the place of accident, by a portion of the crew of the steamer Swan, on her down trip from Augusta to Savannah. The next day after it was seen, as aforesaid, Deponent and his 3 brothers, Robert, William, and Paul, set out in quest of said body, they going down the river till they came to the spot or place where said body had been seen the evening previous, and looked and examined closely for it, but that it was not there, nor could they see it around there, nor even find any trace or vestige of it. Whereupon Deponent proceeds to enlighten us why it could not be found. Again he explains why the concussion of the river caused by the passage of the steamboat must have loosed the body from its fastening, and it had floated on down the river. They continued to search and were rewarded only with disappointment. Finally they arrived at some further conclusions. Not another passing steamboat, with its concussion of the river this time. Concluding that the body must either have been pecked open by the buzzards and again sunk, or was devoured by an alligator or some other carnivorous inhabitant of the water, and that in either case further search down the river would be fruitless, the bateau was placed in the waggon and all parties started for home. Meeting with other parties, the deponent was advised to make a still more extended and protracted search, and he returned to make a closer inspection, but finally fell back upon his strong point, his conclusions, which are summarized as follows. All of which facts lead the deponent to the belief, and confirm him in the conclusions before mentioned, either that said body was pecked open by the buzzards and again sunk, or it was devoured by an alligator, of which there are multitudes in the river, or by some other animal. The deponent then goes on to relate how said deceased was not a good swimmer and was rather fearful of deep water, and was usually very cautious and particular when out in the river in a bateau. Finally, and in conclusion, he does not know how to account for the mishap, except that it was one of those unaccountable accidents which, while they are under the superintendence of an all-wise Providence, seem still to be the result of chance, in that they are without assignable cause, controlled by no fixed or known laws or rules of conduct, or action, or sequence, and are as likely to overtake the most prudent as the most reckless. The aged Uncle Curt, meaning the said Curtis Humphreys, was next brought forward as the deponent, who could testify that he was intimately acquainted with Captain Bryan, deceased, and had known him since his infancy. He then repeated the story of the survey of the swamplands which belonged to this deceased, and of his partaking of a repast, after which the venerable deponent wanted to go home, but the deceased begged him to wait a short while until deceased and said Owens could first go after the boat as has been related by the preceding witnesses. After they had been gone a while, this deponent heard the hallooing of Owens, but he was not disturbed thereby, as he imagined they were hallooing at something they saw in the river, perhaps a deer or an alligator with something it had caught. Uncle Curt is not prolix in his deposition, but desires to put himself on record by saying that, from everything that transpired under his own observation, he was fully impressed with the conviction that said deceased was drowned. The neighbours and friends of the deceased who grappled, dragged, fished and felt for the body of said deceased, personally and individually entered their appearance, and in their several depositions set forth at great length their knowledge of the misfortune which had that day befallen the aforesaid deceased. A glowing tribute to the elevated moral character and the unswerving integrity of the aforesaid deceased appears upon the record of these depositions, while in all his dealings and business deceased was plain, open, straightforward, honest, fair, correct and exact, never appearing to want that which was not rightfully his own, and rather ready to yield a little than to demand too much, or to contend about a trifle. Next come forward the 3 employees on board the steamer Swan, who relate what they know of the deceased aforesaid. They testify that they were acquainted with the circumstances of the accidental drowning, and one of them, a person of colour, had been directed to keep a lookout for said body. At a place about 12 miles by water below the place of accident, the deponent had his attention directed to a dead body under the willows. When he first looked at said body it was lying face downward. He saw the back part of the head of it, and he firmly believes it was a human head. And the deponent believes, from all the circumstances of the case, that said body was the body of said deceased, the said Captain Martin L. Bryan. This coloured deponent further says that said steamer was at the time going very rapidly, so that only a very short time was allowed for beholding said body. The attention of the second employee being directed to a dead body fastened in the river under a willow, expressed his belief that it was a human body. He further goes on to explain that, as he had not heard of anyone else drowning in the Savannah River, nor had he since heard that anyone else than the said Captain Martin L. Bryan was so drowned, ergo the said body, thus seen as aforesaid, was the body of said deceased, the said Captain Martin L. Bryan. This logical deponent did not see said body till the waves of the boat had reached it and were moving it, so that nothing about it could be distinctly defined by deponent. He was able to define some buzzards near by, and was informed the buzzards were on the body pecking and devouring it when first seen, but which the waves had frightened off before it was seen by deponent. Deponent further says that so impressed was he with conviction that said body was the body of said deceased, that he immediately ran upon deck and tried to prevail upon the purser of said steamer to use his influence with the captain of said steamer to stop and take up said body, but the purser said deponent had as much influence with the captain as he, the purser, had, whereupon deponent at once proceeded to the captain, who was also aware of the circumstances attending the death of said deceased, and who also knew that deceased's body had not then been found, and informed him of the discovery which had just been made, and tried to prevail upon him to stop, being then but a short distance below, and pick it up. That the captain asked the deponent if he was certain and knew it was a human body and the body of said deceased, to which deponent replied that though he felt certain, he did not positively and absolutely know it to be the body of said deceased. That the captain then said as deponent was not absolutely certain, he would not stop, but proposed instead to give information at the next landing, and so that aforesaid deceased was left to the tender mercies of the buzzards, the alligators, or some other carnivorous inhabitant of the water. One other deponent was produced and sworn, and made known that on the 19th of June, 3 days subsequent to the discovery from the steamer, while he was on his way up the river, at a certain point he discovered a dead body in the river, which he is convinced and knows was a human body, but being alone, and feeling a timidity and hesitancy in approaching a dead body alone, without company, he did not then go up to it. This timid deponent further says that buzzards were sitting near and devouring said body, which seemed to be much swollen and was floating high in the water. Being familiar with the circumstances of the drowning of the aforesaid deceased, and knowing that the body had not yet been recovered, this timid and hesitating deponent obtained within him the impression at once that the said body thus seen as aforesaid was the body of said deceased. To the underwriters receiving these preliminary proofs of death, they presented the appearance of a studied effort on the part of the person submitting them to explain away suspicion and present a plausible view of his case. It required but the superficial glance of an experienced eye to observe something wrong. Just prior to his mysterious disappearance, Captain Bryan had made his last will and testament, and had named his son, Robert B., the law student, as executor thereof. The busy and tireless hand of the embryo lawyer appeared early in advocacy of the claims arising under the several policies. He addressed by letter the local agents of the several companies as follows: Savannah, Georgia, June 27, 1867. Dear Sir, as executor of the will of my father, Martin L. Bryan, it becomes my sad duty to announce to you the intelligence of his death, which occurred by drowning near his plantation in Scriven County on Savannah River on the 10th instant. The circumstances of the accident are these, as I have learned them. Mr. Owens, a near neighbour, and my father, after a day of fishing, were removing their boat from one point in the river to another, when the boat was capsized by running on a snag. Mr. Owens, with much difficulty, and in a badly hurt condition, succeeded in getting out, but Pa, alas, was not so fortunate, and what is still more distressing, we have never been able to recover the body. We have made every effort to recover it, but without success. It was seen by the crew of a steamboat on Sunday afternoon, about 9 miles below the place of accident, but through want of a small boat, the captain said he could not take it up. I should have informed you sooner, but have been by rain and other causes unavoidably detained away from the city much longer than I anticipated when first I heard of the accident. I desire you to communicate with the insurance company in which my father's life was insured, and let me know their decision. I am aware that the facts of the case will have to be submitted by affidavit, and I will proceed to submit them after hearing from you. The proof, I think, will be satisfactory. Very respectfully, R. B. Bryan. An agent of one of the companies wrote to R.B. Bryan for additional information relative to the amount of insurance, and received the following in reply: Savannah, Georgia, August 28, 1867. Dear Sir, in compliance with request, I transmit you the names of the companies in which my father's life was insured and the amounts in each. Travellers of Hartford, $40,000. Knickerbocker Life, $10,000. United States Casualty, $10,000. Accident of Columbus, $10,000. National Travellers of New York, $10,000. You will naturally ask the question, why did he take so much accident insurance and so little life? A question which I am not able fully to answer. But in partial answer I would first say that Pa, though by no means wealthy, was, previous to his being stripped by the war, independently well off in the world, and after the fortunes of war had swept off most of his means, to a mind like his the idea of leaving his family nothing at his death was almost intolerable, and thus he sought insurance. He was almost wholly ignorant of the nature and character of it, as you will recollect on the day he first entered your office. Finding that accident insurance was much cheaper than life insurance, and believing that it would be some time ere the course of events would take him off, being a man of strong and hearty constitution, he contented himself, for the time being, with $10,000 of life insurance, but took accident insurance to the amount of $40,000. Being at that time unacquainted with the matter of compensation, he took only $10,000 with compensation. Finding afterwards that compensation was just what he wanted, he himself and family were, in a great measure, dependent upon his own individual exertions, and that, should those exertions, through any cause, cease, they would become dependent upon others, an idea or a possibility that was always galling to him. He petitioned in all subsequent insurance for compensation. In fact, compensation was the prime cause of his seeking individual insurance. I am, very respectfully, R.B. Bryan. Again writing at the agent while endeavouring to appease the spectre's suspicion. He had not been called upon to explain the motives of his father in obtaining the insurance. Upon investigation it was soon ascertained that the proofs which Mr. R.B. Bryan thought would be satisfactory were the product of an ingenious though inexperienced hand at manipulating evidence, nor did the moral character or the domestic relations of the deceased aforesaid appear creditably in the light of further inquiry. It will be noticed that there had been but one eye witness to the accident, and he was found to be a worthless drunken pauper. He was sober at times, but only when unable to get the wherewith to buy whisky. After the drowning he went at once to a store, where he purchased 2 quarts of whisky, being able to pay for it, a fact which was too unusual to escape observation and comment. He had a glorious drunk that afternoon, and the next day he received from Savannah 2 gallons more of whisky, which some good friend had sent him. From the time of its receipt until the last drop was consumed, he was too happy to trouble himself about the deceased, and naturally he was excused from being a party to the search for the body. At that time, too, he had in his household a woman who had gone there with her illegitimate child, then about 2 years of age, the paternity of which she had laid at the door of the deceased aforesaid, and on account of which domestic irregularity, it was rumoured that the lawful wife of the deceased threatened to leave his bed and board. Notwithstanding this, the general character of the captain as a business man stood favourably with the community. After a while, as the investigation proceeded, it became evident that the executor of his father's last will and testament began to be more and more apprehensive. The spectre was continually presenting itself to be explained away until it could be no longer endured. Then, after lying some 6 months among the snags, pegged by buzzards, devoured by alligators and other carnivorous animals, the deceased, through earnest entreaties and united appeals, was induced to return to the bosom of his family. A rumour of the wanderer's return reaching the Savannah agent, he wrote and mailed a letter addressed as follows: Savannah, Georgia, January 21st, 1868. Mr. R.B. Bryan. Dear Sir, I learn by rumour that your father, M.L. Bryan, has returned to his home in Scriven County. Is it correct? I ask this as agent of the insurance company, and in view of the fact that proofs of loss have been handed into this office by you. Please give this matter your attention and oblige." Which letter elicited the following reply: Savannah, Georgia, January 21st, 1868. "Dear Sir, yours of present date is received. In reply I am glad to be able to inform you that my father is again at home, where I trust he will be allowed to remain in peace and safety. I make no comment for the present upon his absence or return, further than to say that the latter was induced only by the earnest entreaties and united appeals of his family, but for which he might still be an exile from home. I hope such entreaties and appeals may not be rewarded with another forced separation. I have not seen him, but my information is positive and not to be doubted. Any information I can impart, consistent with the present uncertain state of affairs in relation to this matter, I am ready to give. I am, very respectfully, R.B. Bryan. It thus appears the deceased aforesaid was induced to return home only by the earnest entreaties and united appeals of his family, which would seem to indicate that his family, including the executor of his father's will, and who made up the proofs of death, knew of deceased's whereabouts and held communication with him in spite of the buzzards and alligators. And mark the hint at another forced separation. The emphasis is his own. Was the first separation forced? Does the sensitive conscience of the legal-minded son suggest that such an attempt at wholesale robbing of insurance companies deserved a forced separation, for a term of years in some state institution? Prior to the foregoing correspondence, information of the exile's return had reached the home office of the Travellers' Insurance Company through the following telegram and correspondence: Savannah, Georgia, January 13th, 1868. Rodney Dennis, Esquire, Secretary, Travellers' Insurance Company. Martin L. Bryan is at home alive and well. You did not pay soon enough. In due course of mail came the following letter: Savannah, Georgia, January 14, 1868. Rodney Dennis, Esquire, Secretary, Travellers' Insurance Company. Dear Sir, I telegraphed you that Bryan was alive and well at home. You know Ponce de Leon found the waters of perpetual youth in Florida, and it is reported that Captain Bryan has been in Florida. Now he either floated through the rivers, sounds, and bays to that spring and came to life, after being 7 months dead, or else he has been permitted to come back and find out why the $80,000 insurance on his life was not paid. If you had only paid up sooner, his unquiet spirit might have rested peacefully in its watery bed. It is either a warning to insurance companies to be more prompt in payment of losses, and not oblige a man to come back and collect the insurance on his own life, or else it proves that to secure the return of departed ones, they must be drowned in Savannah River and go to Florida. End of section 14.
Section 15 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Craig Abbott. Stratagems and Conspiracies to Defraud Life Insurance Companies. An Authentic Record of Remarkable Cases by John B. Lewis and Charles C. Bombaugh. Mysterious Disappearances, Part 5. Charles and Martha. Charles and Martha. In the summer of 1870, Charles McCormick, the hero of this narrative, was 24 years of age, of good physique, being nearly 6 feet in height, weighing 180 pounds, and altogether a lusty specimen of the Green Mountain Boy. Early in the history of the late war, he enlisted as a private soldier in the 7th Regiment Vermont Volunteer Infantry, and, creditably serving out his full term of enlistment, obtained an honorable discharge. In 1867, he married a highly respectable young woman, and not long afterwards opened a general insurance agency in Ogdensburg, St. Lawrence County, New York. With the companies he represented, his business relations were favorable. while his social standing was not questioned in the community where he had chosen his residence. Later developments showed him unworthy of the respect and confidence in which he was held at the date of a mysterious disappearance, an event which occurred on a hot summer afternoon in the month of August, 1870. His wife held a policy written upon his life by the Travelers Insurance Company. The proofs of death submitted by her, in support of her claim for the principal sum insured, sufficiently explain the manner of his mysterious departure. According to the evidence thus submitted, the deposition of one H. A. Rockwell informs us that for several years last past he has resided and now resides in the town of Massena, St. Lawrence County, New York, and that he knew Charles McCormick, late of Ogdensburg in said county, and last saw said McCormick at the residence of this deponent in Massena, under the following circumstances. On the 19th day of August, 1870, said McCormick came to the residence of this deponent with a horse and buggy, and informed this deponent that he, the said McCormick, wished to leave his horse and buggy with this deponent, and to borrow this deponent's boat to go to Cornwall, across the St. Lawrence River in Canada, and would return it to deponent on the Saturday or Monday following. He declared his intention of proceeding from Cornwall by rail to Prescott, and from Prescott by ferry to Ogdensburg, and return to Massena over the same route the Saturday or Monday following. That this deponent took charge of said horse and buggy, as requested by McCormick, to keep until his intended return, and let this deponent's boat, a skiff containing 2 oars, 1 paddle, and a tow line, to said McCormick, to go with it to Cornwall. That, at the time aforesaid, and before McCormick left this deponent's residence, he informed this deponent that he, McCormick, had an engagement to keep at Ogdensburg, and had promised to meet a person there from Canton, in said county, on business, and had sent word to said person that he, McCormick, would meet him at Canton on Saturday. That, in pursuit of such purpose and intention, as deponent believes, McCormick, with deponent's boat, oars, etc., as aforesaid stated, left deponent's residence to go to Cornwall, at about the hour of 6 o'clock in the evening of said 19th day of August, and that deponent has not since seen nor heard of said McCormick. Deponent further says that on Monday, the 22nd of August, 1870, and after the time fixed for the return of the boat, deponent went to Cornwall to look after the same, and found the said boat with only 1 oar and the tow line therein, about 2 rods below the wharf at Cornwall, where said boat was lodged against the shore, and not tied or fastened, but lying as having been, apparently, blown or drifted to the shore by wind or current. And deponent further says, the usual route of ferriage from Massena to Cornwall, and that which McCormick proposed to take, is difficult, and to persons inexperienced, somewhat dangerous to navigate, and that the route from Massena to Ogdensburg, as proposed to be taken by McCormick, is frequently pursued by persons traveling from Massena to Ogdensburg, and is the only route by rail for any considerable part of the distance. Deponent further says that McCormick, in his attempted journey across the river, would not be likely to arrive at Cornwall, if successful in meeting no accident, until after dark on said 19th day of August, and that deponent has never found the oar and paddle missing from the boat. In the furtherance of these proofs, Mrs. McCormick, wife of the late Charles, and now his widow, subscribes to an affidavit of great length, wherein she gives a detailed account of her knowledge of her husband's usual business habits and of his movements during the 3 or 4 days immediately preceding his disappearance. She mentions the date of her marriage to McCormick, and says that she resided with him continuously and happily as his wife thereafter. It appears that she and her husband were boarding in Ogdensburg with a Mrs. Kellogg, and that they left their boarding place to go to the residence of her father in an adjoining town, where she intended to remain until her husband should rejoin her there, on his return from one of his usual traveling tours, and convey her thence to their home in Ogdensburg. On the following day, the 15th day of August, 1870, McCormick left her at her father's residence, driving away with his horse and buggy, having first declared his intention of going to the several villages mentioned by name in her affidavit. She further says she has not since seen nor heard from her husband, directly or indirectly, and has had no information of or concerning him, except that derived from her father and others who have been in pursuit of facts touching his fate. She states that she received one linen coat, one linen bosom, and one tape measure from her father on or about the 26th day of August, 1870, and that said articles and a small hand satchel and contents were the only articles taken away by the said Charles when she last saw him, and that said satchel and whatever it may have contained has not been returned to her and has not been found to her knowledge and belief. In her affidavit, she further says McCormick left at their boarding place his entire personal wardrobe, not necessarily in use by him when she last saw him, which, together with the articles returned to her, and the horse, harness, and buggy used by McCormick, one cutter, bells, sleigh robe, and utensils, and articles used by him in taking care of his horse, and the furniture in the rooms occupied by herself and her husband at said Mrs. Kellogg's, constituted the entire personal property of the said Charles when she last saw him, and that he had no real estate at the time of his disappearance. We next have the affidavit of Mrs. McCormick's father, who corroborates the statements of Mrs. McCormick and of Mr. Rockwell, so far as his knowledge of the facts enables him to. This affiant further says that early in the week following the 19th day of August, 1870, he was informed by telegram from Messina of the disappearance of the said Charles, and of the finding of the boat mentioned in Rockwell's affidavit, and that on the morning succeeding the receipt of telegram, he went to Messina, and from Messina to Cornwall, with said Rockwood in search of the said Charles, and spent the remainder of the week in such search, without acquiring any knowledge or information of said Charles' whereabouts, or of his being alive or dead. That he, together with his son and Lewis Rockwood, on Tuesday of the week following, proceeded to Messina and Cornwall and the vicinity to make further and complete search for said Charles, and to ascertain what may have happened to him, and made all examinations and inquiries believed to be effectual for the purpose of ascertaining such facts as could throw light upon the disappearance and whereabouts of said Charles, whether living or dead, and in the pursuit of such purpose visited the shores of islands of said St. Lawrence River for considerable distances, and made inquiries of persons living in such vicinity relative thereto, and pursued said river and vicinity in such search and inquiry as far as the city of Montreal and back, during an absence of 7 or 8 days. That he was informed and believes that said Charles was not seen on the Canadian side of the river on the said 19th day of August, 1870, by any person or persons who, in the ordinary cause of business and travel, would have seen him had he landed and pursued his way to Ogdensburg via Prescott, as stated in the affidavit of said Rockwood. That he was informed by the bridge tender who was present at and in attendance on the drawbridge that spans the Cornwall Canal, in the line of travel from the shore of the said river to Cornwall, that said Charles was well known to said bridge tender, and that said Charles did not cross said bridge on the 19th day of August, 1870, before or after dark. And he was also informed by the ticket agent of the Grand Trunk Railway that said Charles was not at Cornwall on said 19th day of August, or afterward, to his knowledge. He was also further informed by the driver of the omnibus running to the depot of said railway, and present there on the evening of said 19th day of August, that he was well acquainted with said Charles, and saw nothing of him at the depot on the arrival of the train on its way to Prescott. And Affiant was informed by several persons in Cornwall, acquainted with said Charles, that nothing had been seen of him there, to their knowledge, on the day last aforesaid. And further, since receipt of the telegram, this affiant has spent more than 3 months and has expended in cash over $300 for the purpose of ascertaining the fate or whereabouts of said Charles, without success. Mrs. Kellogg, with whom McCormick and his wife boarded in Ogdensburg, was produced and sworn in further support of the claim arising under the insurance policy. From this affidavit, it appears that 3 days after leaving his wife at her father's residence, McCormick returned to Ogdensburg, making his appearance at Mrs. Kellogg's on the morning of the 18th of August. Mrs. Kellogg says he came with his horse and buggy, breakfasted with her, and then drove away to attend a funeral. Before leaving, he informed her that he had an engagement to meet a person from Canton on Friday morning, and would return to her residence with his wife on Friday or Saturday following. She further says that McCormick and wife boarded with her for about a year prior to and up to the time of his disappearance, and that during the period of her acquaintance with them, they lived agreeably and happily together. Upon the foregoing evidence, together with other circumstances of a corroborative character, Mrs. McCormick honestly believed her husband to be deceased, and that the time and manner of his death were as clearly indicated as evidence of a purely presumptive nature could determine. This evidence was forwarded to the insurance company 5 months after the disappearance, and little doubt existed in the minds of the community at that time that Charles McCormick had been accidentally drowned. But the company already had had its suspicions awakened as to the genuineness of the drowning, and had instituted some inquiries which led to a belief that Charles was not lying in the cold embrace of the St. Lawrence. It was ascertained that when McCormick returned to his boarding place on the morning of the 18th of August, he donned his best clothes. True, he was going to a funeral, but he did not come back afterwards and exchange the suit. He attended the funeral, after which he loitered about until afternoon, when he left, saying he was going to Messina to make collections. On his way there, he was met by an acquaintance, who spent a while with him and had an opportunity to observe that McCormick had a considerable sum of money in his possession. He spent the night in Messina, ostensibly at the hotel there, but it was known that he was at the house of a certain woman in that vicinity, sufficiently long to occasion comment by some uncharitable neighbors. The next morning, August 19th, he again called at the woman's house and bade the family goodbye. He spent the day in loafing about, and then, towards evening, drove to the house of Mr. Rockwood, where he left his horse and buggy and procured the boat as set forth in Rockwood's deposition. He had proposed to return to Ogdensburg by rail through Canada, when he might have driven back there as easily as he had driven from there, the distance being about 30 miles. It was pretty certain, too, there was a woman in the case, and a woman not his wife. At this stage of the narration, we may introduce Martha, a comely young woman who had been deserted by her husband while living in a distant western state. As a grass widow, she had been successful, having lived an adventurous life, and had accumulated money among the gamblers and speculators who followed the construction of the Pacific Railroad. Martha had a sister and other relatives residing in the small town of Governor, which is quite near the place where McCormick was last seen, and to this home, in her native village, Martha returned from her wanderings. She was living here at the time of McCormick's disappearance, and it was well known by certain persons that she and Charles had been on intimate relations. Martha's sister was a little piqued with the fact that such relations existed, as, prior to Martha's return home, Charles had been kindly attentive to herself. So the sister was inclined to talk with the special, who was in pursuit of knowledge under difficulties, and she remembered how Martha had told her, just before the happening of the drowning, that Charles was going to leave this little town and would keel up on the bottom of the St. Lawrence River in less than a week, after which he would go west, and there let his mustache grow, so that no one would know him. Furthermore, she had reason to believe that Martha had been in correspondence with Charles since his disappearance. She had seen and read part of a letter which Martha was then writing to Dear Charlie, dated September 9th, and the sister was sure that, up to the date of McCormick's disappearance, Martha had no correspondent by the name of Charlie. The village post office clerk remembered how Martha had wanted him to get an Ogdensburg newspaper of the next week for her. He did so, and when she called the next week for it, she directed his attention to an account in the paper of McCormick's accidental drowning. Martha's sister enlarged upon this fact, and remembered that Martha brought the paper home and, showing the account of the drowning, said, "Did I not tell you he was going to keel up on the bottom of the St. Lawrence River?" Some weeks after McCormick's disappearance, after all excitement had subsided, Martha went west again. Exactly where she went or how she lived during the ensuing 10 months is not fully known. As the matter thus stood, the insurance people believed that a demand to recover under the policy would not be urged against the company, and for a while nothing further was done to solve the mystery. The claim was supposed to have been virtually abandoned when, the following spring, the company's attention was again called to the matter by the legal advisor of Mrs. McCormick. There had been periodical rumors of the discovery of McCormick's body, and one of the reports, which seemed to call for an investigation at the hands of the insurance company, may be alluded to at this point. The skeleton of a man was found on the Canada shore in May 1871, and it was announced that these were the bones of the missing Charles. But an examination disclosed the fact that the bones were those of an elderly person, which fact the numerous gray hairs found upon the skull fully confirmed. Charles had never seen one half the number of winters that had passed over the head of this skeleton. It was observed that these remains were clothed in a heavy, thick, woolen suit, over which was a heavy broadcloth overcoat, closely buttoned up, indicating wintry weather at the time this person perished, whereas McCormick disappeared in August, upon one of the warmest days of that particularly warm month. About this time, the latter part of May 1871, some new facts came to the knowledge of the insurance company, which had the tendency to divert attention from the information which had been obtained from Martha's relatives. As the facts herein alluded to came to the company confidentially, and with the request that the particulars as to how they were obtained should not be divulged, we are unable to publish that which would otherwise be an interesting feature of this story. It will have to suffice our present purpose to say that there existed good reasons for believing that the missing Charles was then in Girard, Kansas, or somewhere in that vicinity, within the knowledge of one Henry E. Perkins, a resident of that place. Upon inquiry, it was ascertained that this Perkins had been an army comrade of McCormick, they having enlisted in the same regiment and company, where they served and messed together nearly 4 years. It was decided to send an experienced agent of the insurance company to Girard for further developments. Accordingly, a pro tem detective made his appearance, incognito, in Girard towards the latter part of June, and at once entered upon his task. Some 2 or 3 weeks were spent in a fruitless search, during which time an acquaintance with Perkins was formed, but only to learn nothing satisfactory concerning the missing McCormick. Perkins finally suspected the purpose of the agent's visit to Girard, and thereupon, seeking a private interview, unbosomed his suspicions and made known his entire ignorance and innocence of the matter. He feelingly expressed his willingness to furnish any and every aid or assistance in his power which would lead to the discovery of McCormick, if living. Whether Perkins' statements were true or false, it was now clear that nothing further was to be accomplished in that direction. The agent therefore returned eastward at once, and then took up the threads which linked the name of Charles with the now missing Martha. His first effort was to find the whereabouts of Martha. She was traced to Chicago and believed to be in that city. It took several weeks to trace her exact locality, but this was finally accomplished through letters addressed to her by a third party with whom she was acquainted. It was ascertained that she was keeping a cigar store in the city, and the detective soon found it convenient to buy his tobacco of her. In due time, an interview with her led to an agreement on her part to furnish the company's agent with satisfactory and conclusive proof that Charles was not dead, but now living. She said he was living under an assumed name, but was not then residing with her nor in Chicago. Finally, upon terms agreed upon between herself and the agent, she placed in the latter's hands 4 letters, dated respectively August 23, 1870, September 6, 1870, October 24, 1870, and November 10, 1870. Accompanying these letters is Martha's statement, written by herself in a neat, businesslike hand, from which we copy the following extract. These letters were written by Charles McCormick, formerly of Ogdensburg, New York. The first 3 reached me at Governor, New York, and the last named at Adams House, Chicago. I have had no correspondence with him since the last letter herein named. The assumed name of C.H. Mack was understood between us before his disappearance from home in August 1870. This statement, signed by Martha's full name, is dated Chicago, August 25, 1871, a little more than 1 year subsequent to McCormick's disappearance. The first of these letters was written 5 days after his disappearance, at a time when his worthy father-in-law was examining the shores of the islands in the St. Lawrence River in search of the body of the said Charles. It was received by Martha while at her home in Governor, New York, where she then was, and to which she replied by mail in accordance with pre-existing arrangements. This verifies the statements made by her sister concerning this alleged correspondence. The following is a verbatim copy. Omoro, Wisconsin, August 23, 1870. My dear Mattie, I arrived at this place yesterday. I can't say as yet how long I may stay here, but think I will leave tomorrow morning. Now, dear, I can't write much, not but that my desire is good enough, but you know I am in rather a sad plight. I wish you were here, that you could be a source of comfort. You know I am of a lonely nature if left alone. You asked me to write you plainly. I will try to do so, and in a very few words. I want you to join me at the earliest opportunity. Now, I may not be able to send for you as soon as I would like, but believe me, Mattie, I will use every effort to advance the project. I want you to write me before you sleep after getting this address. C.H. Mack, Neenah, Winnebago County, Wisconsin. My love to you, sweet one. Write me plainly so I may understand you. C.H. Mack. P.S. Wednesday, 3:00 p.m. Send your letters to Oshkosh, Winnebago County, Wisconsin. P.O. Box number 318. A kiss from C.H. M. The second letter, written soon afterwards, reads as follows. Oshkosh, Wisconsin, September 6, 1870. Dear friend, your kind note is at hand. I am pleased to learn that you are disposed to favor my proposal. Now, Mattie, remember that I am placed in a very peculiar situation. I have reason to believe that the people think I am gone up, or down, really. I can't say which. and it now remains with you to say whether they shall so continue to think or not. For God's sake, Maddie, as you value a true friend, do not indicate by either word, look, gesture, or action that you know or even think of me. I am not fearful, Maddie, that you would knowingly divulge anything which would injure me. Always remember, dear, that I am and will be a friend, even though you should conclude in the future to discard me. Do not think I make the statement with a view to get your favor. My past life I believe to be one of honor towards a friend, and I fail to remember a case where I have ever deceived one. I hope to receive a good long letter from you ere Saturday eve. I am as yet unsettled as regards my future prospect of business. I am to remain here 1 month yet, and then I will very likely know something further. I am well, and for aught I know, happy. But you must write me often if you wish to keep me so. Darling, do not make a confidant of anyone, not even Frank, and at some future day I will repay you for your constancy. Hoping you are enjoying life, I remain yours, truly and ever, C. H. Mack, Box 318. The third letter is as follows. Janesville, Wisconsin, October 24th, 1870. Darling Maddie, I have but just received yours of September 9th, and am now in doubt as to your being in governor. It was in consequence of my changing my P.O. address that your kind note did not reach me until so late a date. Hoping you will pardon me for this, I promise better hereafter. Should have written, but as I ordered all letters to be forwarded, and received none, I feared you did not write. Forgive my doubting, and write me at this place. In haste, C. H. M. The fourth letter, which was directed to and received at the Adams House, Chicago, is as follows. Janesville, Wisconsin, November 10th, 1870. My dear Maddie, your dear note was duly received. Am pleased with results, and trust they may continue favorable, yet I assure you, everything has not worked so smoothly here. I had to leave Oshkosh because of a person being there whom I knew. He, however, did not see me. In looking the directory over, I saw his name, and on inquiry learned he was the man whom I knew, a lawyer, and I, knowing we would surely meet, had to get up and get. I am sorry to say the change has not been a good one for me. I had a good situation at that place, but it is not so here. Therefore, I am at present writing my last from this place, have my ticket in my pocket, and will leave tomorrow morning for Kansas. I do not know as yet in what part I will locate, but am going to Leavenworth. I am sorry it is so, Maddie, but I cannot help it. I have not much money, though I have not gambled, as you heard. I deny the charge, excepting in one instance to the amount of $12. I say I regret having to leave here so soon, as I wished you to join me before I moved, but my means will not allow me to wait. I must get into something soon. Oh, Maddie, it is hard when I think how poor I am, and consider my situation. And then when I remember what you said about money matters, it makes it still harder. Do you remember? It was at Frank's. It was this, that you did not care for a man unless he had money. I know, dear, you did not mean all this, did you? At least I will try and hope not. How I would like to call in and take tea with you this evening. Or, rather, I would prefer to have you take tea with me. But as we cannot have that pleasure, let us hope for the time to hasten when we may be allowed even more. A loving kiss. Be cautious, my own darling, that you do not by word, action, or look give them to understand that you know where I am, but I need not caution you. However, you know Frank is sharp, and will guess more than half. But I must close, as it is near train time, and I have to go out about 5 miles to another station tonight, and return ready to leave in the morning. I wish I could send my love to Jenny, but it would not do. I am, as ever, yours truly, C.H. Mack. According to Martha's verbal statement, she and Charles had separated, and although he had gone back to Janesville, Wisconsin, it was her belief that he was about leaving that place, even if he had not already gone. Without unnecessary delay, the agent pushed on to that city for the purpose of securing a personal interview with McCormick, or, failing in that, to identify him with C.H. Mack by means of his photograph, of which the agent had copies. On inquiry at the post office in Janesville, it was ascertained that C.H. Mack had a box there, that he took a weekly newspaper through the same, that at times he came in person to the post office and at other times sent for his mail, and that he was sometimes seen in the company with a family living some 5 or 6 miles from town. Finally, the hunt was narrowed down closely, and on the 30th day of August, 1871, the agent came upon the long-lost Charles and identified him through his resemblance to the photograph, when he at last acknowledged his real name and subscribed to a statement from which we make the following extract. I learn that a claim has been made out under the policy in your company, the claimant representing that I am dead, and I hereby beg to inform you that the claim is not yet good, as I am living and in fair health. Charles McCormick. During this interview of the agent with McCormick, it was ascertained that the latter had been in correspondence with Perkins, and had recently written him over his assumed name of C.H. Mack. A few weeks subsequent to this discovery of McCormick, the following letter from him was received at the office of the insurance company. Kansas City, Missouri, October 9, 1871. Secretary of Travelers Insurance Company, Hartford, Connecticut. Sir, having seen one of your general agents and given him a certificate of my being alive, I feel it a duty to myself to give a statement of the causes and feelings with which I left Ogdensburg, thereby causing a claim to be made for the insurance on my life. First, I was indebted to the Agricultural Fire Insurance Company, Watertown, New York, and they wrote my surety that they would hold him for my indebtedness, that they having before this told me in person that they would not hurry me. I thought then, as I believe now, that had they let me alone, I could have paid all my liabilities in a short time. True, this is no good reason for me to base a justification of my actions, yet this, in connection with the high estimate in which I held my surety, and a knowledge of the trust he had placed in me, with a sense of the mortification it would cause me to have the matter made public, worked on my mind to so great an extent as to entirely unfit me for business. There was, as you undoubtedly know, having investigated the matter, other reasons which I need not mention. Suffice to say that I truly regret the action, but, sir, I assure you that I had not then, nor have I now, a wish to wrong any person or persons, and I am resolved, Providence permitting, to refund any money which may have been advanced to or for me, feeling that to write more would be only a rehearsal of matter which you understand. I will close. Hoping this may meet your favorable consideration, I remain, etc. Charles McCormick. P.S. I have heard that a statement was made to the effect that I had a large amount of money when I left. I deny, and can prove this to be false. Please address Charles McCormick, care of Henry E. Perkins, Girard, Kansas. For what we know, Charles still luxuriates out west, and mayhap the false and fickle Martha, who sold the secret of his hiding place, regardless of Charles' despairing love letters, has rejoined her lover, since her cigar shop was burned with 20,000 other shops and dwellings on that lurid night of the Great Fire. This little affair cost the insurance company a deal of trouble and considerable expense, all on account of Charles's foolish infatuation for Martha. End of section 15.
Section 16 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Bo Wood. Stratagems and Conspiracies to Defraud Life Insurance Companies. An authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Mysterious Disappearances. Part 6. Donald McLeod. An accident policy insuring the life of Donald McLeod of Sherbrooke, Province of Quebec, Dominion of Canada, was written December 21, 1875, by the Travelers Insurance Company. 6 days later, the company's agent in Sherbrooke gave notice that the policy had become a claim, stating, in the course of his letter, that Mr. McLeod went to the river for a barrel of water, and half an hour afterwards his team was found at the riverbank, his barrel afloat down the stream, and his cap floating near the team. Further, that at the time of writing, 9:30 p.m., parties were still searching for the body in open water in boats with torches. In a sworn statement of the wife of McLeod, it is stated briefly that the late Donald McLeod lost his life by drowning at the junction of the rivers Magog and St. Francis on the evening of the 27th day of December, 1875. The particulars of his sudden departure are more fully given in the statement of one Joseph Whitehouse, who, on his oath, said, I was in the employ of the late Donald McLeod, livery stable keeper in the city of Sherbrooke, was employed as an ostler. Thomas Price was employed there as teamster. About 5:30 in the evening of the 27th day of December, 1875, Price and myself were at work in McLeod's stables, under his orders, when he entered the stable, having just come from his house, which is nearby. I assisted him in harnessing a horse to the sleigh, with which he had been accustomed to draw water from the river. The sleigh was coated with frozen ice, and the horse was a rather unsteady one. He drove to the river, and I remained in the stable, intending to await his return, as the distance is not far, and the trip ought not to have taken him more than 15 or 20 minutes. Mrs. McLeod, however, called me to go to tea, and told me to leave a lantern for her husband. I went with Price, and we had tea. On going back to the stable, we saw that McLeod had not returned. Price went to see what the trouble was, and in a few moments drove into the yard with the horse and sleigh, without barrel or pail, and telling me to hurry with him to the river, as he feared McLeod was drowned. We went at once to the river. The barrel and pail had by this time floated beyond the mouth of the Magog River, and was being carried by the current down the St. Francis River towards the ice. The St. Francis River was open only for a small space about the mouth of the Magog River, and the remainder of it was all frozen over. It was a very cold night, and before lights and assistance of any use could be had, the body must have been carried under the ice of the St. Francis, as it could not be found in the small space of open water. The current of both rivers coming together at the mouth of the Magog would have a tendency to drive the body down the St. Francis and under the ice. From all the circumstances, I have no doubt of his having been drowned on that occasion. The affidavit of Thomas Price corroborates that of Whitehouse, and also relates the following incidents. I went to the stable after supper and saw that McLeod had not yet returned from the river. I started out to look down the hill to see if he was coming. Not seeing him, I went to the river. There I found the horse backed into the stream, the horse's forefeet standing on the edge of the ice in about a foot of water, the hind feet over the edge of the ice in water about 3 feet deep. The sleigh apparently was afloat, and the barrel and pail were missing. I took the horse and sleigh immediately to the stable, and with others hastened back to the river, telling persons on the way of my fears that McLeod was drowned. A crowd soon gathered, one of whom found McLeod's cap drifted and frozen to the shore ice. At the mouth of the Magog River, where this occurred, a strong current prevails, and the waters of the St. Francis, into which the Magog empties, must have carried the body under the ice, as it could not be found in the open water. Price further avers that he has no doubt, from all the circumstances of the evening, that McLeod was drowned on that occasion. In further support of the alleged drowning, the proofs of death exhibit the affidavit of a person who, passing at the time, noticed the horse and sleigh on the bank of the Magog, as McLeod was in the act of backing down to the river. It was too dark for this person to distinguish McLeod sufficiently to recognize him, but he observed a man standing on the rear end of a sleigh or sled, behind a barrel, backing a horse into the water. As this was a common occurrence, the witness paid no particular attention to it at the time, but returning soon afterwards, when passing the same place where he had previously noticed the horse and sleigh, in looking across the river, he saw a water barrel and pail floating out from the Magog toward the St. Francis River. Witness simply thought the man whom he had previously seen had lost his barrel and pail, and he further states that the interval of time between going and returning was no more than would have been necessary for the occurrence of such an accident to the person in charge of the team. Upon this evidence, the widow of McLeod demanded payment of the principal sum insured, and similar affidavits were submitted to the Aetna Life Insurance Company of Hartford in support of a claim arising under a policy written upon McLeod's life by that company. In presenting these claims against the insurance companies, a gentleman who announced himself as a brother-in-law of the widow and also as secretary to one of the ministers of the Crown, addressed the companies by letters saying, "The evidence is, of course, circumstantial, But I believe no equitable doubt remains of Mr. McLeod's death at the time and in the manner specified. The preliminary proofs were not submitted until the May following McLeod's disappearance, they having been delayed in view of the possibility of his body being found on the breaking up of the ice. In the month of July, a body was found in the St. Lawrence River, into which the St. Francis flows, which was thought to be that of McLeod. Upon examination, it was found to be the body of a much older person than McLeod, and although the clothing upon it was torn to rags by the action of the water, sufficient remained to determine that the pantaloons and shirt were different in fabric from those which McLeod was known to have worn. An early investigation of the circumstances surrounding the case at the time of McLeod's disappearance led to the belief that the manner of his departure was not strictly in accordance with the presumption of death by drowning. There were numerous little facts, trivial in themselves and apparent only to the most careful observer, which justified such belief, and which furnished the usual earmarks of fraud. In illustration, we may mention the finding of McLeod's cap. It was an old, tightly fitting sealskin cap, which, drawn upon his head as he was accustomed to wear it, and especially as he would wear it upon so cold a night as the one in question, would not easily come off upon his accidentally falling into the water. But if it did come off, it could not, of itself, or by the action of the current, get upon the fixed shore ice where it was found. This was simply a physical impossibility, overlooked at the time, but nonetheless significant. It was a long time before any trace of the missing man was obtained, but through post office communications, it was suspected he had gone south, and probably to Louisville, Kentucky. Inquiries in Louisville led to the finding of a maternal uncle of McLeod, and this uncle, although he knew nothing of the missing man, was able to give the names and residences of relatives of whom inquiry might be made. One of the names thus mentioned was that of the Louisville man's brother, another uncle of McLeod, and near his residence upon a sheep ranch in Live Oak County, Texas, the materialized form of Donald McLeod, the doppelganger, may be seen. There his wife has rejoined him, and there we leave him. Anyone who will examine a map of the country will find it to be a long and perilous journey for a man to undertake, especially during the inclement season of the year upon which McLeod set out upon his voyage. Starting from the mouth of the Magog River, thence by the St. Francis and St. Lawrence, to the Atlantic, much of the way under ice, thence floating against the current of the Gulf Stream, he is carried through the Atlantic into and through the Gulf of Mexico, thence being irresistibly drawn into the mouth of the Nueces River. He is finally cast ashore upon the riverbank near the little town of Oakville. Later developments suggest another and quite different route as the one by which he finally arrived in Texas. It is thereby shown that upon the night of his disappearance, he first put his fur coat and an extra cap into the water barrel which he took to the river. Then, after arranging the horse and sleigh in the water, as subsequently discovered, tipping the barrel and pail into the river and throwing his wet cap on the ice in a place where the current could not wash it away. He went down along the bank of the St. Francis until he could cross upon the ice to the opposite side. He then proceeded on the ice up the river until he passed the railway passenger station, when he pursued his way along the track and walked thereon to a station about 20 miles east from Sherbrooke, where he entered a Pullman sleeping car. He paid his fare on the cars to escape recognition by purchasing a ticket at the station, and thus continued on his way, mostly by rail. The reader is at liberty to adopt either version of his journey to Texas, but the one by water is more consistent with the proofs of death. A repentant fool. In the year 1874, resided in Louisiana, Pike County, Missouri, a man named Charles A. Folk, about 35 years old, respectably connected, and possessed of considerable intelligence, but not much energy. He had been a section boss on a railroad. He had a wife who was the stronger-minded of the two, and played the part of Gretchen to his Rip Van Winkle. For like Rip, he was fond of hunting, fishing, loafing about corners, and whittling the edges of dry goods boxes. His domestic relations were not altogether lovely, and he was addicted to long absences from home. He did not have the utmost confidence in the fidelity of his wife, but was somewhat indifferent about the matter. Among Folk's intimate friends was one William Moseley, a resident of Bowling Green, the county seat of Pike, where many a time and oft the eloquence of men whose fame has reached as far as St. Louis has shaken the rafters of the courthouse. Folk suspected that Moseley was a trifle too intimate with his wife, but like a good, easy soul, he said nothing, and expressed no surprise on finding them together on his return from a fishing excursion to the Schnei or a duck hunt on Grassy Creek. One day, while the three friends were together, the subject of life insurance came up, and it was agreed between them that Folk should take out a policy of $10,000 on his life in favor of Mrs. Folk. Moseley, the generous and disinterested friend, furnished the money to pay the premiums. On the 13th of August, 1874, the policy was taken out in the New York Life in favor of Olive A. Folk. The next friend, or whatever the term may be in such transactions, was William Moseley. The half-yearly premiums were $125 each. The first one was paid, and the next was due in February 1875. So far, everything seemed proper and legitimate. About the middle of January, Folk disappeared and was seen no more at the corner grocery nor trolling for catfish in Salt River. At that time, the Mississippi was frozen over, and at a certain place there was a large air hole. Near this air hole, the coat, hat, and gun of Folk were found, left lying around loose, as a man would have left such things when he intends plunging into eternity through such an air hole in the ice. Poor fellow! Weary of life, or maddened by jealousy, he had gone to a shivering death in the bosom of the dark river, and would become food for the very catfish he had attempted to ensnare. His disconsolate wife was almost distracted by her sad bereavement, and wept long and loudly. Moseley, too, his bosom friend, groaned and lamented and moralized on the uncertainty of life and the horror of suicide. Search was made for the body. The air hole was sounded, and other air holes below were watched, but the body of the section boss did not pop up. After a short season of mourning, the widow thought of the insurance on the life of the dear departed, and consulted her next friend Moseley concerning it. It was necessary to employ a lawyer, and one David P. Dyer was selected as the most suitable lawyer to manage the case. Proofs of the drowning of Folk were sent to Mr. William L. Hill, the local agent of the New York Life at St. Louis, and the payment of the policy demanded. As the corpus delicti had not been proved, Mr. Hill concluded to wait a while before paying the $10,000. The result showed that his caution was well taken. A few days afterwards, Mr. Hill received a letter dated Memphis, Tennessee, and signed by Charles A. Folk, requesting him not to pay the money to his wife, as he was alive and kicking. Persons familiar with the writing of Folk identified the letter as genuine, but Mr. Dyer insisted that it was a forgery. The company, however, refused to pay, and suit was brought in the Court of Common Pleas at St. Louis to enforce the payment. Further proofs were necessary and were not wanting. The corpus delicti would settle the business, and when the ice in the river broke up in the spring, a colored man was found who testified that he saw the bloated carcass of Folk among some fragments of floating ice, sailing down towards the jetties, ready to be fished out by some enterprising coroner. Still, Mr. Hill was incredulous and was convinced that Folk was alive. The circumstances of the case convinced him that a deep-laid conspiracy had been entered into to defraud his company, and he followed the policy of fighting the case to the bitter end if it cost the whole $10,000 to do it. In the fall, the case was removed to the United States Circuit Court in St. Louis. In the spring of 1876, the case was called, but the judge had more important matters on hand, and it was continued to September. Parties in interest entered into the plans of Mr. Hill, who had taken measures at the beginning to ferret out what he believed to be a cunning conspiracy. Mr. Hill went to Memphis and placed himself in communication with Mr. P. R. Athai, chief of police of that city, to whom he related all the facts in his possession. Folk had assumed the name of R. Russell at Memphis, and afterwards that of J. R. Sloan. He had disappeared from Memphis and left no trace of his whereabouts. It is supposed that when he wrote to Mr. Hill, informing him of his existence in the flesh, he was moved partly by fear of detection and partly by revenge against Moseley. He believed that Mosley was living with his wife and had entered into the conspiracy to get rid of him and to share the spoils with the woman. Chief Athai sent a description of Folk to all parts of the South, and a reward was offered for his arrest. After a diligent search of 18 months, the fugitive was arrested at a place called Surrounded Hill in Prairie County, Arkansas, by Sheriff Williams of that county. Mr. Hill obtained a requisition and brought the prisoner to St. Louis and lodged him in jail. Being taken into custody, Folk expressed extreme gratification at the event. He had been wandering in the wild woods so long, a fugitive from justice, haunted by a remorseful conscience, and stung almost to madness by the conviction that his wife was not only untrue to him, but had conspired with her paramour to rid herself of his presence, that he was glad of a change. He had become a vagabond on the earth, afraid to look upon the face of a white man, and had made his home in a miserable cabin inhabited by Negroes, with whom he associated on terms of equality, though he knew they were his superiors in morality, if not in intelligence. When taken on board the train and placed in a sleeper, he could not contain his joy, but gave vent to his feelings in loud and oft-repeated self-gratulations. On being locked up in jail, he was still better pleased and declared his cell was a luxurious apartment compared with the place he had been occupying in Arkansas. He said he wished his wife and her lover no greater punishment than to be compelled to pass 13 months of their lives down in Rackensack, where he had been. End of section 16.
Section 17 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Tom Milliken. Stratagems and Conspiracies to Defraud Life Insurance Companies. An Authentic Record of Remarkable Cases by John B. Lewis and Charles C. Bombaugh. Mysterious Disappearances, Part 7. A Disappearance in the Black Hills. The gold mania, engendered by the reported discoveries of the precious metal in the Black Hills country, freshened the activity of the adventurous classes. Cleveland did not escape the contagion, and 6 of his citizens, including one James Hearns and his son, made preparations to violate the treaty of the government with the Indian occupants and poach upon their hunting grounds. The party traveled together until they reached Wolf Mountain, north of the Black Hills, where Hearns and his son, by mutual arrangement, parted from their companions to pursue a different course and seek their fortunes alone. The father and son had not proceeded a great distance when, according to the statement of young Hearns, they were attacked by Indians, and his father was shot in the forehead and thigh. Of course, young Hearns did all that an affectionate and dutiful son should do under the unfortunate circumstances. He tried his best to save his father's life, but all efforts were in vain. The deadly bullet had completed its work, and nothing was left for the sorrowing youth but to give his paternal ancestor decent burial. After performing the last sad and solemn funeral rites, the young man arrived at Yankton and, finding himself without funds, telegraphed to Cleveland for the means with which to return to his widowed mother. The disconsolate youth returned and, after the lapse of a brief period, applied for the insurance which Hearns, Sr., had, with wise forethought, effected upon his life. From certain suspicious circumstances, the insurance companies, prudently, refused to pay $1 of the sum claimed, and the consequence was a lawsuit, which resulted in a verdict for the plaintiff. The counsel for the defense were not at all disconcerted at the turn affairs had taken, but simply asked for a stay of proceedings. Now comes the interesting part of the business. Immediately after the trial, Mr. E.K. Wilcox, in company with Detective Reed, started for Lake County, Ohio, and, in their rambles around Madison, a village about 40 miles from Cleveland, they thought they saw something which looked very much like the departed James Hearns. At first, they were inclined to doubt their senses, and determined to wait and watch. About midnight, again they saw the supposed corpse, and traced him to the house where he was staying, where, upon an interview, the dead James Hearns, who had been shot in cold blood in the Black Hills, was found to be alive and well. Upon recognition, there were no hearty congratulations, but all that was heard was the laconic, "You're my prisoner," and the sharp click of the handcuffs. The prisoner, seeing that all resistance was useless, meekly accepted the situation. When the big game had been bagged in Lake County, a dispatch was sent to Cleveland to forward James Hearns, Jr., which was promptly done, and the affectionate couple were reunited in jail and detained to answer the charge of perjury, attempt at swindling, and subornation of perjury. Evans, the Northwood murderer. On the 16th of August, 1870, Franklin B. Evans, a man 60 years of age, then living at the house of his brother-in-law, Elias Evans, in Derry, New Hampshire, called at the Boston agency of the Travelers Insurance Company, and, on pretense of going to Canada, obtained a general accident policy for 1 month in the sum of $1,500 for the benefit of his brother Elias. On the 29th of the same month, the beneficiary, a man between 50 and 60 years of age, notified the company that Franklin B. Evans had been drowned accidentally on the evening of the 24th while bathing at Hampton Beach, New Hampshire. Inquiry into the matter by the adjuster of the company aroused his suspicions, and he proceeded to investigate the case more minutely. He found that Evans had called at the Granite House, Hampton Beach, on the afternoon of the 24th of August, and arranged for rooms and board for himself and 2 friends who were to come there. On his arrival, Evans had requested the clerk to enter his name upon the hotel register, which was done. No room was assigned him, nor was he present at any meal. The same evening he was in the office of the hotel and had some conversation with the clerk relative to bathing near the house. This was the last seen of him. The next morning, clothes were found spread upon the beach at a time when there appeared to be no one in bathing to whom they might belong. Finally, the garments were examined, and from papers found in the pockets, the clothing was supposed to be that of Franklin B. Evans. In the course of the day, Elias Evans arrived at the beach from his home in Derry and inquired for Franklin. He was informed of the clothing that had been found, and at once identified it as having belonged to his brother Franklin. Immediate search for the body was made. The morning was calm and clear, and the translucency of the water permitted a good examination of the sea bottom at considerable depth. But although boats passed carefully over all that portion of the water where it was supposed that the missing body might be, no discovery was made. After a visit to Derry and interviews with several parties living there, the adjuster became satisfied that the whole affair was a fraud, and he freely stated his convictions to Elias Evans. He further refused to accept the allegations as satisfactory proofs of loss and demanded the surrender of the policy. Nothing further was heard from Franklin B. Evans for more than 2 years. About the 1st of November, 1872, he was revealed to the world as a monster of cruelty and villainy. He was arrested and tried for the fiendish outrage and murder at Northwood of Georgiana Lovering, aged 14 years, the grandchild of his sister, Mrs. Day. To his conviction of this awful atrocity, the details of which are as heart-rending as anything in the whole range of criminal annals, was added his own confession, not only of the murder of Georgie, but of a little child, the daughter of Mr. Mills of Derry in 1850, and of repeated guilt in theft, counterfeiting, defrauding, adultery, and incest. As one portion of these confessions forms a fitting sequel to the particulars we have given, and justifies the traveler's insurance company in resisting what was presumably a fraud, we subjoin a copy. New Hampshire State Prison, Concord, New Hampshire, February 14, 1874. To the Traveler's Insurance Company, Hartford, Connecticut. Gentlemen, in the month of August, 1870, I was a poor man, and thought of a plan whereby I could obtain some money. Together with Elias Evans, I planned to obtain an accident insurance upon my life, the insurance to be for his benefit. Elias is my brother-in-law, he having married my sister, and lives in Derry, New Hampshire. Having decided upon our plan of operation for defrauding your company, I went to your office in Boston on the 16th day of August, 1870, and made application for a policy, stating to your agent that I contemplated a visit to Canada. A policy insuring my life for $1,500 for 1 month was written by your Boston agency and was made payable to my brother-in-law, Elias. Having obtained the policy, I went to Hampton Beach and made arrangement for board at the Granite House there. This was on the afternoon of the 24th of August. That evening, I went out of the hotel, saying to the hotel clerk I was going in bathing. I did not go into the water at all. I took off my clothing, leaving it all on the beach, and put on another suit which I had provided for the purpose. I left my clothes lying on the beach at about 10 o'clock that night. The day after I left the beach, while walking in the road near Raymond, Lawyer Bartlett came along and took me into his carriage and carried me a few rods, when I got out at a cider mill where was some new cider being made. I went up into northern Vermont. Elias did not know where I was going, for when I left him, I told him it was better he should not know where I was going, so that when he was inquired of about it, he would not have to lie about it. I got tired staying off in Vermont, hiding up. I concluded to return to Derry, and did so in about 4 weeks after I left the beach. I was hid in Elias's barn for a while. While I was in the barn, I learned from Elias that your agent had been there to see Elias, and that he did not believe I was drowned, and that he would not pay the $1,500 to Elias. Elias and I had arranged that if the money was paid, he was to have $500 and I was to have $1,000. I feel that I have done wrong in this matter and want you to forgive me. Franklin B. Evans. Witness, J.C. Pillsbury, Warden. On the 17th of February, 1874, the hoary-headed scoundrel expiated his crimes on the gallows at Concord, New Hampshire. A lame man leaves tracks of betrayal. Joseph L. Clement, a shiftless and worthless fellow, lived at Brownfield, Maine. He had a wife and 2 children and a boon companion named George A. Hartford. In May 1871, Clement obtained a policy of $5,000 upon his life in the Northwestern Mutual Life, and in September of the same year, $5,000 more in the Travelers, and $5,000 in the Economical, $15,000 in all, and the last policy being dated September 27, 1871. Out of these facts grew incidents which brought Clements into notoriety. During the evening of October 3, 1871, Clement and his crony, Hartford, were returning home from Cornish in separate teams. According to Hartford's statement, when about 5 miles from Cornish, where the road runs along a bluff of the Saco River, Clement started ahead. Soon afterward, Hartford heard a noise, a splash in the water, and loud cries for help. He hastened to the spot and shouted over the bank in the darkness, but received no reply. He hurried to Hiram Bridge, in the neighborhood, gave the alarm, and procured assistance. The body of the horse and the wagon were found in the river, but Clement could not be found. In 1874, suit was brought by Mrs. Ruth H. Clement against the Economical to recover under its policy, but it was resisted on the ground of gross fraud. Defendant's counsel contended that the horse had been backed over the bank and had received a heavy blow between the eyes as he went over. It was also claimed that the cloth and the hat found in the road were placed there by Hartford. It was shown, moreover, that Clement was lame in the left foot, occasioning a hitch in his walk and leaving a peculiar track. The track was discovered the next morning, leading from the place of the occurrence, and the same track was found within a fortnight after, between Hartford's house and the neighborhood where Cyrus Durgan, brother-in-law of Clement, resided. Dr. Jesse P. Sweat also saw a man he thought to be Clement coming out of the road leading to Hartford's, who suddenly disappeared in the woods. The same man was seen by other parties, but soon after he disappeared entirely. Defendants alleged that he had gone to some other part of the country, where he was living under an assumed name. The jury returned a verdict for the defendant company on the ground of fraud, and that the man had been seen alive since his presumed death. On the 24th of September, 1878, Mrs. Clement brought suit against the travelers in the United States District Court before Judge Fox. After the case was called, the counsel for the defense produced an affidavit signed by the mother and sister of Clement, which sets forth that he was not drowned at the time of the loss of the team, but had hidden in the woods, where he remained for some time. While there, his tracks were seen and aroused suspicion, owing to a peculiar formation of one of his feet. He managed to communicate with his mother, and, as soon as he could escape, went to Blue Earth, Minnesota. His mother removed to the same place, and there they had been together until a year passed, when Clement went to the Black Hills, and his mother returned to Waterboro, Maine. She remained quiet, but the lawyers got wind of her presence. A justice of the peace sought her out, and finally she and her daughter signed an affidavit to the above facts. The lawyer, by letters, had found out where Clement was. End of section 17.
Section 18 of Stratagems and Conspiracies to Defraud Life Insurance Companies. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Bo Wood. Stratagems and Conspiracies to Defraud Life Insurance Companies. An authentic record of remarkable cases by John B. Lewis and Charles C. Bombaugh. Mysterious Disappearances, Part 8. The Capture of a Shrewd Trickster. In cases of mysterious disappearance, where claims have been brought to recover under life or accident insurance policies, the evidence was at first almost wholly of a circumstantial nature, such as the finding of the hat or coat of a missing man in places or under conditions that would lead to a presumption of death by accident. Fraudulent claims arising from such cases became so numerous that the accident companies sought to protect themselves by specifically providing in their policies that this insurance does not cover disappearance. Therefore, to establish a valid claim, it now becomes necessary to identify the dead body of the insured or to furnish credible eyewitnesses to an alleged accident. The substitution of a body in a fraudulent case is attended with no little risk of detection, while arranging for eyewitnesses to a pretended accident almost necessarily means conspiracy and its attendant dangers. Each of these schemes is occasionally practiced, but disappearance claims are much less frequent than formerly, probably because of the increased hazard incurred through the necessity of having more than one interested person in the plot. It is, of course, possible that a trick may be so adroitly planned and be carried out with such masterly ability that even the eyewitnesses themselves may be deceived, and thereby led to give their aid and cooperation in an attempt to defraud. In a case whose details are as follows, eyewitnesses to the drowning of Joel Piper attempt to explain their innocence on the grounds of such deception, and Piper himself endorses their explanations, thereby appropriating to himself all the cunning, all the skill, and all the glory belonging to his fraudulent venture. Joel is therefore undoubtedly the hero of this tale, and it is proper that he should be presented to the reader as such. At the time of which we write, in the fall of 1880, he was a resident of Quincy, Illinois, called himself a farmer, 50 years of age, was married, and, so far as known, enjoyed a somewhat unenviable reputation. A few months previous, he had been indicted for burglary and was out on bail, his bondsman expecting him to appear at the November term of court. In this matter of burglary, Joel had a pal, or confederate, in crime named Scott, who also was indicted, but being obliged to stand trial, was convicted and duly sentenced to the penitentiary. Shortly before the time when Piper would have to appear for trial, that is to say, on October 9, 1880, he obtained 2 insurance policies written by Travelers Insurance Company of Hartford, Connecticut, in the total sum of $4,000 upon his valuable life, procuring them through an agent to whom he was a stranger. The policies were made payable to his wife in the event of his death by accident. Notice of the untimely drowning of the insured soon followed, the alleged widow presenting sworn statements as follows. First, her personal affidavit that said Joel Piper, in company with Thomas H. Bryant and James H. Bryant, did, on the morning of October 31, 1880, start from his house in Quincy, Illinois, with the intention of crossing the Mississippi River into Missouri for the purpose of gathering nuts and persimmons, and has never returned. Piper's 2 companions, whose names Mrs. Piper mentions, were her own brothers. Their affidavit in support of her claim under the insurance policies is as follows. They were with said Joel Piper in a small boat or skiff on the Mississippi River about 8 miles south of Quincy, Illinois, on the Missouri side, October 31, 1880. At said time, we saw said Piper fall out of said skiff into the river, and that he rose to the surface of the water but once afterward, and then about 30 feet below or down the river from the boat, and that they used every means in their power to rescue and save said Piper from drowning, but without effect. And further, that they believe and are fully satisfied said Joel Piper was drowned at that time and place, although his body has not as yet been found and identified. Said Piper had on, at the time of said accident, a very heavy overcoat, buttoned up close to the throat, which said affiance believe had a tendency to hold the body underwater. These two eyewitnesses, who were brothers-in-law of Piper, a few days after the occurrence, were able to show satisfactorily to the court why and wherefore Piper could not appear in answer to the indictment for burglary, and the forfeiture of bail by his bondsman was accordingly set aside. The two Bryants were on the bond. Public opinion seemed to be divided upon the credibility of the drowning story as related by the Bryants. The affiants were young men of good reputation for veracity, and those who knew them personally felt confident that they were incapable of being parties to a conspiracy to defraud. Mrs. Piper employed as her counsel one of the leading lawyers of Quincy, and he informed the representative of the insurance company that he had fully satisfied himself of the honesty of his client's cause before he consented to advocate it. He further wrote, "I took great pains to inquire fully about the facts. I am aware of the occasional attempts to defraud in matters of this sort. I am satisfied, however, that this is not one of them. Whilst I feel certain as to this, I also feel that it is proper the company should have ample time to become fully satisfied before paying the insurance." On the other hand, there were not a few who expressed their belief that such a combination of circumstances, that is, of indictment for burglary, of obtaining bail, of the near approach of trial, of the insurance, of the accident, and of the relationship of the dramatis persona, clearly indicated trickery and fraud. It appeared to be a general opinion that if Piper was not actually drowned as alleged, it must be because he had been landed dry shod from the boat upon the Missouri shore and was then in hiding. A year elapsed, and October 1881 arrived without any material disclosures touching the missing man. True, the local newspapers had published a rumor in August previous that Piper had been seen in St. Louis, alive and well, but added that the story is not credible and the evidence is entirely too slight to allow belief that Piper is alive. No effort to find him had been made, and the insurance company realized that it now was necessary to pay the claim or satisfy the courts that it should not. It was decided that a search should be instituted with a view to ascertain something conclusive, one way or the other. The first move was to obtain reliable and thorough information as to Piper's habits, mode of life, and general surroundings. As a result, a more negative character would be hard to find. He seemed to have lived pretty much to himself, but with few associates and no intimates. It was some days before anyone could be found outside of his wife's family who really knew him personally. Finally, one, Brown, was got hold of, a sort of a river habitué, who knew Joel Piper and more about him and his antecedents than did anyone previously seen. According to Brown's account, Piper, who had stated in his insurance application that he was a farmer, had not been on a farm for years, but was by turns a boat carpenter, fisherman, and swamp hunter. Becoming satisfied as to Brown's reliability and fidelity, he was employed to enter upon a prolonged search. The trail was an old one, and it had become cold, but the amateur detective started down the river, making only brief stops until he reached St. Louis. He remained a few days in and near that city and satisfied himself that Piper had been there about a year previous, or very soon after the drowning. Getting no further trace, Brown then went to Cairo, Illinois, and there took a skiff and ransacked the river landings and islands as far down as Fort Pillow. At one of the islands, 40 or 50 miles below Cairo, he first struck the trail. Piper had been there some months before. Nothing further was learned, however, until he reached Fort Pillow. Brown knew that Piper had a relative some miles from this place, so he then abandoned the river and went into the country. It required several days tramping, often retracing his steps, before he successfully located the relative. But when it was accomplished, he had the satisfaction of learning from the neighbors that Piper was then at this relative's house. Brown then went to Ripley, Tennessee, the nearest point where he could communicate with the insurance company, and reported the situation. The next thing to be done was to obtain Piper's arrest. Brown, in the meantime, being quietly on guard, but wholly unknown to Piper. A complaint was duly made, charging Piper, his wife, and his brothers-in-law with conspiracy to defraud, and a copy of the complaint was forwarded to a lawyer in Ripley, to whom Brown was ordered to report in person. The arrest was made December 3rd, 1881, and was so well planned and suddenly executed that Piper made no resistance. On receipt of telegrams announcing the arrest, a requisition was obtained, and the Quincy chief of police was sent as messenger. He returned at once to Quincy with his prisoner, who was lodged in jail. So quietly was this done that the other participants in the affair, Mrs. Piper and her two brothers, were taken completely by surprise. Piper was duly arraigned for a hearing, and his story was substantially as follows. While out on bail to appear in the burglary case of the year previous, he devised the scheme to get his life insured, disappear under such circumstances as to leave a presumption of his death, and thereby escape the law, provide for his wife, and release his bondsman, all at the same time. Accordingly, after effecting the insurance, he induced his brothers-in-law to go with him down the river in a skiff after persimmons and nuts. They spent most of the afternoon in the woods, and shortly before sunset started for home. Having selected beforehand the place in the river, he, under pretext of changing seats with one of the Bryants, purposely fell out of the skiff and swam underwater to a drift pile about 100 yards from where he went overboard. He lay concealed amongst the brush and logs with his body in the water, till after the search by his brothers-in-law had ended. Then, leaving his hiding place, he made for the shore and went to St. Louis and thence to Fort Pillow, Tennessee. He swore that his wife and her brothers knew nothing of the scheme, and that he took the two Bryants along in the boat in order that they might be good witnesses of his death at the time of the pretended drowning. On cross-examination, he admitted that on arriving in St. Louis, he met the father of the two Bryants and of his wife. He asserted that he did not tell his father-in-law about the circumstances under which he left home, and that he did not request him to refrain from mentioning, by letter or otherwise, the fact of his being very much alive. This father-in-law Bryant accompanied him to Fort Pillow and worked with him there or in the immediate vicinity until the following May, when he, Bryant, returned to Quincy. Mrs. Piper, the ex-widow, testified that her father came to Quincy in May 1881 and remained until sometime in August following, and that he had never given her any information that her husband was living. Of course, she never had the slightest doubt of her husband's death until she saw him in jail. How much truth or falsehood went to make up the story which Piper told was of little consequence to the insurance company. Its interest in him ceased when it had restored him to the bosom of his afflicted family. The capture of Fraker. In the summer of 1893, Dr. George W. Fraker was physician to the St. Elmo Hotel, the leading hotel in Excelsior Springs, Missouri, a health resort near Kansas City. Together with several companions, the doctor went fishing in the Missouri River one day in July, and after dark, while in the company of George Harry, James Triplett, and Jake Crowley, a Negro, he disappeared and was seen no more. These three persons swore positively that they heard a splash and immediately afterward saw Fraker waist-deep in the water, he having fallen down a bank into the river. At the place of the alleged accident, there is a violent current or eddy in the river, where logs or stumps being drawn in would be swirled around as in a maelstrom, and it seemed impossible that a man falling in there could escape with his life. The next Sunday, after the reported drowning, a memorial service was held at the springs, a great crowd being present. The funeral oration extolled the virtues of the doctor. The music was charming, and the flowers were in profusion. Some who were present regarded the funeral as a mockery, but it was generally believed that the turbid waters of the Missouri had closed over the doctor's lifeless body. 3 or 4 months previous to this occurrence, Dr. Fraker began to load up with life insurance, taking $10,000 in the Kansas Mutual Life of Topeka, $15,000 in the Hartford Life and Annuity, $15,000 in the Provident Savings of New York, $10,000 in the Equitable Life of New York, and $8,000 in benevolent societies, a total of $58,000. Immediately after his disappearance, the insurance companies held a conference and discovered that while the doctor's income was only about $1,800 a year, his premiums amounted to more than $1,000 annually. Besides this, George Harry and James Triplett, who swore to having witnessed Fraker's death, were men of bad character, Harry having been arrested in eastern Missouri on a charge of burglary in New Mexico. Before going on his fishing excursion, Fraker had drawn all his money from the bank, saying he was about to start for California to bring home the orphan children of his deceased uncle. $40,000 of the insurance money was payable to his brother-in-law in trust for the children. Dr. Fraker, who had practiced medicine for 8 years, was a great fraternity man and was an active leader in Sunday school work, but held rather peculiar views on religious subjects. After a thorough investigation, all the companies, except the Equitable, refused to pay the claims, whereupon James E. Lincoln, the executor of the will, brought suit in the district court at Liberty, Missouri, which was afterward transferred to the United States Circuit Court at Kansas City. Robert T. Herrick, an attorney of Topeka, was appointed to conduct the case for the companies jointly and was assisted by eminent legal talent. In December 1894, after a sensational trial lasting 2 weeks, the case went to the jury after the court had given it instructions, which inclined very favorably in the direction of the plaintiff, as will appear by the following quotation. As men do not ordinarily engage in such a conspiracy or undertaking without some underlying motive or incentive, the question naturally enough suggests itself to an honest mind, where is to be found in this evidence any satisfactory motive or inducement for these men to come into court and commit perjury to enable Dr. Fraker to accomplish such a stupendous fraud. It may be that the mind can conceive, and there may be in actual history, incidents of men of so depraved motives, or so bound by the mastery of attachment to a friend, that without money or hope of reward, they would sacrifice truth and their oaths to advance the wicked course of another. The jury was out only 20 minutes and returned a verdict against the insurance companies. An application was made for a new trial, but in February, the insurance companies agreed with the Fraker heirs that unless the body of Fraker was found within 6 months, the money would be paid. The 6 months expired August 12th, and in the meantime, the companies ran down several false clues and, failing to find the doctor, paid over to the executor the several judgments, and at the same time withdrew their offer of $20,000 for the arrest of Fraker. Herrick, who deserves to rank with the best detectives of modern times, obtained a clue in the latter part of 1894, which he patiently followed until sometime in August, when he learned the hiding place and assumed name of the doctor. On the 29th, he arrived in Tower, Minnesota, together with John Wilkinson, Chief of Police of Topeka, to assist in taking Fraker back. Herrick and Wilkinson learned that Dr. Fraker went by the name of Schnell and lived with a young man in a woodman's hut 50 miles from Tower on the Itasca County Road. A warrant was secured in Tower, and on Sunday morning, September 1st, accompanied by Deputy Sheriff Phillip and a guide, they started for the place. Before they had gone far, the guide told them that Schnell had recently moved to a shanty only 13 miles from Tower. Their course was then changed, and about 12 miles from Tower, Philip, who was acquainted with Fraker under his alias as Schnell, saw Fraker's companion in a shanty near the wood, and on inquiring where the doctor was, learned that he had just moved to this place and was out hunting. The young man was placed under guard, and about 2 miles further on, Dr. Fraker, with a gun on his shoulder, was found. Herrick engaged him in conversation, when suddenly Philip seized his arms and Wilkinson put on the handcuffs. Fraker thought he had been arrested for killing game out of season, as Philip was also game warden. When the warrant was read to him, he was thunderstruck, but admitted his identity at once. He was brought to Tower together with his companion. Fraker readily agreed to accompany the officers to Missouri without waiting for extradition papers. He stated that he had expected his relatives to get a portion of the insurance money, and himself some also. He had been greatly benefited, he said, by the waters of a spring where he was staying. Fraker's hiding place was only a day's travel from the Canadian boundary. He had been there about 6 months, coming into town occasionally for mail and provisions. His supply of money was quite low, and he evidently expected some shortly. He said that at the time of the drowning Fake, he went directly to Kansas City, shaved off his beard, and after 3 or 4 days went to Chicago, thence to Milwaukee, where he assumed the name of William Schnell, and where he stayed most of the fall of 1893. He then went from one place to another until he finally reached the wilds of northern Minnesota, where he was living, with only a boy for his companion at the time of his capture. He expressed a relief in being captured, saying, "I have wanted 1,000 times to come back, but the disgrace and what people were saying about me kept me from doing so. This living death is horrible, and I am glad now I am going back." As his executor had not yet distributed the money, Mr. Herrick telegraphed to Kansas City to have suit instituted against him at once to recover it. A reversal of the decree of the United States Circuit Court followed on the 6th of November. By agreement of all concerned, a decree was entered by Judge Phillips, whereby the insurance companies, which paid nearly $50,000 to the heirs of Dr. George W. Fraker, were to recover all the money except about $4,000, which had been spent by the executor of the will in administering on the estate of Dr. Fraker and in prosecuting suits against the insurance companies. The parties to the agreement were the attorneys for the insurance companies and Judge James E. Lincoln, executor of the will of Dr. Fraker. The total amount recovered by all the companies was $36,557.04, but this was not all in cash, and it is uncertain yet what it will net the companies. The Equitable made a compromise settlement before trial for $8,500. The new decree provided that the judgment rendered by the court February 12, 1895, ordering the insurance companies to pay the money to Lincoln as the executor of the will of Dr. Fraker, be set aside, vacated, and annulled, and the plaintiffs and respondents, meaning the executor and the beneficiaries of the will of Dr. Fraker, be perpetually enjoined and restrained from further proceedings in the cases against the insurance companies. Of course, the agreement between the companies and the executor and the decree of the court could have no effect on the prosecution of Fraker for attempting to defraud the insurance companies by pretending to be dead so that his heirs would get the money. End of section 18.